Commissioner Floyd B. McKissick Jr. with the North Carolina Utilities Commission, and I am the presiding commissioner for this hearing. With me this morning are Chair William M. Brawley Jr., Commissioners Karen M. Kammerite, Tommy Tucker, and Donald Vanderhart. I now call for hearing docket number E2 sub 1354 in the matter of the application by Duke Energy Progress, Inc. for approval of joint agency asset cost recovery rider pursuant to North Carolina General Statute 62-133.14 and Commission Rule R870. On June 10th, 2025, DEP filed its annual application for approval of joint agency asset cost recovery, including pre-filed testimony and exhibits of Brian L. Sykes. The Carolina Utility Customers Association, Inc. and SIG and CUCA have petitioned to and been allowed to intervene in this proceeding. On July 15th, 2025, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring public notice. On July 16th, 2025, the Commission issued an errata order scheduling hearings, establishing procedural and filing requirements, and requiring public notice. On July 18th, 2025, Duke Energy Progress and the public staff filed a joint proposed public notice of hearing for joint agency asset rider. On July 21st, 2025, the Commission issued an order approving the public notice. On August 19, 2025, Duke Energy Progress filed supplemental testimony and revised exhibits for witness Brian L. Sykes. On September 2nd, 2025, the public staff and the interveners SIG and CUCA and CUCA filed their direct testimony and exhibits. On September 5th, 2025, the public staff filed a motion for leave to file pre-hearing briefs and request for an oral argument. On September 10th, 2025, Duke Energy Progress filed their response to public staff's motion for leave to file pre-hearing briefs and request for oral argument. On September 11th, 2025, the Commission issued an order granting the motion for leave to file pre-hearing briefs and scheduling oral argument. On September 12th, 2025, Duke Energy Progress filed a motion for extension of time to file the pre-hearing brief. On September 16th, 2025, Duke Energy Progress filed rebuttal testimony of witnesses Sykes and Leslie G. Quick, an accompanying exhibit. The same day, the Commission issued an order granting the motion for extension of time to pre-file pre-hearing briefs. On September 19th, 2025, Duke Energy Progress, the public staff, and SIG and CUCA filed their pre-hearing briefs. On September 22nd, 2025, the Commission issued an order clarifying and providing procedures for oral arguments, which we will follow today. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute 62-15D. In compliance with the requirements of Chapter 138A of the State Government Ethics Act, I remind members of the Commission of our responsibility to avoid conflicts of interest, and I inquire whether any member has a conflict of interest with respect to the matter before us this morning. Let the record reflect that I have no such conflict and that my fellow commissioners have not identified any such conflicts. That brings us to today. I now call upon counsels for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good morning, Commissioners. Robert Kaler, here on behalf of Duke Energy Progress.
Good morning, Presiding Commissioner McKissick, members of the Commission, LaDon Toon, also appearing on behalf of the applicant.
Morning, Presiding Commissioner McKissick, members of the Commission, Brett Breitschwartz with the law firm McGuire Woods on behalf of the applicant, Duke Energy Progress.
Good morning, Commissioner McKissick. Peter Ledford of the law firm Morton Smith, appearing on behalf of the Carolina Industrial Group Repair Utility Rates 2 and the Carolina Utility Customer Association.
Good morning, Presiding Commissioner McKissick and members of the commission. My name is Mariana McMurray, and I'm with Ward and Smith, appearing today on behalf of SIG and CUCA and CUCA.
Very good.
Commissioner, from Jennifer Harris, representing the using consumer public.
Will Freeman, also with the public staff. Thank you.
Very good. Of course, we have a scheduling order that's in place about the sequence of what we will do in terms of our proceedings this morning. And of course, that involves the oral arguments first. But before I proceed to that, let me ask if there are any other preliminary matters that need to be addressed at this time.
None from the applicant.
Okay. Very good. So what we're going to do is this: pursuant to the order clarifying providing procedures for oral arguments, SIGFR CUCA will first present their prepared remarks, then the public staff, and lastly, Duke Energy Progress. Each party is directed to limit their remarks to 25 minutes, and each party will be notified when there's 5 minutes left to the allotted time. Commissioners will ask questions of each party immediately following each presentation, and the commission's questions will not count toward each party's allotted 25 minutes. So with that, we'll go ahead and begin with SIGFR CUCA.
Good morning, Presiding Commissioner McKissick. May it please the court. My name is Peter Ledford, and I'm appearing on behalf of SIGFR 2 and CUCA. General Statute 62-133.14a sets out, quote, "The commission shall, upon the petition of an electric public utility, and after hearing, approve an annual rider to the electric public utilities rates to recover the North Carolina retail portion of all reasonable and prudent costs incurred to acquire, operate, and maintain the proportional interest in electric generating facilities purchased from a joint agency established under Chapter 159B of the General Statutes." In its pre-hearing brief, Duke states that at the most basic level, the question pending before the commission in this proceeding is whether all means all. Duke conveniently ignores one very important word contained in the statute. I would put to you that the actual question before the commission in today's oral arguments is whether the word annual controls, as SIGFR and CUCA assert, or the word all controls, as Duke asserts. For multiple reasons that I will set forth, the word annual should control. If the word annual controls, then the $16 million in contested costs that Duke seeks to recover from medium general service and large general service customers is actually ineligible for recovery. The Court of Appeals has held that the commission cannot delete words used or insert words not used in a statute. Duke would have the commission delete the word annual from the statute. In contrast, my clients argue that the words all and annual must be read in concert. Duke may recover all reasonable and prudent costs in an annual rider. The word annual qualifies the word all and serves to put a time constraint on all costs, in addition to the reasonable and prudent standard, which will be discussed later today at the evidentiary hearing. Duke similarly tries to ignore words in Commission Rule R8-30. Rule R8-30B1, Roman numeral 6, sets out that, quote, "The electric public utility will maintain an over or under recovery balance and add to the balance the difference between the reasonable and prudent financing and non-fuel operating costs incurred by the electric public utility during the test period and the revenues to recover those costs during the test period that were actually realized." This language clearly allows Duke to recover reasonable and prudent financing costs incurred by DEP during the test year. It clearly allows Duke to recover reasonable and prudent non-fuel operating costs incurred by DEP during the test year. But the contested costs are neither of these because they were incurred prior to the test period. Much as Duke seeks to delete the word annual from the statute, Duke also seeks to delete the phrase incurred during the test period from the rule. The absurdity of Duke's position is plain to see. According to the accounting entries filed publicly in the CPCN transfer proceeding, Duke spent well over $1 billion purchasing the assets subject to the JAAR rider. However, according to Duke's interpretation of the statute, they could have requested to recover $1 single in every JAAR rider proceeding to date and still be eligible to recover the remaining amount during the instant proceeding. This sort of absurdity is precisely the reason why the Commission has routinely held that retroactive rate making is prohibited. Take the Northbrook Hydro case, for example. From 2015 to 2017, Duke Energy Carolinas invested in several of their small hydropower facilities in Western North Carolina. These investments were included in base rates in their 2017 rate case. In 2018, Duke Energy Carolinas proposed to sell these small hydro facilities at a loss. In that proceeding, the public staff asked the Commission to re-examine the prudency of the 2015 to 2017 investments in DEC's next rate case. DEC argued that this would be prohibited retroactive rate making, and the Commission agreed. The case at hand is no different. The statute does provide for a limited exception on the prohibition on retroactive rate making, allowing the Commission to authorize recovery of, quote, any under recovery or over recovery resulting from the operation of the rider. Duke will argue that this language gives them free range to recover any and all costs from any period of time, but Duke conveniently ignores two things. First, this is an annual rider. Therefore, its operation occurs on an annual basis. As such, this provision, too, is limited to any under recovery or over recovery during the test year. Second, this is in subsection C of the statute, governing what the utility must file in its applications. Subsection B of the statute, which governs how the Commission determines the amount of the rider, includes no such look-back provision. In any event, given the general prohibition on retroactive rate making, the Commission should narrowly interpret any statutory exception to the rule. Duke cites to State XRL Utilities Commission v. CF Industries to argue that the prohibition on retroactive rate making applies only to rates set in the general rate case, not in a rider proceeding. Duke's reliance on this case law is misplaced. While in that case, the North Carolina Supreme Court held that an annual true-up did not constitute retroactive rate making, Duke's assertion that this case law allows it to recover costs from 2021 to 2024 fails for two reasons. First, Duke yet again ignores the word annual in the controlling authority. Second, Duke ignores an important factual distinction between CF Industries and the instant matter. The rates appealed in CF Industries were formula rates, where the inputs were not known at the time the provisional rates were set. In fact, the Court of Appeals expressly cited CF Industries in its decision striking down an experience modification factor in State XRL Utilities Commission v. Thornburg, explaining that CF Industries in another case, quote, provisional non-fixed rates, which were adjusted at later hearings. Thus, the use of true-ups is still allowed to the provisional rate cases in which they had previously been allowed. Finally, Duke's request violates the filed rate doctrine, a similar but distinct principle from retroactive rate making. As the North Carolina Business Court explained in a case involving Duke Energy Progress's predecessor, quote, North Carolina has adopted the filed rate doctrine, which provides that a plaintiff may not challenge a commission-approved filed rate, including attendant contractual provisions, unless the challenge is made while the proposed rate is before the Utilities Commission for approval. Once a rate contract is approved by the Commission as being reasonable, a plaintiff may not later collaterally attack the rate contract in a court of law, even if the rate itself is the product of unlawful conduct. Novo Nordisk Pharmaceutical Industry, Inc., the Carolina Power and Light Company. The business court goes on to explain that, quote, the filed rate doctrine bars any later claim that would result in the recalculation of approved rates. In the case before the Commission today, Duke is arguing that the rates the Commission previously set were unfair. However, the filed rate doctrines say that Duke cannot later attack this rate. The fact that Duke is attempting to call the attack on the previous rate a true-up is a distinction without a difference. We are here today because Duke asserts that the rates that the Commission previously approved were unfair, and that argument is barred by the filed rate doctrine. As I said in the beginning, the issue before the Commission is whether the word annual in NC General Statute 62-133.14 has any meaning. Duke argues that it does not. While the Court of Appeals has held that the Commission cannot delete words used or insert words not used in the statute, even if the Commission agrees with Duke, Duke is prohibited from recovering the contested costs by both the prohibition on retroactive rate making, because the contested costs fall outside the test year, and the filed rate doctrine, because Duke is attacking the previously approved rates as unfair. In closing, I want to leave you with some more language from the Court of Appeals. Quote, "We consider it more probable that if the General Assembly had intended to follow the example of other states in permitting a true-up, it would have done so with more specific language exemplified in those statutes. Indeed, the fact that North Carolina statute lacks direct references to over-recoveries and under-recoveries could well be some indication that the General Assembly was aware of practices for true-ups elsewhere and simply rejected the implementation of such practices here. Moreover, the General Assembly must be presumed to have been aware of the judicial prohibition against retroactive rate making, as it is doubtful that the General Assembly would have intentionally modified or overruled established judicial decisions without language that made its intent manifest and unambiguous." State XRL Utilities Commission v. Thornburg. The General Assembly could have made its intent to allow Duke to recover costs incurred several years ago in the rider manifest and unambiguous, but the General Assembly did not do so. Instead, we have a situation before us where Duke seeks to ask you to ignore the word annual in order to reach the conclusion that the recovery of many years of expenses is permitted. I would argue that the General Assembly's intent is manifest and unambiguous. Duke is permitted to recover costs from the test year in its annual rider, but not costs from before the test year. Thank you.
Thank you. Let me see if there are any questions. Commissioner Comrade?
Just a couple of questions. Thank you for your oral argument. Your argument focuses or centers around the words annual and all in the statute. Is there anything in the statute or rule R-870 that expressly prohibits true up of costs outside the test period in the annual proceeding? Is there any specific language that that the commission should be considering?
The only specific language in the statute is the word annual that provides a temporal restriction.
And in regard to the word annual that is provided in the statute, what about the word annual would prohibit a true up outside of the test period? Because, you know, we have annual proceedings, but there's nothing that expressly prohibits a true up outside the test period. So why is it inconsistent to, you know, Duke's argument is that it's entitled to collect all reasonably incurred and prudent costs. And what prohibits those costs from being considered in each annual proceeding?
For that, it's the judicial history and case law on retroactive rate making.
And then I guess my last question is how do you distinguish the commission's orders in the 2024 Duke fuel riders when the commission basically took the position that it was not retroactive rate making and they allowed a true up of a true up outside the test period? So how do you reconcile the commission's order that was not retroactive rate making in this particular proceeding? What is the difference?
So I'm not going to take a position on the commission's previous order in the fuel dockets, but I will point to the series of case law, both before the commission and at the Court of Appeals and the state Supreme Court, that prohibit retroactive rate making.
Okay. And then I guess my last question about that, is there any significant legal difference between the costs that Duke was truing up in the 2024 fuel rider proceedings and this accounting error in this proceeding? Is there any legal difference between the costs that Duke was attempting to collect?
I believe that is something that the Court of Appeals is going to be deciding shortly.
Okay, thank you.
Heard Chair Brawley.
Thank you, Commissioner. I think I heard you say that the statute said recover all costs in an annual rider. Is that the language that you quoted?
Yes. That was a paraphrasing of the statute, but yes.
Oh, that was paraphrased on your part. Because the reason is when I would read that, all costs in an annual rider, the rider is annual. but the costs are not. The costs are just are. And so I'm having trouble wrapping my arms around the annual moves back in the sentence to be the cost, to recover costs in, it seems to me all applies to cost, annual applies to rider.
I understand, and that is very similar to the argument that the company is making. However, there's a general prohibition on retroactive rate making, meaning that the commission cannot look back to previously what the utility has recovered. It can only look forward. The statute provides limited exceptions to that. And it's our argument that the word annual applies to that limited exception, meaning the look back period can only be annual 1 year.
Okay, I understand what you're saying.
Are there any other questions? I have one quick question, and that's kind of following up on Commissioner Kammerite identified. Is the fact that this is a computational error that we are looking at distinguish it from, say, other costs that might have been contemplated statutorily when the statute was written, and likewise when the commission rules were written?
Well, I think that's where the filed rate doctrine applies. These are rates that the commission has considered and approved and put on file. And in essence, what we have here is it's typically a ratepayer who's challenging the rates as unfair. But in this case, we've got the utility challenging those rates as unfair. And the fact that it is a rider proceeding is a distinction without a difference. They are still arguing that the previous rider amounts were set unfairly. And that's an argument that's prohibited from under the filed rate doctrine.
Okay. I'm not seeing any further questions. Let me thank you for your conciseness,
Thank you.
and we'll now hear from public staff.
Presiding Commissioner McKissick, Chairman Brawley, Commissioners, thank you for hearing oral argument in this matter, and I look forward to the opportunity to explicate our position and hear your questions as well. So there is only one dispute among the parties to this rider, and that is whether the commission should allow Duke to recover $16 million for its own revenue reporting error that affected 3 prior JAAR proceedings. Many of the key facts are not contested. For one thing, Duke acknowledges that it's completely responsible for this error. Sun contested that Duke at all times had the information that it needed to report correct JAAR revenues to this commission, but it did not do so. It is also, as Duke's witnesses have laid out in their direct and even in more detail in their rebuttal testimony, that Duke's internal systems were so flawed that this mistake, they believe, began in 2021. They had an opportunity. They learned that there were some revenue reporting issues in 2023. They looked, they thought they corrected it. They still missed it. And we come to 2025, and for apparently unrelated reasons, they decide to do a comprehensive review of financially significant reports that came out of Customer Connect. And they found a slew of mistakes. The one in JAAR is not the only one. There were mistakes in CPRE and DSMEE. There were reporting errors that affected many riders. So this is not just a one-off mistake that was corrected during the test period. This is an entrenched error on Duke's part that they have struggled for now years to correct. And they say they've corrected it now, but even as late as, I think it was August 18th, they filed supplemental testimony in the CPRE docket, further supplementing their testimony, further revealing errors. One simple thing would have corrected all this. if Duke had tied out those JAAR, those internal customer connect reports, if they tied those out to their financial statements, they would have seen that there was a mismatch in the revenues reported through Customer Connect and the financial statements, but they did not do that. They did not do that. And now they do have a procedure in place, a Sarbanes-Oxley compliant procedure that does tie those out. But all along the way, at least from 2021, we don't know about before then, but at least from 2021 until 2025, they were not tying that report out. And so that error is entirely in their lap, which they acknowledge. Now, Duke's witnesses today are going to tell you that they gave testimony in 3 separate rider procedures before this commission. Mr. Ledford spoke in a very erudite manner about the filed rate doctrine. Here's why it matters. 3 separate times, Duke came out of the box and filed testimony under oath about what its JAAR revenues were. And they are going to come here today and tell you we were wrong, we were wrong, we were wrong. Which, you know, I don't want to seem like I'm kicking them when they're down. If that was all there was to it and they weren't trying to recover the $16 million, we would say thank you very much. So they're here. It's not just a matter of truing something up. It's a matter of reopening closed proceedings where, again, Duke would tell you, we build our customers according to the tariffs that this commission approved, that we asked this commission to approve. I believe they're going to show cross-examination exhibits during the evidentiary hearing that shows that the public staff did not contest any of Duke's reasonable and prudent charges in connection with JAAR. And in fact, we're not contesting them today. They're wanting to cast this as somehow disallowing prudently incurred costs, but that's not the case. We're just saying you goofed on what your revenues were and you don't get to recover for your goof on your revenues. This is not about not allowing them to recover their prudent costs. Now, I want to make one thing clear. It may sound like I'm hammering on the equities because I don't have any law. I'm not here telling you, the details about Duke's errors because I don't have a legal argument. I'm not appealing to your emotion or to your sense of outrage or anything else. What I am saying is that the law of North Carolina, which is another thing we in Duke agree on, the statutory construction principles that are in their briefs are very common sense principles. I know I'm speaking to 3 former legislators and you know infinitely more about this than I do. These are common sense principles. You don't need to, you don't need to be a Harvard law professor to understand statutory construction. We start with the plain language of the statute. We read the statute, we read all of the provisions of the statute in total, okay? So the plain language and the intent of the legislature needs to drive this decision. So what does the plain language of the statute do? Yes, it gives Duke the ability to recover all of their JAAR costs, all of their reasonable and prudent JAAR costs, pursuant to the procedures that are laid out in the statute. Duke would have you, I don't know if you all have the statute in front of you, if it was our proposed cross exhibit 1. Duke would have you basically, and that statute is like, half a page of dense text. Duke wants to stop reading after the first sentence. They want to say, we can recover all of our reasonable and prudent costs. Don't listen to anything anybody else has to say. Give us all. But the legislature didn't do that. The legislature went into some detail and laid out a procedure. And I'll just touch on it briefly now and circle back around to it. But what the plain language of the statute allows is for Duke to adjust rates each year, but only for a limited number of things, and that's in subsection C. The commission shall require that an electric public utility file the following proposed annual adjustments to the rider. It's a list of 4 things. Only one of them is at issue here. I'll go in reverse order. Subparagraph 4, changes to the customer allocation, should we have had a rate case. Subparagraph 3, changes to the cost of capital, again, should we have had a rate case. Subparagraph 2, any changes necessary to recover costs as forecast over the next 12-month period. And then we get to the one that's at issue here. Any under recovery or over recovery arising from the operation of the rider. Does it say arising from Duke's mistakes in its internal reporting that caused it to not accurately report to the commission what the revenues were? It does not say that. And the statutory language cannot stretch that wide. So Duke's theme in their brief, all means all, is very catchy. It's easy to, it's easy to talk about. It's easy to understand, but it does not stand up to review of the actual statute. Duke would turn chapter 62, section 133.14 into an insurance scheme for Duke. It doesn't, but it's not intended by that legislature to be an insurance scheme. Duke is not absolved from its responsibility for following the statute, for making timely and accurate requests for the recovery allowed by the statute. Were they to do that, they would in fact recover all. This, to Commissioner Kimmerheit's question, this is very different from the fuel statute. So the statute provides a mechanism that allows Duke to recover all of its costs, assuming it makes timely and accurate reports to the commission. Duke's, just to go through the statutory construction principles, you follow the plain language of the statute. Okay, so what does paragraph C sub 1 say? That they're allowed to adjust for under recovery or over recovery resulting from the operation of the rider. We need to take that phrase under the whole text canon. We need to take that phrase and understand how it works with the recovery of all reasonable and prudent costs. You have to construe the statute as a whole. You have to read the statute in light of the legislative intent. Again, I'm a little hesitant to tell legislators how to do that, but I will note, if you look at subparagraph B, which lays out what categories of costs Duke can recover. The biggest part of the JAAR, the biggest component of the JAAR rates are the purchase costs, the actual acquisition costs for buying those assets. And so those are to be levelized over the course of the rider. For the benefit of the consumer, the acquisition cost shall be levelized over the useful life of the assets at the time of the acquisition. So the intent of the legislature was not for the JAAR rider to create rate shock for ratepayers, not for it to be up and down. And if you see, when we get to the expert witness portion of the hearing, you can see that the JAAR rates for the large industrial customers who the burden of this is going to fall on, the JAAR rates went through the roof as a result of this. So that does not seem consistent with the intent of the legislature. And I'm not going to repeat Mr. Ledford's discussion about the importance of it being an annual rider, but that is the point. It's not for the company to sandbag and come forward with new evidence years after the fact. It's for those costs to be distributed annually among ratepayers for their benefit. I handed out and provided these to all the parties on Friday, but handed out to you all a couple of additional cases that we would cite to the commission. And again, this is common sense, but the specific language controls the general. So the general language is Duke can recover all of its reasonable and prudent costs associated with the acquisition of these joint assets. Okay, great. What does that mean? Then you go to the specific and you see what are the procedures. What does it mean? The other one is that we presume that the General Assembly did not intend an absurd result. Here, what Duke is asking for does strike me as an absurd result. What it would do is it would allow Duke to reopen no JAAR rider order and potentially no rider order at all. I haven't looked at all the other statutes to see if they all say the word all, but potentially no rider would ever be closed. The idea that previously settled rider proceedings could be reopened, again, I agree with Mr. Ledford, is so unusual that if that's what the General Assembly intended, you would expect them to have said so in so many words. Duke is suggesting, and this is a separate point, Duke is suggesting that the General Assembly intended for them to have no accountability, nothing at risk for this repeated and systemic errors. Think about this, or think about what a rider is as compared to standard cost of service rate making. Duke is a monopoly. They've been granted a monopoly by the state. Typically, most rate making traditionally was cost of service, which is you take the test year, you make that a budget, you say, guys, if you can fit your expenses within this budget, maybe even save a little bit, you get to keep the extra. And that aligns the utilities' incentives with the ratepayers, the incentive to keep costs low. If they can come in under budget, they get to keep the extra. Now, utilities love riders, as I'm sure you know, because it allows them to recover their costs right away without the regulatory lag. So they love them some riders. This rider is especially juicy because Duke still gets to earn its rate of return on this acquisition. So this is a really nice rider for Duke where they get to get all of their costs. There's nothing at risk to them. They're not at risk for this cost. They get their rate of return. They get their full authorized rate of return on the acquisition cost, and they get it annually. There's limited regulatory lag compared to regular rate making. So they want you to accept that on top of all that, on top of that benefit of having all this flow through a rider in that way, that they also are not at risk for their own internal reporting errors, that they can, I don't know, go in a warehouse and discover a new box of invoices from 2016 and say, guess what? We get to recover this. That they have literally nothing at risk. And I find that very difficult. I think that would be a very difficult proposition for anybody to go home and explain over Thanksgiving, or explain to a rate maker, or explain to a voter, sorry, a rate payer, or explain to a voter why that's what the General Assembly wanted. That strikes me as a very difficult thing to swallow. So turning back for a minute to the language of the statute, which again does not say. I think it's very difficult to say that Duke losing track of $16 million of revenues is, quote, an under or over recovery resulting from the operation of the rider. I think that really violates the plain language of the statute. So in their brief, Duke doesn't attempt to explain the phrase resulting from the operation of the rider. I'm going to quote you this. Duke says it means the series of actions necessary to effectuate the legislative intent for the utility to recover all of its reasonable and prudent JAAR costs through the rider. That's quite a mouthful, 25 words, 26 words. But what it amounts to is an attempt to take that phrase, just to write that phrase totally out of the statute. Violates the whole text principle of construction. So let me turn briefly to Rule R-870, and then I'll listen to your questions with great interest. As we said in our brief, Duke and the public staff jointly proposed Rule R-870 when the statute was passed, and the commission promulgated it as proposed by the parties. It provides for a rolling recovery factor. And what that means is that, and we'll see this when we get to the evidentiary portion, but you can see it in Mr. Sykes's exhibits to his testimony. What that means is the ending balance for one period then becomes the beginning balance for the next period. And so that gets us away from the issue that we remember from the 2024 fuel proceeding. In that issue, and I'm going to put a big asterisk here, Mr. Ledford was very cautious, and I will be too. As you know, of course, those orders are on appeal, and also the statute has changed. So the public staff is not here to, reopen that debate, or, we understand that the commission has made its order and it's now in the hands of the Court of Appeals. So I'm not here to argue with the commission's order at all. And I'm also not here to waive our arguments on appeal either. But I think Commissioner Kimwright, understandably, asked, how does this differ from fuel? And so the answer is, and remember, of course, fuel is like the grandfather of all riders, right? That's the classic rider. It predates JAAR by quite a bit. So in the fuel rider, at the end of the year, the EMF factor goes to 0. So you take that money and you then recover it over the next year, or you try to. But if your forecast for your sales are wrong, then you're either going to over or you're going to under recover it. And so if you don't allow what in that case was called a true-up, you have a shortfall or an overage resulting from the operation of the rider. Well, the JAAR statute comes in and says, well, let's not do that anymore. Let's do this. Let's do JAAR differently than how fuel is set up. And so the parties got together and proposed this rolling recovery factor. Well, what does it say? It says Duke is required to maintain It says that the electric public utility will maintain an under or over recovery balance. Now, Duke wants to interpret that statute to that language to say, well, we can do anything we want and call it maintenance. But, you know, like when my daddy taught me how to maintain my car and rotate the tires and put oil in it every 6 months, he didn't say, wait till the check engine light comes on and then, you know, fix the problem and that counts as maintaining your car. That's not what maintain means. Maintain means on a regular basis, maintain that balance. And you'll see that again, period to period, month to month, year to year. The ending balance for one period becomes the beginning balance of the other period. And that's what prevents any over or under recovery on account of the rider. I would just like to briefly, you know, there's some rhetoric in Duke's brief. They say that the public staff is arguing for a management penalty. No, it's never going to be a penalty for the commission to apply the law as written. They say that disallowing the $16 million would be inappropriate and unprecedented. As far as I am aware, Duke's request is unprecedented. So I suppose that in a literal sense, anything this commission does will be unprecedented. But, you know, it's this commission's duty and you have the power and the responsibility to manage the utilities, the public utilities of the state. So it certainly is not, it may be unprecedented to not allow Duke to recover. And again, this is not about cost recovery. They were given their full cost recovery. What they're asking for is to recover from their reporting error. So it certainly is not inappropriate for this commission to not allow Duke to recover from a years old reporting error. And I'll be happy to hear any questions you have.
Okay, thank you. We're able to do that in 20 minutes. So we'll look to see if there are questions. Commissioner Cameron, go right ahead.
Thank you as well, along with Mr. Ledford for your oral argument and your providing the positions in a very clear way to the commission. We appreciate that. I do have a couple of questions, and then I'm going to also have questions for Duke as well. But in your oral argument and also in your brief, you focused quite a bit on the phrase in the statute 62-133.14 about any over recovery or under recovery resulting from operation of the rider. What is the definition of operation of the rider? Where can we determine what that actually means?
Well, I gave away the secret to the answer there. I think it's what I just said. I think that there had been some experience with the fuel rider where, because it zeroed out every year by the operation of the rider, every year there was going to be at least some over or under recovery. I think that's what it points to. I think you know, the world is big and my imagination is human. There may be some other thing that it means, but I think what it definitely does not mean is Duke's repeated failures to maintain appropriate business records, which led it to repeatedly under oath providing incorrect information to this commission.
And I think Duke's argument in response to that would be that operation of the rider, that there's nothing in 62-133.14 or Rule R-870 that expressly prohibits consideration of costs that were incurred outside the test period. Is there anything that is expressly in the statute or understanding of the word operation of the rider or the rule that would support your argument and would state that Duke is not entitled to consider anything outside of the test period?
Well, and that's not exactly our point, our argument, Commissioner Kemmerite. If the parties had not proposed Rule R-870 and it didn't exist, then I think they could consider that true-up of a true-up that happened outside of the test period. But, you know, the parties did sort of anticipate that issue and crafted the rule to address it. So it's not exactly our position that the statute says don't look at anything outside of the test period. Our position is the statute says it has to be arising out of the operation of the rider. I don't know everything that that possibly could mean, but it has to mean something. It can't just mean if we didn't, I mean, literally, I'm not aware of any limitation on Duke's position. I'm not aware of, is there an error too big that they would say it doesn't fit? Is it an error too small? Is there something too long ago? Is there something that would impact ratepayers so heavily that they wouldn't think that it qualified? As far as I know, there is nothing off the table. So I don't know everything that phrase might mean. I think I do logically, and looking at the history of how the riders developed, I do think it is getting at that true-up of a true-up issue. Perhaps we could have some other example that might fit into that, but I do know that it has to mean something. It can't mean whatever we want, which is how I believe, unfortunately, Duke is interpreting it.
And I heard your argument about the 2024 fuel orders are on appeal by the Court of Appeals, so no need to go into those details about that. But outside of the issues on appeal, are there legal or practical differences between the costs in the fuel rider, which was the forecasting inaccuracies in the fuel rider versus the mistakes, the accounting mistakes that occurred in this proceeding? Are there legal or practical differences between those costs?
Yes, Commissioner Kimmeray, there most certainly are. And the difference is a forecast, nobody presented, to my knowledge, in those fuel rider proceedings, nobody said, Duke, your forecasts were imprudent, your forecasts were inappropriate. As far as I'm aware, certainly as far as the order that the commission entered and the evidence the commission considered, Duke had done an appropriate job forecasting its sales, but it's definitional that no forecast is going to be precise. And Duke was asking to recover from the immediately prior test year. This is both of those things. Oh, and furthermore, it was not a situation where Duke had come in, and I guess there's three distinctions. It was not a situation where Duke had come in and had said under oath, these are our costs, please let us recover them. And the commission had said, sure, go at it, do it. And then they come back later and say, actually, we were wrong. So there's those three distinctions. As compared to the fuel, as opposed to the fuel situation, here Duke made not just one blunder, honestly, but a series of blunders, a series of very avoidable errors that our witnesses, and this is certainly a point of contention between the parties, but our witnesses would say were just imprudent to not tie these records up to their financial statements. So Duke made a series of errors. That wasn't the case in the fuel. They're coming in here asking the commission to essentially reopen closed rider proceedings. That was not the case in fuel. And they are asking to go back multiple years, not just, through the operation of the rider, we need to dip back to the period prior to the test period, but going back 3 years for no reason other than that's how long ago, as far as they're aware, the error extends.
Okay, thank you. And just a couple more questions. I'm anticipating what Duke might argue about some of your arguments, so I'll just go ahead and ask these questions. You talked about that Duke should not be able or legally entitled to reopen closed proceedings, but is there a difference between these costs here? It's undisputed that they were actual and prudently incurred costs versus, a situation where Duke might, the argument of opening a closed proceeding to re-argue about the prudence of costs that had been disallowed. What is the difference when you say that they should not be entitled to reopen closed proceedings where here these are undisputed actual costs?
Well, we would certainly say that they did recover all their reasonable and prudent costs. They brought that evidence forward to the commission. Public staff had an opportunity to audit it, and those were allowed. They were put into rates. They were billed to customers. Duke said the customers were billed according to those rates. And now they want to come in and say, actually, the information that we represented to the commission under oath was, in hindsight, incorrect, and we would like to take that back. So that's really the difference. It's potentially, and we get around to the order, I mean, potentially it's an estoppel situation where the witness is coming in and repudiating prior testimony and asking the commission to find actually a different set of facts. But it does not relate to the prudently incurred costs. Those were fully allowed, and they were fully allowed to recover them. It relates to the reported revenues that offset those costs, and that's where the error lies. Just
Okay. And then my last question is, you talked about how the General Assembly did not intend that any absurd results occur from operation of the statute. How would you respond to an argument that Duke did incur actual costs of $16 million and that disallowing all costs, which would include the $16 million, would be an absurd result, as opposed to your position?
Well, the way I would respond to that is to say that, I mean, it does have kind of a gut check quality to it. If you imagine explaining this to the average ratepayer, or even the not so average large general services ratepayer, I think it just is difficult to explain that, you know, Duke receives and base rates a lot of money. You know, the Customer Connect was an expensive system, and it was supposed to yield a lot of customer benefits. And they receive a lot of money in their base rates to operate those systems, to maintain a trained workforce that understands its tariffs, and to provide adequate service. And this commission is blessed or cursed with the responsibility for managing these utilities. And so what they're asking for is please take all of the risk off of our back. We're already in a very low risk situation here where this is just being treated as a flow through. We get all of our costs, we get our rate of return, we get it every year. It's already a low risk situation. Literally the only risk that they have is the one that they're facing here, where they failed to accurately report to the commission what their revenues were. That literally their failure to maintain adequate systems is the only risk they face. And they're asking to be relieved of even that risk. So I do think that would be an extraordinary result for the General Assembly to have intended. I find that to be a very extraordinary outcome. And as I say, I don't know where, if that argument, I don't know where that ends. I don't know how any rider is ever settled.
Thank you for the answers to my questions.
Thank you, Commissioner Kamai.
Chair Rowley.
Thank you, Commissioner. It seems a large part of the argument is they made a mistake and they should have to own it. Would the reciprocal argument also hold if their error turned out they had over collected $16 million? Would we not expect them to return that to the shareholders? I mean, to the ratepayers?
It's a very good question. And as you might imagine, we've discussed it and thought about it a lot, and it's a hard question. But what you come around to is the fact that Duke and ratepayers are not similarly situated. This is an error that Duke, you know, again, the rebuttal testimony has quite a bit of detail about what Duke did, how we got to this place, how they tried to correct the error, how they tried to avoid the error. And even they were not able to find this error despite the eyes they put on it. So there's no prayer that any of the rest of us can find it, right? You know, that the public staff, the commission, the ratepayers, we're dependent on Duke to maintain adequate records. So I may get the hook for saying this, but legally, I think if we were talking about 2022 and there was an error in the customer's favor, I think we would have to look long and hard about whether we thought that the filed rate doctrine said we can't correct that error. But should Duke correct the error, which is what they've done in the SEPS rider? Is it the appropriate thing for them to do? I mean, Duke is not a nonprofit. They are not a charity. If Duke comes to this commission and says, we discovered this mistake in SEPS and we would like to give this money back to ratepayers, it's because they know that that's in their best interest to do, frankly. I mean, just to be direct, not to hide the ball. And it is appropriate for them to give that money back for the reasons I said, because they're not similarly situated. And ultimately, this commission has a lot of tools at its disposal with respect to to its duty and responsibility and privilege to supervise these utilities. It can impose a management penalty. It can disallow costs if it finds that, that Duke hasn't been maintaining its books and records in an appropriate way. So were Duke not to voluntarily fix its mistake as it did with respect to subs, the commission still does have tools. Would those tools include reopening a prior rate proceeding? We'd have to really look hard at that were it to come to pass. And I don't want to, I don't want to say for sure we would say yes or no, but I take the point. It's a fair question.
Thank you. And that was a very enlightening answer.
Commissioner Tucker, do you have a question?
Thank you, Commissioner McKissick. Ms. Harrod, you focused on the word all, and Mr. Ledford focused on annual. Is there any dispute that the $16 million that Duke is trying to reclaim through its admitted errors over, I think you said a 3-year period, is there any question that they had that expenditure?
Well, again, not to play semantics with you because I am aware that money is fungible, but the error involves them misreporting their revenues, which offset the expenditures. But is there any question about whether in fact that Duke made that error and in fact it's in the amount of 16 million? We have not taken issue with that number. I'll say that. I'm not sure the extent to which we had an opportunity to audit it fully because although Duke discovered this error in February of 2025, they did not reveal it to the public staff or to the commission until they filed their rider proceedings. So we are operating under, riders are supposed to be pretty streamlined, pretty tight turnaround proceedings. So, we haven't done to the studs an audit of it. But no, I think to answer your question, we're not taking issue with that amount of money that they did in fact experience that underreporting. And I appreciate you giving me an opportunity to say something I meant to say. I did not I thought Mr. Ledford did a good job or did a thorough job describing the annual nature of the rider. And so the fact that I was not full-throated about that should not be interpreted that I disagree with his points on that. I think those were very valid points in terms of the whole, the whole text analysis.
As you interpret the statute, is there any time limitation other than the term annual specific to the statute?
Well, that's a good question. And I think, I'll try to give an answer consistent with what I said to Commissioner Kimmerer, which is the statute does not say thou shalt not recover something outside of the test period. The statute says you can't adjust the rates for anything other than those 4 things that are listed in the statute. And pertinent to this, any under recovery or over recovery resulting from the operation of the rider. Now, the rules that this commission has promulgated at the rest of the party kind of fix it so that in effect, you're not going outside of the test period because you do maintain that over or under recovery balance period to period. So money is not getting left behind in prior test periods. And so in effect, that's where you get to, but no, the statute does not say that.
Okay. The only reason I'm bringing this up, public staff in the bond hearing for Helene, the $1.1 million bond hearing, the only comparable amount to this proceeding, which is irrelevant, was $16 million by happen chance that public staff did not allow Duke to collect. And I believe Chair Brawley, cost of capital, something. So the $16 million was not allowed there. And then in this case, we're talking about $16 million again. Let me ask you about a hypothetical then. Hypothetical tax bill. The IRS comes back to Duke and says 3 years ago you didn't report properly on your taxes and you have a $16 million error there. we know that you owe this to us. And it's 4 years old, not annual, not all. And should they be able to recover the $16 million in the error in their taxes to ratepayers because they made errors there as well?
That is,
Hypothetical, I had it happen to me in my business, so I know that, the spread of time, sometimes, you make errors there. Duke's a big corporation and they got lots of people that should have caught this, and I concur with all of that. Just trying to understand, the inflexibility in one scenario and then the inflexibility in this scenario.
well, that is a truly wonderful hypothetical. And I hate to
Thank
tell
you
you.
for that, by the way.
Well, I can tell because I don't want to answer it. No, I hate to sort of punt and say it would depend on the facts, but you did set it up in a way that if it were due to error on the part of the utility, that they blundered and they didn't they didn't file correct information with their taxes, I think would be more in the situation we find ourselves here. If it were a situation where they were relying on tax advice, that was from a reputable source, not a fly-by-night tax shelter, and, they got a bill that was kind of out of time, if you will, I think that would be a different situation. In this case, this may not be much of a balm to Duke, but they made numerous incorrect filings with this commission in their monthly JAAR reports in this test period. And we didn't say, no, you got to eat those mistakes. We said it's appropriate for them to be able to correct the mistakes that occurred in the test period. So you would have to look at the whole facts and circumstances, where it falls on a range of, that may be a partial answer to Commissioner Kimmeright's question. What does by operation of the rider mean? If it means that this is a bill that for reasons that were outside of anybody's control, was I don't do accounting, but was incurred in time period -2, but didn't accrue until time period 0, perhaps that would be an example of another thing that would be arising out of the operation of the rider.
So you're in fact stating there is time limitations that you determine within the statute.
If I said that, I didn't mean to.
You did not say that.
I certainly didn't mean to say that.
You did not
Okay.
say that. Ask me. I asked that question.
You asked
About the
that
time limitations. Yes.
Okay. And do you feel like you got as much of an answer as you're going to?
As much as I can. Thank
I
you.
did try to
Thank
answer.
you, Commissioner McKissick.
Commissioner Vandervaart.
Yeah, thanks very much for your presentation. I guess I'm going to just follow up on your point, which is, where are the parameters under which this could work? I mean, it's not surprising to me that General Assembly didn't provide statutory language for
Easy now.
Duke making, well, they didn't anticipate Duke making mistakes and say, when Duke makes mistakes, this is what you'll do. So there's no statute that addresses that, unfortunately, for this purpose. But I mean, where does that go? I mean, does negligence get to, if they're negligent, do we still pay? If they're criminally negligent, no. But I mean, I'm just trying to understand where, because I wasn't around during the fuel situation, but if somebody's following all the procedures and that people follow to try to predict the future, that's not that, and then they get it wrong. I don't view that as a mistake, but my understanding here is we just messed up, and so I guess I'm trying to understand: is there a test that you would advocate that if it's negligent that they don't get the money back?
That's another good question. I'm gonna talk around in a minute, which you're not supposed to do, and say, when you say the General Assembly didn't anticipate that Duke would make a mistake, I think, and that very well may be true. again, they receive quite a bit of money in rates to maintain adequate business systems and provide adequate service to ratepayers. And so, but I think you've kind of put your finger on it, that the General Assembly set this up assuming Duke would accurately and timely report its revenues and its costs. And if and when and to the extent that they do that, they will recover all of their JAAR expenses. So I'm going to back into an answer to your question, which is essentially yes. I think there is kind of a negligence standard. And maybe that's the answer to Commissioner Kimmeright's question too, is if it's something that's outside of anybody's, reasonable control and it happens, then that's perhaps the kind of thing, I hate to answer with respect to a hypothetical, but that seems to me to be the kind of thing that would be arising out of the operation of the rider. But if it's just, a failure to live up to what this commission, I think has a right to expect, which is, we all file supplemental and amended testimony. It's not like we're operating under huge time pressure. It's not like mistakes don't happen. And as I said, when a mistake happened in the test period, public staff did not say, oh, you shouldn't be allowed to recover for that. But this is a mistake that bled out very much outside of that into prior test period. So I think a negligence standard is one way you could certainly think about it.
And we've had a lot of questions asked and answered. I'm going to follow up on Commissioner Vandervaart's question, because it seems that what I'm hearing is that while the costs that were they were reasonably imprudent expenditures, but we did have a mathematical computational error. We have a general statutes that's very clear in terms of what we need to be looking at. We have Rule R-870, but if in fact we had discovered this 3 years ago, rather than, and of course there was an initial discovery and there were some changes made, and after they were made, they were not, they did not cure the true impact of the revenue that was overstated. But had in fact we had been looking at something that came to us, 2 or 3 years ago, would the public staff's position be the same? And if we were looking at something that was simply negligent in terms of an oversight, a computational error, versus something that has perhaps matured over time in the fact that there were not appropriate remedial actions taken to address the overstatement of the revenues, then now it becomes more than just a simple negligence, almost gross negligence. Can you address that?
I can try. I have my my colleagues who are the subject matter experts in the back of the room, and they're probably, you and I are lawyers and we think in terms of negligence. Their testimony is that it wasn't reasonable for Duke to lack the basic internal control that would have tied those reports that came out of the billing system, that would have tied that back to the financial statements. If they had done that, they would have seen the error. Instead, they were sort of living inside the construct that they made, and they kept saying, well, this seems reasonable when I compare it to this other thing, but they were in that bubble of the incorrect report. And so I'm hesitant to agree with the negligence language, just because that's not the language of my accounting colleagues. That's more of a legal term. But I do think, to try to answer your question about how this unfolded in time, and I hope you find this, if it's not responsive, just try to keep asking me and I'll try to answer you. But this isn't as much a question of, oh gosh, that happened all the way back in 2021 and now we're talking about it in 2025. It really is a question of mistakes that occur within the test period. And this happened in the 2023 rider, where Duke caught a mistake that had, had happened at the time of the migration, but it only affected that 1 year. And we did not oppose correcting that mistake that happened in that test period. Same thing here. Some of this error was in the reports that were filed during the test period. We did not oppose correcting the errors that took place within the test period. It's really that question of, are we making an adjustment for something other than the operation of the rider? This is an annual rider. It's not a monthly rider. So they did file erroneous reports with the commission, but within the construct of the annual rider, those were corrected. Fine, no problem. It's when it falls out, not temporally falls out, but causally falls out of it being connected to the operation of the rider. Does that answer your question?
I believe it did, but you're looking at it purely within, say, the test period itself. Is that correct? I mean, that test period is occurring annually that we're looking at from, say, December 1 of one year to November 30th of this next year. And when we're looking at it, if it's occurring within that test year period and there's an error that's detected, there's no problem correcting it. But if you're getting outside of that period for which the rider was established, it's kind of a bright line, notwithstanding whether it's a error that was perhaps a result of simple negligence or a magnitude that's greater than simple. Is that an accurate characterization of what I believe I heard you say?
It is, Commissioner McKissick, and if I can just be, well, I'm going to be really nerdy here, really pointy headed, and I hope you'll forgive me. It is because of the way Rule R870 works. That within the test period, that language is not in the statute, okay? The statute does not say that. The statute says any under recovery or over recovery resulting from the operation of the rider. But the parties, and I wasn't around, so I don't know whose bright idea it is, but it is a bright idea, set up Rule R870 such that because you're maintaining that over or under recovery balance, because at the end of one period, the ending balance of one period goes to the beginning balance of the next period. Because of that, in effect, it is the test period. But I just wanted to be really clear that that's not because that's what the words of the statute say. That's because that's how the statute and the rule work together. Does that make sense?
Sure.
Okay, thank you.
And I believe that would be consistent with the public staff testimony that I reviewed. That's been pre-filed. Okay, on that note, we're going to take a 5-minute recess and we will resume in exactly 5 minutes. And then Duke will be able to make its oral arguments. Go right ahead. You can announce your, on behalf of Duke, and go ahead and proceed.
Thank you. Good morning again, Presiding Chair McKissick, members of the commission, Chair Brawley. My name again is LaDawn Toon, and I'm appearing on behalf of Duke Energy Progress. Thank you for the opportunity to present our positions and respond to any questions you might have this morning. Before I begin the substantive part of today's presentation, I want to take a moment to acknowledge the administrative oversight that brings us here today. Separate reporting issues in 2023 and 2025, though different in cause, miscalculated revenues collected that ultimately did not align with the actual customer billings. Although we are not held to the standard of perfection, we strive for perfection in all that we do. In this case, we made an error. Please know that behind every decision are dedicated people who care deeply about their work, and our customers trust in us. And we are committed to learning from this error and improving going forward. However, to be clear, the error did not result in additional costs to customers. In other words, there's not a dime that we are seeking to recover from customers that was caused by this error. Instead, the error caused us to overstate revenues collected, which led to an incorrect balance being reported. The overstatement does not affect actual expenses incurred, nor the reasonableness or the prudency of those costs that customers would be expected to pay over time in full in the absence of the error. The company's request is simple. We're requesting to correct the cumulative balance to accurately reflect incurred but not recovered costs. We are not attacking any prior rate. We're not seeking to reopen prior JAAR proceedings. We're seeking to correct our mistake by accurately reflecting the cost incurred, which were reasonable and prudent, but not recovered. Again, we regret the error, take full responsibility, and have already taken steps to avoid this type of reporting error happening in the future. I will review the basics of the error in my prepared remarks, and our witnesses, Mr. Sykes and Ms. Quick, will also offer further details. With that context, I would like to turn to the core legal question before the commission, which is a straightforward but critical question. When the General Assembly mandates that a utility shall recover all reasonable and prudent costs, does all mean all? The company respectfully submits that the answer must be yes. While counsel for opposing parties have presented a series of flawed legal arguments attempting to block recovery, not a single party has contested the reasonableness or prudence of the cost at issue, which is the only limitation the statute imposes. That's because there's no legitimate dispute on that point. When the General Assembly authorized a $1.2 billion acquisition to serve the public interest, it did not intend for reasonable and prudent costs to be lost on a technicality. This transaction, the purchase of partial ownership interest in DEP nuclear and coal plants previously held by the North Carolina Eastern Municipal Power Agency, was entered into prudently and has delivered substantial fuel cost savings to customers since its inception. In anticipation of this acquisition, the General Assembly enacted a specific and unique cost recovery framework, which you've heard today from parties referenced as Section 62-133.414, the JAAR statute. This statute expressly directs the commission to develop a rider that enables a utility to recover, again, all reasonable and prudent costs incurred to acquire, operate, and maintain the proportional interest in electric generating facilities purchased from a joint agency. Acquisition costs were to be levelized over the life of the assets. It further mandates annual adjustments to that rider, including any over or under recovery resulting from its operation. In other words, the General Assembly made its intent unmistakably clear. The commission is to establish a mechanism that ensures DEP is allowed complete recovery of all reasonable and prudent costs to acquire, own, and operate joint agency assets subject to annual adjustments over the life of the rider. With this mandate in mind, the commission adopted Rule R-870, which incorporates what is known as the rolling recovery factor. This factor is designed to reflect the balance of any over or under recovery and cost recovery each year, and to ensure that DEP's annual cost recovery stays aligned with actual prudent costs incurred over time. Importantly, in testimony, commission orders, and public affidavits, this balance is consistently called the cumulative balance. That term is used throughout the record, makes clear that the rolling recovery factor was intentionally established to track and maintain costs incurred but not recovered. It's not a one-time adjustment. It is a rolling, forward-looking mechanism built to ensure that no prudent costs fall through the cracks due to timing or test year limitations, or in this case, a technicality. And an example I will offer you, you will see across all of the commission's orders since the inception of the rider with respect to the term cumulative balance. The language is consistent and states a cumulative balance of costs incurred but not recovered through the joint agency rider. So Commission Rule R-870B provides for an over or under recovery component as a rolling recovery factor or a joint agency asset RRF, and requires the company to use deferral accounting and maintain, again, a cumulative balance of costs incurred but not recovered through the joint agency asset rider. That language appears in every single order this commission has issued in the annual JAAR rider without any objection from any party, including the public staff. This design was deliberate. The rolling recovery factor carries forward the cumulative balance, adjusted each year based on actuals from the test period. So the cost recovery remains accurate and complete throughout the life of the rider. And if any ambiguity remains, the JAAR statute will eliminate it. The JAAR statute ends with subsection D, which explicitly states that the rider will continue until the end of the useful life of the acquired assets, and that any remaining unrecovered costs at that time must be deferred to the company's next general rate case. That provides clear additional pathway to ensure full recovery as intended by the General Assembly. The General Assembly established a primary way and then in a secondary way to ensure that the company recover its costs in full, provided they are reasonable and prudent. And the parties have not contested their reasonableness or their prudence, and this commission has reviewed those costs. They've been vetted and audited and deemed reasonable and prudent. And I'll step back a second there to say the costs have been in total determined to be reasonable and prudent. As it relates to the acquisition costs, consistent throughout all orders, if the cost relates to the acquisition price, the commission is very clear. That price is deemed reasonable and prudent. So anything beyond that is what's being subject to prudency and reasonableness. The General Assembly was very intentional about making sure that the company could recover its costs in full. Despite all of this, the statutory mandate, the commission's rules, and the consistent use of the term cumulative balance, the parties now ask the commission to adopt a radically narrower interpretation that the rolling recovery factor was meant to incorporate only test year actuals. That view is not only illogical, but directly contrary to the statute, the rule, commission precedent, and even public staff testimony. For example, in the 2023 JAAR filing, E-2 sub 1324, Mr. Sykes testifies that the rolling recovery balance is $23.3 million and largely comprised of the under collection for the previous test period. Not the current test period, the previous test period. And public staff's affidavits filed in that docket state that the incremental RRF rates for that period, which is the future year, were determined based on a cumulative under recovery of $23.3 million, the same number that Mr. Sykes referenced, which was comprised of an under collection from previous test years. Now public staff is saying that is not permitted. The commission should not be swayed by the arguments that require legal and logical contortions to achieve a conclusion that is unsupported by the statute, rule, or established practice. And why are these contortions being made? Because the parties know the law and the rule supports the company's request. They see that the statute mandates full recovery of all reasonable and prudent costs. They know the commission has both the authority and the duty under the JAAR statute to correct this current error so that the rolling recovery factor accurately reflects the full cumulative balance. Instead of honoring the statutory framework, they now argue that the RRF should not be corrected and that the company should be denied recovery of costs. The commission has already found to be reasonable, prudent, and recoverable, simply because the reporting error did not cause any increased costs for customers. That is not consistent with the law and is not what the General Assembly intended in establishing the rider. And in fact, it's not consistent with what public staff has stated. In public staff's testimony, they state that if this had resulted in an overcollection, that it would be reasonable for the company to correct the cumulative balance to refund customers. And the company agrees, it would be reasonable. It goes both ways. The cumulative balance has been that is there and tracked through the rolling recovery factor is to ensure that any over recovery or under recovery is reflected based on actuals to align with cost recovery with cost incurred. The core issue the parties point to is an acknowledged error that they now argue should override the law, the rule, and established practice. And to be clear, the company is not minimizing the error. The error did not result in incremental costs to the system. The costs at issue relate to acquisition and O&M costs already incurred and assets already providing value to customers. With that said, I'd like to briefly discuss the evolution of the error. In 2025, as I mentioned earlier, during a comprehensive enterprise-wide review, the company identified a previously unknown flaw in the internal revenue report used to calculate JAAR revenues that it then used to determine the cumulative balance that drives the rolling recovery factor. This flaw caused an overstatement of revenues assumed to be collected, resulting in approximately $16 million in under-recovered JAAR costs dating back to 2021, during which the Customer Connect billing system transition took place. Detecting this was especially challenging due to how impacted customers are billed correctly on a KW basis, but in a way that masked the error within the internal reporting system. That flaw was mistakenly introduced during the Customer Connect conversion. Someone made a mistake. They misinterpreted when they were taking the legacy reports and converting them to Customer Connect. We converted over 700 reports. Someone made a mistake. It wasn't intentional. It wasn't malicious. No one was asleep at the wheel. Despite business practices that helped identify an initial issue, it took time for the error to fully reveal itself, further emphasizing the complexity of customers' bills on a KW basis. In 2023, during preparation of that year's JAAR adjustment, the company detected a narrow proration problem related to mid-cycle rate changes and implemented a targeted correction based on the available information. If it's helpful for an example, in that case of proration, if there was a change in rates during mid-cycle. So any given month, there might be a change in rates halfway through. And so the first half of the month, the company took the commission-approved rate and applied it to, say, 500 kilowatts. And then on the second half of the month, applied the new rate and applied it to 500 kilowatts and correctly billed the customer for 1,000 kilowatts based on the approved rates, the new and the old. The flaw in the system for the reporting aspect was just pulling it and viewing it as 2,000 kilowatts, not appreciating that the proration was taking place. So we billed correctly, but the report that the end user uses to develop, to report the cumulative balance, which drives the RRF, was doubling AWs in that instance. The semi-annual review, newly implemented and led by Witness Quick, allowed the company to understand the scope of the reporting errors fully. She worked closely with Witness Sykes and his team to investigate and validate the corrective logic now embedded, aimed at preventing a similar occurrence in the future. As I've noted, the company would have proposed a corresponding adjustment if the report had understated revenues. The principle remains the same. It's consistent, aligning actual revenues with actual commission audited and prudently incurred costs. There's no evidence that the company ignored these discrepancies. Instead, as new facts emerged, the company's understanding evolved and the teams acted appropriately and in good faith at each step. Correcting the mistake does not give the company anything beyond what the statute entitles it to. It simply ensures the company recovers the cost it prudently incurred, and the customers pay their lawful share as contemplated by the commission's rule and the statute. That is precisely what the rolling recovery factor was designed to do. Maintain alignment between actual incurred costs and actual cost recovery, even when a technical or administrative error occurs. The parties are not asking the commission to discard that framework, not because the costs were found to be unreasonable or because the statute has changed, but solely because the technicality is due to a mistake. Further, as I've mentioned, the error didn't cause any additional costs for customers. You've heard a lot of oral arguments or presentation remarks that this is a $16 million error. It's not a $16 million error. There was no additional cost. The $16 million represents the reporting error, the report that captures the revenues. The costs are still the cost. The cost, that number has not changed, and we're not seeking any more than what customers would have been obligated to pay, but for the mistake. And on this point of the fact that every dollar that we're requesting was prudently incurred, it's worth noting that parties have not carried their burden. Earlier was a discussion about negligence. The standard would be prudence. First, the only limitation in the statute is reasonableness and prudency. Both of those have been met. And there's no evidence in this record or any prior filing that would state otherwise. So back to the standard would be prudence, the prudency standard that this commission has considered in the past. As the commission has established, to support a disallowance or recommendation for disallowance, a party must identify a specific and discrete instance of imprudence and demonstrate the existence of a prudent alternative, as well as quantify the effects of the imprudence on ratepayers. And we don't believe that the parties have satisfied the first two prongs, but importantly, they haven't even attempted there's been no attempt by any party to satisfy the third prong. That is because the error, which we don't agree equates to imprudence, did not cause any additional costs. Therefore, there has been no financial effect on customers. The request is requiring customers to pay prudent costs that they otherwise would have paid, but for the error is not an effect on ratepayers for purposes of this analysis. If the commission were to accept the opposing party's position, it would mean that while other rate classes, the residential rate class, have already paid their fair share of these costs, the LGS customers, or large industrial customers, medium general service customers, would avoid their lawful obligation due to a technical mistake. Ensuring that all customers ultimately pay their appropriate portion preserves the fairness and the integrity of the recovery mechanism, especially since the company has met the standard of reasonableness and prudence as required by the law. Before concluding, I would like to briefly address the company's position on retroactive rate making, which is fully briefed in its pre-hearing brief, and we're happy to address any additional questions that the commission might have. But I will touch on it briefly. The claim of retroactive rate making is misplaced. As noted, the statute requires full recovery of prudent and reasonable costs. To implement full recovery, the commission designed a rolling recovery factor to reflect cumulative under or over recovery balance, which is adjusted for test year costs annually to ensure costs are recovered over time. That is, from the very inception and design, the JAAR rider looks back in time, and that fact is clearly allowed under the law. The company's request to correct its error is within the bounds of the mechanisms enshrined in the JAAR statute, confirmed by the commission's rules. The company is not revisiting past base rates. It is applying a lawful, commission-approved process to recover reasonable and prudent costs incurred on behalf of customers under a tariff that has been trued up to reflect actual costs and actual recovery since its inception. The commission's ability to allow the company to recover its prudent costs in full is well established and clearly is not retroactive rate making. To suggest otherwise disregards the General Assembly's directive and recovery structure the commission put in place to meet that directive. What the company now requests is not extraordinary relief. It is necessary and appropriate correction to ensure that the RRF functions precisely as it was designed to. In the course of 10 years of administering this complex tariff, this is the first instance of a reporting error coming before the commission, and there's certainly no pattern of repeated errors impacting this rider. And had this error again cut the other way and we over-collected, I can assure you that we would have returned the cost to customers. The costs at issue were prudently incurred and their services were rendered and customers received all of the benefits of the underlying assets. The error resulted in no incremental costs to impacted customers. And the company is sensitive to bill impacts, which is why the company offered initially a 2-year mitigation strategy and elected to forego interest, even though it is entitled to recover interest on those costs. We offered a 2-year in our direct, and then our rebuttal testimony offered further mitigation to a 3-year. And the company remains open and has been very transparent about that with the public staff, as well as CUCA and SIGFR, because we recognize bill impacts. But there also has to be a balance here. The company has incurred those costs on behalf of customers, and those costs have been audited, vetted, they're reasonable and prudent, and they're recoverable. And the customers who have not been impacted have paid their share, and it is not unreasonable for the company to expect the impacted customers to also pay their share. The statute does not demand perfection. The error resulted in no incremental cost or harm to impacted customers, as I just stated. The statute does not demand perfection, nor has the commission ever held the company to such a standard. Instead, all that is required under the statute is that the costs be prudent and reasonable, which no party has disputed or challenged. The company respectfully asks the commission to approve this correction, uphold the statutory framework, and preserve the integrity of the JAAR rider established by the General Assembly. Thank you for your attention. I'm happy to answer any questions to my best ability. I think
You're right on 25 minutes. You did not have 30 seconds left.
I could feel it.
Well, you were sensing it correctly. Let me just ask you this. So Duke's contention basically is if you look at the general statute and you look at what's permitted there, that as long as these costs are reasonably and prudently incurred, even though there may be an error, it makes no difference when that error might be found. It could be 10 years from now. It makes no difference as to the magnitude of that error. It makes no difference whether it's computational or resulting from perhaps other factors. As long as those costs are reasonably and prudently incurred, they're able to recover them.
I think the short answer is yes, and I will build on
Go right ahead.
that. The limitation, as you stated, is that the cost needs to be reasonable and prudent. And that is laid out clearly in the statute. And the fact that the statute stated that any cost over or under the recovery resulting from the operation of the rider, and then goes on to make a point that any costs that aren't recovered at the expiration of this rider must be deferred to the company's next general rate case, is a clear indication that these costs must be recovered. And so it is not ideal to be standing before you, having to recognize this error. And we will take every steps to avoid errors in the future. But if an error does occur and then doesn't relate to the actual cost, in this case, the costs have already been vetted. The costs are what the costs are. We should be able to recover those costs. So if it did go back 10 years and the company has done a very comprehensive review to make sure that anything that the flaw would have impacted going back to the inception of Customer Connect, and either did some further research to see if there was anything historical going on. We were very comprehensive, so I don't anticipate anything arising from 10 years ago. But I think the point is you can set the rate, according to the statute, a future rate based on the company's cost recovery of costs that have been incurred but not yet recovered.
So as long as the rider is still in effect and the debt from the original acquisition is still being retired, any of the other cost factors related to that proportional interest that was acquired, that even if you had to go to the last year of that rider and go back and find something that occurred a decade or more before then, you're still eligible to get the recovery. That's what I'm hearing. Is that correct?
I think that is correct. And now, obviously, we're speaking about hypotheticals. There might be facts and circumstances that might require a different approach. Considering customers and the utility, and we're always, because our customers are always front of mind, and we're always trying to balance those things. But as we read the statute would allow for us to make further corrections. I think the General Assembly was very clear, especially making sure that at the expiration of the rider, any costs unrecovered would go into the company's next general rate case. That when they carved out a recovery pathway for this significant transaction, that it wanted to be very clear that those costs would be recoverable by the company, provided they're reasonable and prudent. Hence the rolling recovery factor. You're setting a rate and carrying the costs and moving them forward through the life of the rider, and anything left over would then be deferred to the general rate case.
And of course, you have Rule R-870, which was proposed, and I guess by the public staff and by Duke, and the language was clear or appeared to be clear and unambiguous at that time. You would say every provisions dealing with test year are not a limitation in any respect.
No, I don't see it as a limitation in any respect.
Okay.
The rule says that the electric public utility will maintain an under or over recovery balance and add to that balance the difference between reasonable and prudent financing and non-fuel operating costs incurred by the electric public utility during the test period and the revenues to recover those costs during the test period that were actually realized. And as I mentioned earlier, testimony from public staff is always recognized that the RRF has reflect a cumulative balance based on test year costs and costs preceding the test year. And that has been approved over and over again with each JAAR rider, starting the 2026 JAAR rider.
And the rolling recovery factor, of course, takes that all into consideration.
Yes, it was designed for that precisely to make sure that the cumulative balance is being tracked And so then you track the balance. At the end of the year, you have a cumulative balance. And then you look at test year actual. It might be over recovery and under recovery, and you net that out. Then you take the balance and you move it forward, and then you reset a new recovery, rolling recovery factor on an annual basis. The statute starts out by saying, upon petition by the utility, that the commission shall allow the company to recover its reasonable and prudent costs. It's the annual petition that brings the company before the commission to review the costs that are in the rider, all the adjustments that are required in subsection B of the statute, and then further adjust it for the four things Ms. Herrick mentioned, including any over or under recovery resulting from the operation of the rider. And with those mandates, the commission designed a rolling recovery factor. And in all of the orders and in testimony, it is always referred to as a cumulative balance because the intent of the statute is unambiguous. Look at the plain language of the statute, and the rolling recovery factor is in place and designed to affect the intent of the General Assembly.
Very good. I'm going to look for questions here. Chair Brawley, do you have any questions first? All right. Commissioner Cameron.
Ms. Toon, thank you for your oral argument and responses to Commissioner McKissick's questions. Following up on his question about if there had been, an under recovery from, I think you said 5 or 10 years ago, I think your response was, do you think that the statute and the rule allows DEP to recover those costs, even if they, so here we're looking back 4 years, but if the under recovery was from costs 5 years ago or 10 years ago, I think I heard you say that your position is that Duke should be able to recover those costs. Is that correct?
That is correct. The statute allows for it. And in the same way, if we owe customers, we should also make that correction to refund customers if it goes back 5 years or 10 years.
Okay. Well, that was going to be my next question. If it's 5 years or 10 years, the standard Duke's position would be the same. If you over collected, that Duke's position is that it would agree to make that correction. If it over recovered, say $16 million 10 years ago, that would be returned to customers. Is that your response?
Absolutely.
Okay. Is there not does Duke think that there's a time period when it becomes stale, the cost becomes stale, or it becomes unreasonable to try to collect costs because too much time has passed? Is there not any time period that it becomes unreasonable to try to collect or to return costs?
I think in respect to the JAAR statute, there is not a time limitation. The language of the statute makes it very clear. It says through the life of the rider. Subsection B says when the rider expires, when the assets are no longer useful, it still established a secondary pathway for recovery. And so the rolling recovery factor is designed to maintain a cumulative balance to ensure that any over or under recovery is tracked over the years and to make sure that the company recovers, provided they're reasonable and prudent, their costs, but no more or no less.
Right. And I understand your position about that, but the rolling recovery factor with addressing the cumulative balance, there's no language in the statute of the rule that provides any express or specific authority to Duke to look back outside the test period. Is there any express or specific language that you can point to?
I would say there's no limitation on the language. The language I would point to is that the commission shall require the company to propose an annual adjustment for any over or under recovery resulting from the operation of the rider. There's no limitation that says operation of the rider ending in a 12 months period, starting January 1st. There's no qualifications around that adjustment. Is make it very clear that that adjustment should happen, whether it's over or under recovery resulting from the operation of the rider.
Okay. And then my last question, I just wanted to make sure I understood your argument about I think you referred to the 2023 JAAR proceeding. And did I understand your argument or what you stated that in that proceeding for the rolling recovery factor, that DEP included a look back to costs outside of the test period and the public staff did not object to that? Is that what happened in that proceeding?
That is correct.
Okay. And is there, where in your brief or testimony is there information about that, or did you include that argument in your brief so that we can refer to it?
I included it in my brief, but also the witnesses will speak to it at our rebuttal panel.
Okay. And there was and the public staff did not object to considering costs that had not been recovered outside of the test period in the 2023 proceeding. Is that correct?
That is correct. And yes, that is correct.
Okay. Thank you.
Go ahead, Commissioner Tucker.
I think Commissioner McKissick and Kim Wright have answered most of my questions. Just curious for the commission, what internal changes have Duke made to eliminate the possibility of this happening again, because you've been chastised for making errors over 3 different reports by public staff? What internal changes have been made? If I made a $16 million mistake, or an employee of mine made a $16 million mistake, I don't know what that outcome would be, but can you share with me what you've done to change to shore up your accounting so that we can have confidence in what you present to us in the future?
Yes, I can speak to it, and I think Witness Quick will be able to provide you more detail. But we have established the semi-annual review I mentioned earlier. And as part of that review, the findings came out about the JAAR report. They've since implemented a formal SOX control to avoid this happening in the future. In addition, and that came after doing a comprehensive review, looking back to the inception of Customer Connect. And then we took the time to sit with public staff, our technical folks, work with public staff technical folks to do a 41 account audit, where it has with the bills, look at the bills, to look at the revenue report to ensure that what the bills state and how customers have been billed aligns with the revenue report, to make sure that the revenues that the report are capturing properly align with the bills. So they did do an audit of 41 accounts, and our folks, staff folks, to make sure that they were comfortable with that the control we put in place and the process we put in place moving forward would avoid this type of error happening again.
So, as best you can tell, you think you've made the internal changes that would not allow this to happen again, ever?
Ever for the time.
I don't know if I can say ever.
It's a really long
We've
time.
taken every step, and Ms. Quick will speak more to it, to sort of add additional control, now a formal control. There's and I'd be going over my skis on this part, but there are business practices that are in place, and then there are also a formal control. And those are 2 different things which Ms. Quick can get into more. So we now have a formal control for the JAAR revenue report. And as I said, we've done the sample audit to make sure for our own knowledge that the process we've put in place is now making sure that the revenue report aligns with the bills. And we've also had the opportunity to sit with public staff, and I'll let the public staff speak to that, but with their technical folks to make sure that we're moving in the right direction. But I will say, and Witness Quick can speak more to this, there's no number of controls I think that anyone could put in place to mitigate risk to 0. But we've made every single effort. It is front of mind. We've implemented a semi-annual process. Certainly folks are, like I said, there are people who are dedicated to their job behind the decisions, and they feel bad about it, and they're doing everything they can to make sure this doesn't happen again.
So all the same personnel still there that
Nope.
made the error?
Many of those folks are not. here. This, I
They've
think,
chosen careers and elsewhere.
I don't know, maybe some have retired.
Right. Let me just, one more question. I think the entire assertion of your oral argument is when there is a over collection, we return those revenues to the customers. When there's an under collection, we've got the right to collect that. And I think you stated that, Commissioner McKissick, I've heard that. And is that a correct representation of your position and your interpretation of the statute?
For the collection portion, provided they're reasonable and prudent, that is correct.
Thank you.
I believe Commissioner Cameron might have one last question.
And one follow-up question. I think a number of the commissioners have asked questions about a time period of looking back, and your Duke's position is that there is no limitation in the time period to look back to collect for reasonably and prudently incurred costs. But from a practical standpoint, if doesn't that become more difficult with the passage of time? Because the public staff, they're tasked and they're responsible for investigating and auditing costs to make sure that they are in fact reasonably and prudently incurred costs. But if we had a look back, and this is not the situation here because we're looking back 4 years, but if the look back was 5 years or 10 years, doesn't that become potentially problematic for the public staff to do its job and to determine whether the costs are reasonably and prudently incurred? In other words, from a practical standpoint, shouldn't there be, is there not some time limitation about when it's possible for public staff to do its job and to ensure that costs are in fact prudent?
The statute requires us to bring annualized data to the commission as part of the annual record. So we did bring that information, and those costs that we presented haven't changed. So we're not seeking to change the cost. We're not coming in and saying we thought it cost $100, turns out it cost $150. We're saying it did cost $100. We recovered $50, but we told you we recovered $100. So what we're seeking, I think it'd be very different to go back 10 years from now and say, we told you it cost $100, but it turns out it cost $150. Like, that's a different scenario as opposed to we over recovered by $100 10 years ago. We need to refund that back to customers, or vice versa. We didn't recover the full 100. I'm using small numbers here, mostly for my benefit. And I know there'll be bigger numbers than that. But if we, for the $100, so I'm using it as an example, if we didn't recover those costs and they were reasonable and prudent and they aligned with the costs that we presented in the annualized data, then I believe that we should be able to recover those costs.
And so I think what you're trying to argue is that my hypothetical about difficulties and impracticality is not applicable here because, in fact, for the costs that were incurred up to 4 years ago, there's no dispute that they were reasonably and prudently incurred, and that my scenario might have a different fact pattern. Is that a correct to
I
state?
think it's fair assessment because the costs we're talking about, public staff and other parties doing trade have had the opportunity to review its effects. So I think, again, we're dealing with hypotheticals. There are different facts and circumstances that could arise that says maybe we should be approaching things differently. I don't know what those are. But I think based off of the questions you've asked, that for the purpose of this writer, which is unique and very intentional as recovering our costs, provided they're reasonable and prudent, that the approach we're taking in this request is lawful and supported by the commission's precedent and testimony provided by parties and these writers.
Okay, well, thank you. Doesn't look, oh, excuse me, Commissioner Vandervoort, I didn't see your hand raised or a note.
So
I'm sorry.
just to follow up on the question I asked Ms. Harrod, sounds like you don't have any bounds on this. In other words, no time limitations, no cost limitations, or no reimbursement limitations either. Doesn't matter whether it's 16 million or 16 billion. But what about the standard of duty? I mean, does it matter that, I mean, is there a question of fact in terms of how, no matter how egregious the mistake was? I mean, it seems to me that wouldn't, I think it gets after Commissioner Tucker's point is I don't see any incentive. I mean, I'm very worried about a precedent that's set here because it's not established law. If we say something, if we decide something, then I'm not sure if we decide, yeah, sure, it doesn't matter how long ago it was, doesn't matter how much it was, doesn't matter, if somebody was sleeping at his desk or whatever, you're going to get backstopped. It's not much of an incentive to do better. I mean, I hear your assertions and I'm sure you're sincere, but you're in a big organization and, incompetence is everywhere. So are we supposed to say, that's fine. We'll backstop your inability to manage your people. They can make mistakes willy-nilly. They can be negligent and don't worry, we'll pay. And if the costs were higher, I know 16 million in the grand scheme of things isn't a lot, but if the costs were higher, there would be detriment and damages to companies who have perhaps for which their electricity costs is a big component of their budget, and they've been planning their next year's expenditures, and all of a sudden that may get thrown into a bit of a disarray because oops, here Duke screwed up again, and we got to pay for it. So that's my concern. If we could have some parameters around either the length of times that has passed, which I think Commissioner Kimmerat makes some good points. I mean, the same arguments for statute of limitations applies to this kind of inquiry. If there's no limits to the amount of money we're talking about, you could really cause a problem for a small commercial budget who relies heavily on electricity use. And if the standard of duty is not relevant, I mean, that's no incentive on y'all doing a better job. So you don't, I mean, I hear you're saying if it's reasonably prudent, I'm not sure it is prudent if he keeps growing up, right? I mean, at some point, there's got to be a backstop here that says we don't really, we want to be incentivized to do better in the future. I mean, I understand what you're going to say. It's reasonable, prudent, go pound sand. I get it.
I'll try to address a couple of things that you've stated. So I'll start with the last thing I heard, with the concept that if Duke keeps repeating this mistake, then they should still be allowed. I don't think that it squares with the commission's framework for assessing prudence. If this is a repeated offense over and over.
Okay, so
Pretty sure.
okay, so we can take into account, right.
So part of, and that's what, there's and I can mention it, I can reference it again if that's helpful, but there is a 3-prong that is set out by this commission. If we're gonna find something is prudent, you have to find a discrete act that was prudent or an inaction that was imprudent, and then provide an alternative and then quantify the impact. And so another indication that something might, and I'm not trying to argue for them, but it might indicate that in any case, that not just the JAAR, that not just the matter of JAAR, is like, a repeated errors going over and over again. And so to your point, there are limitations. Duke isn't able to, and nor does Duke want to just sort of be of the mind, that we'll just do whatever we want, no big deal, we'll recover our costs. That is not our position at all. As I stated earlier, our people are really dedicated and care about our customers. We are our customers, and we care about our customers' trust in us. So it's important that we strive for perfection, although it's not the standard, that we strive for perfection, but sometimes mistakes happen. Now, mistakes are happening over and over again, and we're doing everything to avoid that happen. I think this commission would be in a position to say, you're now being imprudent. And as to the cost, and sort of earlier you mentioned the costs don't matter how high or how low, the costs have to be prudently incurred. So we can't incur costs imprudently. There's still the opportunity to say, the cost you incurred, was that prudent? Was that reasonable? And if it isn't, then public staff and other parties have the opportunity to say, the cost they paid was not prudent. And then that can be subject to an adjustment. So there are limitations there.
No, I get that, but in this case, the costs incurred for the JAAR program were prudent, everybody gets it. And rather than say that you all making a mistake makes those expenditures imprudent, which, I have a hard time with that. Would you argue that perhaps we should go ahead and reimburse those prudent costs that were incurred, but we should consider a management penalty instead? I mean, with that to me is a cleaner, I don't want to place a burden on you all for, as you said, having incurred reasonably imprudent expenditures. And just because of failure to manage a group that was responsible for doing some number crunching, that shouldn't impact the prudence of the original expenditure, right? So I don't want to take it out in that context. But so would you argue perhaps that if things really got out of hand, we should, I forgot who brought that up, but one of our other tools, which is to levy some sort of a management penalty. Would that make sense?
To my knowledge, a management penalty has not been applied in the context of a rider. And I'm happy to brief that if that's the question. And I think we spoke to it a little bit in our brief. But even if, and from my understanding of management penalty, the penalty would be to the cost incremental to the cost incurred. And so if the under recovery is 16 million and then say there's additional 5 million. And I think management penalties are usually applied in like a base rate case, so like the return, you are sort of penalizing the return on those costs, which I think is why it's not been applied in the context of a rider, but it still would be those extra costs. And so even if a management penalty were to apply, which I don't believe it does here, it wouldn't apply to the 16 million, it'd be any additional cost. And we're not asking for anything other than the approximate 16 million. And we've elected to forego the interest that we could recover, which is approximately $2.1 million. Even though we're entitled to recover under the statute in recognition of, bill impacts. And again, which is why we said, here's a 2-year mitigation strategy, and the rebuttal we've offered further mitigated to a 3-year strategy so that customers can step into the payment. But the customers did have received the benefit. We did incur the cost on behalf of the customers. And so we've seen that the request is consistent again with the law, commission rules, commission precedent.
Thank you.
All right. Well, I believe we have concluded all commissioner questions relating to oral arguments. So let me thank you and sharing your thoughts and perspective, as well as all the others attorneys who have provided us with their collective thoughts and perspectives as it relates to the critical issues in this case. We're now going to go ahead and begin the evidentiary hearing. We'll allow just like a 2-minute transition. We're not going to take a recess, but if we could go ahead and get people in order. And I believe the first panel would be DEP, direct and supplemental. And before we do that, let me ask if there are any motions we need to address at this time or any other matters. Not seeing any. So if we'll go ahead and begin to make that transition, and we'll look at our schedule. We're trying to move things along, knowing that we have other rider proceedings today as well that we will need to get to. I believe Sykes would be the first one. All right. You could put your left hand on the Bible and raise your right hand. Do you solemnly swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? All right, very good. And it looks as if we have cross-examination time provided by SIGFR, CUCA, as well as the public staff. And we'll go ahead and recognize SIGFR's counsel. Okay. Oh, yeah, go ahead, put your preliminaries into the record. Excuse me.
Thank you,
Yep.
Presiding Commissioner. Mr. Sykes, Would you please state your full name and business address for the record?
Yes, my name is Brian L. Sykes, and my business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Progress LLC as Director of Rates and Regulatory Planning.
Please briefly describe your role and responsibilities at Duke Energy.
As Director of Rates and Regulatory Planning, I have responsibility for certain annual rider filings for both Duke Energy Progress LLC and Duke Energy Carolinas LLC, including the Joint Agency Asset Rider, the Fuel Cost Adjustment Rider, the Clean Energy Portfolio Standard Rider, the Competitive Procurement of Renewable Energy Rider, and the Customer Assistance Program Rider.
Mr. Sykes, did you cause to be pre-filed on this docket direct testimony consisting of 22 pages, 2 summary rate exhibits, and 2 sets of exhibits labeled A through K, E, and A through K, TU, and finally Exhibit L?
Yes.
And do you have any changes to your direct testimony or exhibits at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes.
Your direct testimony does not include any confidential information. Is that correct?
That is correct.
Mr. Sykes, did you also cause to be pre-filed in this docket supplemental testimony consisting of 3 pages and all of the exhibits you filed in your support of your direct testimony with revisions to Exhibit E5, E, E9, E, and D3TU?
Yes.
And do you have any changes to your supplemental testimony or exhibits at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed supplemental testimony, would your answers remain the same?
Yes.
Your supplemental testimony does not include confidential information, correct?
Correct.
And did you pre-file a summary of your direct and supplemental testimonies for the commission?
Yes.
Presiding Commissioner McKissick, I would ask that Mr. Sykes' pre-filed direct testimony and pre-filed supplemental testimony be entered into the record as if orally given from the stand, as well as a summary of his direct and supplemental testimonies, also pre-filed with the commission.
All right. We have a motion to have this introduced into the record. Of course, what I have here is 22 pages of direct testimony with 2 appendices and 12 exhibits. I believe you identified it a little bit differently because you identified it by alphabet.
I did, but that is correct.
All right. And likewise for supplemental testimony, we have 3 pages, 2 appendix, and 12 exhibits filed on August 19th, 25. That'd be correct?
That is also correct.
As well as his summary.
That is correct.
All right. Without objection, that motion is allowed.
Presiding Commissioner, I'd also ask that Mr. Sykes' direct and revised supplemental exhibits be pre-marked for identification to be entered into a record at the appropriate time.
Thank you. So duly noted.
Mr. Sykes is now available for questions from the parties
All right.
and commission on direct and supplemental testimony.
Sure. Go right ahead, Mr. Ledford.
Thank you, Commissioner McKissick. Good afternoon, Mr. Sykes. My name is Peter Ledford, and I'm here on behalf of the Carolina Industrial Group for Fair Utility Rates 2 and the Carolina Utility Customers Association. At the top of page 12 of your direct testimony, you testify that, quote, "In this proceeding, the company has compared the actual unlevel revenue requirement for test period 2024 to the estimated unlevel revenue requirement for test period 2024 to determine the test period true-up amount that is part of the Joint Agency Asset RRF standing for Rolling Recovery Factor. Is that accurate?
Yes, it is.
And you say a little further down on page 12 at line 14 that there are also some inventory items that are included.
Yes, I do.
And then a little further down on line 19 through 21, that the financing costs for these amounts are included in the test from the test period.
Yes, I do.
But that's not all that's being included in the rolling recovery factor, correct?
I would say all of the costs that we are allowed under the statute and commission rule have been included in the determination of the rolling recovery factor.
So if you turn to page 16 of your testimony, you discuss a correction of approximately 16 million that you're proposing to recover, correct?
That is correct.
So for simplicity's sakes, I'm going to call this $16 million correction the contested costs, given that my clients are contesting the company's ability to recover them. And so you testify that this $16 million correction was caused by an error that occurred in the billing periods beginning on December 1st, 2022, correct?
Yes. So I would say the issue that I'm talking about here is related to revenues, not the costs, which have been deemed reasonable and prudent in prior proceedings.
Understood. Witness Sykes, if you can reach these two binders down here on the end, sorry. They're identical. One's for you, one's for Witness Quick when she comes up for rebuttal. Presiding Commissioner McKissick, at this point, I'd like to introduce SIG for CUCA, potential cross exhibit 17.
Okay. Motion to introduce Sigford cross examination number 17. Without objection, it's allowed.
Witness Sykes, can you please read Rule R8-70 B16? And that's at the top of page 3. It's Roman numeral 6.
Yes. Upon request by the electric public utility,
I'm sorry, number 6, not number 7.
Oh, I'm sorry. A joint agency asset rolling recovery factor, the joint agency asset RRF, to reflect the under or over recovery balance. The electric public utility will maintain an under or over recovery balance and add to the balance the difference between the reasonable and prudent financing and non-fuel operating costs incurred by the electric public utility during the test period and the revenues to recover these costs during the test period that were actually realized.
Thank you. Are the contested costs that we are discussing financing costs incurred by DEP during the test period?
A portion of the $16 million would be related to financing costs.
But were they incurred during the test period?
So I would say those costs, again, have been deemed reasonable and prudent in prior proceedings.
Understood, but were they incurred during the test period?
No, the
Thank you.
$16 million relates to costs prior to the preceding test period, which is calendar year 2024.
And similarly, are the contested costs non-fuel operating costs incurred during the test period?
Yes, once again, the $16 million represents the difference of the contested costs in this case, upon which the company is allowed to recover through the JAAR rider.
But were they incurred during the test period?
No, they would not have been incurred during the test period.
Thank you. The error that led to the need for this correction was caused by a report indicating the company was collecting more revenue than it actually was. Is that correct?
That is correct.
And that report was generated using the Customer Connect system. Is that correct?
So a slight nuance here. We bill customers through the Customer Connect system. We have a separate reporting system that is designed, when the reports are designed, to illustrate what revenues we would have recovered from those or collected from those customers from the billing system.
Commissioner McKissick, at this point, I'd like to introduce SIG for CUCA, potentially cross exhibit 26.
To turn my mic on, cross-examination is number 26, and we will identify that as your exhibit number 2.
Thank you. With this before you, does this not say that this was generated by Customer Connect?
I believe it says the requirements for the report were incorrectly interpreted during the reporting conversion from the legacy system to Customer Connect.
So Customer Connect is what generated the report?
No, Customer Connect, once again, is our billing system. And then there is a separate process to develop reports that the company relies on to illustrate revenues as they were billed to customers.
So what exactly is Customer Connect?
Customer Connect is the company's internal billing system, and happy to defer to Witness Quick when we get up on rebuttal, who can elaborate a little bit more on that.
And if I need to hold these for rebuttal, I can. But in the meantime, I would like to introduce SIG for CUCA potential cross exhibit number 9 and have that marked as SIG for CUCA direct cross exhibit 3.
All right, we have your cross exhibit number 9 being marked as CUCA direct cross exhibit number 3.
And can you turn to page 3 of the exhibit? Can you read lines 7 through 12 into the record, please?
And so this is not something that's within my testimony, but I will read it. You said page 3?
Yes, please.
7 through 12. Again, not my words, but happy to read it. I have executive management oversight for the Customer Information System, CIS, consolidation project known as Customer Connect, including the planning, execution, and deployment. This program is responsible for the successful deployment of a new customer platform that will enable the functional capabilities needed to meet our strategic purpose of powering the lives of our customers by transforming how we serve them.
Thank you. And now can you flip to page 12 of the exhibit? And can you read lines 14 and 15, please?
Once again, not my words, I will read. The estimated cost for DE Progress is $175 to $180 million, with approximately 50% reflecting the capital investment.
So is it correct to say that the company's North Carolina ratepayers have been paying for this multiple $100 million software system that was incorrectly implemented?
I cannot speak to that. I'm not an expert on that.
Okay. So turning back to your direct testimony, the rates that the company billed were approved by the Utilities Commission, correct?
Yes, my testimony states that customers have been billed the appropriate commission-approved rates.
And, well, thank you. You got ahead of my next question. So is it fair to say that the rider operated correctly?
I will say that the rider operated correctly based on the best information we had at the time when we were preparing the annual filings.
So how are the contested costs resulting from the operation of the rider, if it operated correctly?
The contested costs, once again, if you're talking about costs incurred in the JAAR rider, have been deemed reasonable and prudent by this commission.
Thank you, Mr. Sykes. Those are all the questions I have on direct.
Okay. Very good. Of course, at this time, we have those 3 exhibits you have identified, which have been appropriately marked, that being CUCA. Sure. I just want to make sure we have those officially into the record.
Yes.
Direct cross exhibit number 1. Of course, your cross exhibit number 26 is cross exhibit number 2, and then we have your cross exhibit number 9 going into cross exhibit number 3.
That is correct, and I would move those into the record at the appropriate time.
Without objection, it's allowed. And now we'll go ahead and proceed with public staff.
Presiding Commissioner McKissick, if I may, I have
Sure.
one redirect.
You would, okay, go right ahead. I didn't see any time requested, but go right ahead.
I didn't know, I apologize. I didn't know public staff. I thought you were more did redirects. Sorry.
No problem. I've done a lot of talking today and everything. President,
Yes,
sure you
go right
ready
ahead.
for public staff cross-examination? Good morning, Mr. Sykes. I'm Jennifer Harrod on behalf of the public staff.
Good afternoon.
No, I guess it is after. So obviously, I'm going to focus on the reporting error. That's the topic of this hearing. I'd like to note on page 16 of your direct testimony, starting at line 6, it says the company determined that an internal report designed to illustrate monthly JAAR revenues selected incorrect kilowatt values, which serve as the basis for how certain medium general service and large general service customers are billed. And as a result, revenues previously reported to the commission and subsequently used to set rates for the RRF were overstated. What does that mean that the internal report was designed to illustrate monthly JAAR revenues? What does that verb illustrate mean?
So as I stated earlier, the billing system is Customer Connect. We have a separate system where reports are designed meant to show us what customers were actually billed for various riders, various matters, including the JAAR rider. And so the report was simply saying, let me retrieve the appropriate kilowatt value for these customers from the billing system, apply the commission approved JAAR rates to illustrate what revenues should have been collected through the JAAR rider.
All right, so it's designed to illustrate revenue should have been collected through the JAAR rider.
That is correct.
Okay. But is it correct to say that the actual revenues, as opposed to what should have been collected, the actual revenues that were collected through the JAAR rider were recorded in the company's financial statements?
Yes, that is accurate.
Okay. Now, I believe it's your testimony that this error with respect to the JAAR report, and I'm going to call it that. I think it's got another like BIL 509. We could call it the JAAR report.
Yes.
Thank you. So I believe it's your testimony that the errors with respect to the JAAR report, the company discovered those in February of 2025. Is that correct?
So I would say predating 2025, in 2023, the same report would have existed. And we did identify an error in preparation of the 2023 annual filing. We identified the initial error in 2023 once we had a full year worth of revenue from, I'll say, the new system to base our expectations on for that year's annual rider proceeding.
I believe that's something that's more covered in your rebuttal testimony, correct?
That's fair, yes.
Okay, so I just, for the purposes of the cross-examination on your direct testimony, I'm just going to focus on the issue with the kilowatt, selecting the incorrect kilowatt determinant in order to develop that JAAR report, okay?
Okay.
Okay, so am I correct in understanding that Duke discovered that error in February of 2025?
That is correct.
Okay, and that was in connection with a company-wide investigation into what you call financially relevant reports that are generated out of Customer Connect, correct?
Yes.
Was there any sort of triggering event for that review of all financially relevant reports that was done in early 2025?
Not to my knowledge, and I'll defer to witness Quick to give a little bit more color around that.
Okay, we'll ask that when she's on the stand then. At any point prior to filing the application for this JAAR rider, did Duke approach the public staff and discuss this error that had been found?
No, not to my knowledge.
All right. I am not going to ask you about Rule R870 because Mr. Lepfer already asked you that. And so what I would like to do, though, is there a difference if we turn to Exhibit A1TU? Is that the same in both your direct and your supplemental testimony? Did that change?
Just a second.
Sure. Well, I want to look at the correct one. So
Okay, let's look at supplemental then.
okay. So for the benefit of anybody who doesn't have this tab, because I don't think these pages are numbered, that one is roughly halfway through. Well, that one is roughly halfway through the attachments to Mr. Sykes' supplemental testimony. And it's labeled at the top left-hand corner, Exhibit A1TU. Now, Mr. Sykes, what can you just tell us what this exhibit, especially this page of this exhibit, what this represents?
Let me make sure I have the correct exhibit. in the upper left-hand corner, what is the, I'll say, third line describer or description in there?
Joint agency asset rider rolling recovery factor, the third
Okay.
line. Are we looking at the same one?
Yes.
Oh, my colleague tells me that's page 48 of the PDF. So I guess we know I'm a paper person. Okay, what's the relevance of this particular exhibit, please, Mr. Sykes?
So this exhibit is meant to demonstrate where the company is with its rolling recovery factor for the JAAR proceeding.
Okay. And it begins January 2022 on line 78, and it runs through December of 2024 on line 113, correct?
Correct.
Okay. Do you have in front of you what I believe was previously marked as SIG for CUCA, Sykes Direct Cross Exhibit 1?
Yes.
Okay. And that's Commission Rule R-870, correct?
I'm showing Exhibit 1 as the general statute.
Oh. Is that pre-marked as? Excuse me, Mr. Sykes, lawyer stuff.
Ms. Harrod, it was potential cross exhibit 17 that
Thank
was
you.
introduced as exhibit 1.
Okay, Mr. Sykes, the exhibit that we want to look at is the one that was pre-marked as Exhibit 17, and which has been identified for the record as being SIG for CUCA Cross Exhibit 1. All right, so we're looking at Rule R-870 together?
Yes.
All right, and I'm going to focus on the same provision that Mr. Ledford did. Okay. So when we look at column A, revenue requirement,
Just for the record, I just want to make sure we're referring to SIG for CUCA Sykes Direct and Supplemental Cross Exhibits. We referred to number 1, number 2, and number 3. I believe right now you're on the one that's dealing with, was it number 17? That was the original?
it was pre-marked as Exhibit 17. That's correct.
Okay, just want to make sure for the record that we have it correctly identified, just so that people can refer back to it. Thank you.
Thank you. Okay. With reference to Commission Rule R-870B 1-6, what does column A represent? Is that something that's reflected in that rule?
So as it relates to the rolling recovery factor in
Mhm.
column A from the exhibit,
Mhm.
that is the company's ongoing rolling recovery factor balance under this rider.
Column A is?
Yes.
That's, I would, is,
Well, so with changes in the annual rider, that is the starting point for how we determine the rolling recovery factor balance that's in column H.
so, I'm sorry, I didn't enunciate. Column A as an apple.
Apple. Yes,
That
that is
explains
our
the
revenue
disconnect.
requirement. Yes.
Okay, so the revenue requirement, is that the reasonable and prudent financing and non-fuel operating costs incurred by the electric public utility during the test period?
Yes.
Okay. All right, so now let's look at column B as in ball. And with reference to the commission rule, what does column B represent?
So column B is our revenue collected, meaning the report that we rely on determines how much revenue or illustrates how much revenue we have collected from customers under previously approved JAAR rates.
Okay, and does column B break out on a monthly basis the revenues to recover the cost during the test period that were actually realized?
No, it does not.
In what way does it not?
So as we're talking through the revenue report, these numbers, the revenue collected in column B is coming directly from the report. And we've said previously that the report had errors in it. And so as customers were billed appropriately in the billing system, there will be a disconnect between revenues actually realized and billed from customers and what is reported in column B.
Okay, okay. Thank you for that clarification. Was this column intended to reflect when you first started running this in January of 2022, was it intended to reflect the revenues actually realized during that period?
Yes.
Okay. And, okay, thank you. Now let's talk about, column H as in hello. And so that represents in each period, the ending, that's the balance of the rolling recovery factor that Duke maintains, correct?
That is correct.
Okay. And it shows there, but it's little tiny print. So what you do is you take, first of all, we do the arithmetic that's suggested by Rule 870B sub 1 sub 6, and you take the difference between the reasonable and prudent financing and non-fuel operating costs and the revenues to recover those costs. And that's what's in column C, correct?
Yes.
Okay. And then to get to the ending deferred balance, we take, what does column D as in DAPR represent?
That would have been the balance as previously reported.
Okay. And is that, when reference to the rule, it says the electric public utility will maintain an over or under recovery balance. So is that what column D shows us? That's the balance that Duke is maintaining?
Yes, that is the balance before we add on the remainder to get to the ending deferred balance, the RRF.
Okay. So you start with what you've been maintaining, and then under column H, it shows what you're adding together. You're taking column C, which is the difference between the costs and the revenues. You're adding that to column D, which is the beginning deferred balance. And then you're adding in the gross up return, and that gets you to column H. And then is column H also demonstrating the math of maintaining that over and under recovery balance?
Yes.
Okay. So I'm not going to do this for every line of the spreadsheet, but if I take, so the test year for the JAAR is also the calendar year, correct?
That is correct. The test year would have been calendar year 24.
So if I were to take, okay, so let's do that. So if I were to take the ending, and I wish I had a straight edge up here with me, but if I were to take the ending of December 2023, which is line 101, and I go all the way across there and I get column H, the value there is what, please?
On line 101, the value is 1827.
Sorry, with respect to column H, the ending deferred balance.
It might not be on the right line.
Oh, I think you are.
It's a negative 547.
Okay. And then if we drop down one more line and we look at January 2024, so that's the beginning of this test year, what do we find the beginning deferred balance to be?
Negative 547.
Okay. So that's how that works. The ending balance for one period becomes the beginning balance for the next period, correct?
Yes.
Okay. So let me ask you this, and you kind of touched on this already, but in fact, now Duke has discovered that column B, that the listed figures all the way from line 78 all the way through line 1, well, I guess let's just deal with the prior test years, all the way through line 101. Those were not actually the revenues collected, correct?
That's correct.
And I believe you were the witness for those two rate cases, for those two JAAR revenue recovery rider proceedings, were you not?
I was.
Okay. And so did you provide testimony under oath that those were in fact correct?
Yes, through the course of my testimony, I would have said the revenues or the balance was correct.
Okay. I mean, these same figures would have appeared as exhibits to your testimony in those two prior riders, correct?
Yes, they would have.
Okay. So now let's look at line 114, which is called revenue correction. Now, Mr. Ledford already discussed with you that that doesn't reflect revenues or costs during the test period. Let me ask you this. Have you ever, has Duke ever, not you personally, but has Duke ever done a quote unquote revenue correction to the RRF balance in a prior proceeding?
Not that I'm aware of.
All right. I don't have any further questions for you, Mr. Sykes. Thank you very much.
All right, Duke. I assume you have some redirect?
I do, and apologies for earlier getting out of
It's okay. I knew they were next in my queue.
Thank you. Mr. Sykes, to an earlier question from Council for CUCA and CPRE.
Is your mic on or up? Maybe you want to bring it a little closer.
Is this better?
That's much better.
Mr. Sykes, earlier Council for CUCA and CPRE asked you some questions about customer connect costs. For the record, does the company's application include costs for customer connect?
No, it does not.
And you, Council for Public Staff has we've gone through your exhibit to discuss maintaining a cumulative balance. And I believe Ms. Harrod stated that the cumulative balance in 1 year becomes a cumulative balance in the next year. Do you remember that discussion?
Yes.
Okay. And does that mean that the cumulative balance that might move from the year 2022 to 2023 is completely paid in full, and then the next year's balance no longer includes costs from previous test years?
No.
Okay. Can you speak more about how costs over time, as we're maintaining the balance, are reflected through the rolling recovery factor?
Yes. So the rolling recovery factor is meant to be just that, a cumulative balance. And so the balance that we have as of a point in time will be made up of not only the test year costs, but also costs that preceded the test year. We are never going to be perfect in our recovery. So in some years we will be over recovered, in some years we would be under recovered. But conceptually, the balance as of a point in time consists of more than just costs incurred in the test period.
And when you prepared your testimony in this filing, as well as previous filings with Ms. Harris reference, when you prepared that testimony, did you prepare it honestly with the information you understood at the time?
Absolutely.
No further questions. Thank you.
We will now look to see if there are commissioner questions. All right, not seeing any commissioner questions. No, not at this time. No. All right, I think at this point in time, what I would like for us to do, it's 12:49. I know we technically have public witness hearings that are scheduled that have to take place promptly at 2 p.m. What I would suggest that we do at this point in time is, after your testimony, we'll go ahead and take a break for lunch. I think that might be the wise thing to do. I'd like for us to make through as much as we can, but at the same time, I don't want us to be rushed in doing so. I know that next in the queue, we have, of course, Collins McLawhorn, which is coming up. And it looks like that could take an extra 20 minutes or so. So I don't want us to get pushed too much with lunch approaching. So we're going to go ahead and recess at this time. We will return here. Why don't we try to get back here by 1:50? Okay. And we'll try to logistically work out things as much as we can before those public witness hearings at 2 p.m. to just see how things are rolling and what it's looking like in terms of scheduling, not just for this particular rider proceeding, but for other matters that are on the docket today. I think that might be the best way to proceed logistically. So we will return here at 1:50.
Mr. Sykes will be back for the rebuttal plan.
Yes, we have him down for rebuttal. And we will have questions of him at rebuttal.
Thank you.
Mhm. in terms of scheduling, we have all of the public hearings noticed for 2 p.m. So at 2 p.m., Chair Brawley will conduct those public hearings. After those public hearings are conducted, we will go back to the JAAR proceeding, and we will continue receiving testimony in the JAAR proceeding. When that testimony is completed today, we'll then move to the fuel proceeding. It is anticipated that we will adjourn for today at 5 p.m. and begin tomorrow. Was the stipulated time 9 p.m.? 9 a.m. Yeah, 9 a.m. 9 a.m. Yes, yes, yes. 9 a.m. tomorrow morning. We will begin and continue with whatever has been left incomplete. So, Chair Brawley, we got about 7 minutes before you begin. So people can be at ease until that occurs. And then we'll go back on the record in the JAAR proceeding at the conclusion of those public hearings. Thank you. in the JAAR rider proceeding. And next I have on my schedule here witnesses Collins and McLaughlin on behalf of SIGFR and CUCA.
Thank you, Presiding Commissioner McKissick. At this time, SIGFR and CUCA call the panel of Brian Collins and James McLaughlin to the stand.
If you could both put your left hands on the Bible and raise your right hand. Do you solemnly swear that the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Mr. Collins, would you please state your full name and business address for the record?
Brian C. Collins. My business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017.
By whom are you employed and in what capacity?
I'm a consultant in the field of public utility regulation and a managing principal with the firm of Brubaker and Associates Incorporated.
And did you cause to be pre-filed in this docket direct testimony consisting of 12 pages, one appendix consisting of 4 pages, and one exhibit pre-marked as BCC1?
Yes, I did.
Do you have any changes to your direct testimony at this time?
No, I do not.
If I were to ask you the same questions today that appeared in the pre-filed direct testimony, would your answers be the same?
Yes, they would.
Did you cause to be pre-filed a summary of your direct testimony?
Yes, I did.
And is the testimony set forth in your summary true and accurate to the best of your knowledge?
Yes, it is.
Mr. McLaughlin, would you please state your full name and business address for the record?
My name is James S. McLaughlin. My business address is 3216 Bedford Avenue, Raleigh, North Carolina, 27607.
By whom are you employed and in what capacity?
I am employed by both, in this case, by both SIGFR and CUCA as a consultant.
And did you cause to be pre-filed in this docket direct testimony consisting of 12 pages and 6 exhibits pre-marked as JSM 1 through 6?
Yes, I did.
Do you have any changes to your direct testimony at this time?
No, I do not.
If I were to ask you the same questions today that appeared in the pre-filed direct testimony, would your answers be the same?
Yes.
Did you cause to be pre-filed a summary of your direct testimony?
Yes.
And is the testimony set forth in your summary true and accurate to the best of your knowledge?
Yes, it is.
Presiding Commissioner McKissick, at this time, I would move the direct testimony and summaries of witnesses Collins and McLaughlin be entered into the record as if given orally from the stand. And I would also move that the witness summaries pre-filed on their behalf would also be entered into the record at the appropriate time.
Okay, without objection, we will admit the direct testimony of Brian C. Collins consisting of 12 pages with one appendix and one exhibit as filed on September 2nd, 2025, as well as his summary, as well as the direct testimony of James S. McLaughlin consisting of 12 pages with 6 exhibits filed on September 2nd, 2025, as well as his summary.
Thank you. I would also ask that the pre-filed exhibits be marked as pre-marked when pre-filed.
Your motion is allowed.
At this time, Presiding Commissioner McKissick, the panel is now available for cross-examination and questions from the commission.
Okay, I believe I have here DEP.
Yes, Presiding Commissioner McKissick, good afternoon. Gentlemen, Brett Brychwart on behalf of Duke Energy Progress. How are y'all?
Good. Good afternoon.
Good afternoon. Mr. Collins, I'm glad you sat on that side of the room because I don't have any questions for you. Mr. McClawhorn, it's good to see you. All right. So reviewing your testimony, you start off with explaining what the NCMPA assets are around page 3 of your testimony. Do you have that?
Yes.
And just around line 20, going on to the top of the next page, you refer to the purchase assets representing NCMPA's ownership interest in nuclear and coal plants owned by DEP, proportional interest. Is that right?
Yes.
And those are all pretty large power plants, correct?
Yes, at least at one time, they were all considered baseload plants.
Well, look, can we accept for this purpose their base load, meaning that they're high capital costs, they operate efficiency, lower fuel costs to operate the nuclear and coal facilities?
The nuclear facilities are definitely more efficient. The coal facilities, it's relative to what? I mean, they're natural gas facilities that are much more efficient than these coal facilities. These coal facilities don't operate very much. They're important until something replaces them for reliability, but they operate much less than they were built to operate.
Understood. Important assets to the system. And so you were at the public staff at the time that these assets were acquired by, the proportional interest in these assets was acquired by DEP in 2015, correct?
Yes.
Okay. And can you give a brief explanation of the circumstances of DEP acquiring these assets? Were you familiar with the proceeding that the commission authorized the acquisition of these proportional interests?
I recall the proceeding taking place. Of course, it was pursuant to passage of a law by the General Assembly that authorized this. It wasn't just something that happened here at the commission. There was a proceeding that had to take place at the commission, but it was pursuant to state law.
Understood. So the representatives who were up the street decided that this was an important act for Duke Energy Progress to take to acquire these assets. And so they enabled this commission to approve both the acquisition of these proportional interests as well as the recovery of the cost of those proportional interests. Is that right?
That's what the statute says.
That's right. And that's your recollection at the time.
I don't know exactly what the legislature was thinking, but obviously they wouldn't have passed the law if they didn't think it was something that should take place.
Very good. All right, let's talk about the costs that are allowed to be recovered. So you address this on page 4, line 9 or so.
Yes.
And so this refers to Rule RH-70, but this is generally effectuating the legislature's intent. Is that right?
I believe that's the case, yes.
Okay. So financing costs associated with the acquired plant. That's the capital investment in those acquired plants and the associated financing costs?
That's my understanding, yes.
Okay. And then fuel inventory, non-fuel operating costs, financing and non-fuel operating costs associated with the future capital investments. So that's you acquired the plant, then to run the plant, there's associated ongoing O&M. Is that accurate?
Yes.
Okay.
That's my understanding.
Okay. And that's what you meant in your testimony there?
Yes.
Okay, great. And so based on that understanding of this recovery mechanism established by the General Assembly and then implemented by the Commission in Rule RH-70, there's the concept of a rolling recovery factor. Are you familiar with that?
I'm familiar that the rolling recovery factor is in RH-70. That doesn't appear in the statute.
Okay, but it doesn't, you would agree with me that the commission in putting it in the rule was implementing the statute, and the public staff in agreeing to put it in the rule must have assumed at the time that it was consistent with the statute. Agree with that?
It certainly, I did not think it was inconsistent with the statute. There are probably many things that could have been done to implement this rider.
Okay.
Many nuances, and this was the one that was settled on.
Okay, but you agree that this effectuates the General Assembly's intent, and that's what this concept of rolling recovery, maybe just strike that and say it differently. You're not contesting that the rolling recovery factor is reasonably authorized by the statute and is appropriate to implement. It's been there for a decade, and the public staff never challenged the rolling recovery of these costs.
I will agree that the public staff would not have proposed something that it felt or supported something that it felt was not consistent with the statute, and I don't believe the commission would have approved something that it felt was inconsistent with the statute.
Yes, sir. Thank you. So turning to page 5, where you further discuss what is included in the RRF, starting on line 6. Do you see that?
Yes.
Okay. And you referred to line 9 to 10 that the commission the DEP reports to the commission any difference between the deferred balance at the beginning of the test period plus any over or under recovery resulting from operation of the JAAR rider during the test period. See that?
Yes, that's taken directly from the rule.
Okay. And what is the deferred balance as you used in your testimony and is presented in the rule?
It would be any costs that have been approved in the prior proceeding that were not recovered, or a prior proceeding that were not recovered.
Okay, so one or more prior proceedings prior to the test period, there would be costs that had not yet been recovered that would be rolled forward. Is that your understanding?
I mean, that presumably, yes, that's right. I think most of the focus is usually on the immediately prior proceeding, but yes, it could be costs from an earlier proceeding.
Okay. And so it's your opinion as the expert on behalf of SIGFR that costs can, and CUCA, that costs can continue to roll forward from prior proceedings that were unrecovered prior to the test period, correct?
Yes, within reason, yes.
Okay. If you could turn to page 8, please. So there's a Q&A at the bottom of the page, starting on line 15, where you address your view of whether the RRF was intended to recover cost, essentially we'll call it, to use Mr. Ledford's term earlier, the contested cost here that preceded the test period but remain unrecovered. Are you following the concept?
Yes.
Okay. And on line 19 in your answer, you say no. Unlike other causes of rider revenue under recovery, such as weather, economic downturns, government actions, which are outside the control of DEP, the issue at odds in this proceeding is the sole responsibility of DEP.
Yes, and I still agree with that.
And so I read that correctly?
Yes.
Okay. So, but you make a distinction there between under recovery for weather or economic downturn or other actions that would affect the revenue that the utility recovers. But would you agree with me that you are accepting that if, as a result of mild weather, let's say the utility recovers less revenue, that they should be able to go back and true that up in the future proceeding? That's what the rolling recovery factor contemplates, is these pre-test period costs that were unrecovered will continue forward and be recovered in the future.
Well, I think it depends on the situation. Certainly the items that I listed, economic downturn, unusual weather, governmental action, those are things that are outside the utility's control that could cause recovery of the JAAR rider or any other rider or any other cost to not transpire as was anticipated in the proceeding. That's not what we're talking about here. We're talking about costs that, in the company's words, were not recovered due to actions of the company itself or inactions of the company itself.
But to be clear, there's no dispute about the costs not being recovered. This is a revenue reporting issue, correct?
Which costs are we talking about now?
The
JAAR?
contested cost.
Well,
the
I mean,
22 to 24 costs that have not been recovered because of the revenue reporting issue that the company has conceded they made a error in their revenue reporting. Those contested costs have not been recovered, correct?
well, that's not a purely black and white answer. I mean, I'm not aware that during this time frame that Duke Energy Progress ever had a negative rate of return. So you always have a positive return. So by that theory, you've recovered all your costs.
Mr. McLaughlin, we went through a few moments ago what cost the General Assembly authorized DEP to request and to recover under the JAAR statute, did we not?
Yes,
And these are the categories of costs that are allowed to be recovered through this cost recovery mechanism, correct?
I guess I would phrase it a little different. They provided a means to recover costs. I don't know that I would agree that the language authorizes DEP to recover every penny of every cost. That language, recover reasonable and prudent costs, that's standard statutory language for rate making, and not just in riders, but in base rates that appears throughout the statutes. And that doesn't mean that every cost that was established or was found in a rate case to be prudent, that every penny of that gets recovered just as it was anticipated at the time of the hearing. And you don't get to go back and recoup that many years after the fact.
But Mr. McLaughlin, we've agreed that the General Assembly authorized recovery of all reasonable and prudent cost. We've agreed that the rule provides for a rolling recovery factor, which has operated in precisely this manner for a decade and allows for full dollar for dollar, no more, no less, recovery of these categories of cost that have been unrecovered to this point. Isn't that accurate?
Well, I agree that the General Assembly provided a mechanism for the opportunity to recover all reasonable and prudent costs. I don't agree that it was their intent that every penny gets recovered.
Okay, well, I'm going to move on because I think we've gotten to a point where we are just going to have to disagree on that. Will you agree with me that through your investigation, you have not identified any incremental cost that the company has incurred as a result of this revenue reporting error? These contested costs are the same costs that were incurred and identified in the 21 through 24 rider proceedings that for the residential class was actually included in the rates and already fully recovered. Would you agree with me that these are the same costs and there's no incremental cost?
Yeah, I would agree that these are costs from prior rider proceedings and prior test periods. They're not part of this case. Yes, I'll agree with that. As for the residential, I did not investigate the residential rates and riders. I'm only investigating and testifying in this case on behalf of LGS customers of SIGFR and CUCA.
You weren't curious? You didn't assess whether the residential customers had been assigned the correct rate and whether.
That was not my assignment in this case.
Okay.
I assumed the public staff would have found and reported that.
And they've not identified any incremental costs or contested the company's position that residential customers have fully been charged and paid their allocated share of these prior JAAR costs, have they?
I don't recall that they did, no.
Okay, thank you. We talked at the top of this discussion about the types of power plants that the JAAR assets are, the large nuclear and coal plants, and how those plants operate. And they are high capital costs and lower fuel costs power plants as a general matter, baseload plants. Would you agree with that?
That was your assertion. I agree with that for nuclear. I don't necessarily agree with that for coal at this point in time, but we don't need to argue about that.
Okay, thank you. And are you familiar generally with Rule R870, which is the JAAR rule?
Generally, yes.
Okay. Are you familiar with the provision? This is subsection E1, Roman numeral 6, and I can put it up on the screen here or provide you a copy if you don't have it. But that provides that.
I believe Mr. Ledford has provided me with that. Which exhibit was that? He can direct me to that. 17, thank you.
Yes.
Figure this thing out.
So I have it in front of me.
All right, great. It would be the last page of the rule. All right, so numeral 6 there, do you see that?
The little 6 at the top, yes.
Yes, sir. And so the commission in approving this rule, which the company and the public staff agreed upon, directed that for each of the first 10 years, as part of the application, the company would present the fuel cost savings to each customer class resulting from DEP's purchase of these JAAR assets. Do you see that?
That's what it says.
Okay. Are you familiar with that exhibit of the company's application?
I'm sure I looked at it at one time, but I don't have it in front of me.
Okay. Well, I will put it here, and if we need to get another copy, we can work with your counsel. But this is Exhibit L to the company's application, which has been now entered into the record of the proceeding. Do you see that there?
I see it. Give me just a second.
Yes, sir.
Okay.
All right. And so what this represents, which has not been contested by any party, is the fuel cost savings that were calculated for each of the plants and then that were totaled out and then were allocated amongst the customer class for the current test period. And it says just at the top here that this is for the current test period of this case, which is January through December of 2024. Do you see that?
I see that that's what it says. I'm not overly familiar.
Okay, but
Yes.
you did testify in your pre-file that you reviewed the company's
I
application.
did. I looked at it.
Fair enough. And just subject to check, understanding that you haven't reviewed this in great detail, but would you agree that line 18 there represents the fuel cost savings to the LGS class for the test period?
That is what it appears to be, yes.
Fair enough, subject to check. And would you agree, subject to check, that that number says $10 million roughly of fuel savings in the test period?
That's what the number is.
Okay, and so DEP made the investment in these plants and is owning and operating them to serve customers' electricity needs and is delivering in the test period $10 million of fuel savings to the LGS class, but is going to be, based on testimony of SIGFR and CUCA, not allowed to recover those under-recovered costs, which were investments made that have delivered these fuel savings.
Well, we have not contested any costs that occurred during the test year in this case,
Okay,
costs or savings.
fair enough. I'm going to talk you through one more here. So are you able to see that? That lining up a little better? I'm sorry,
When you
guys.
say
I'm trying-
that, could you be more precise as to?
Yes,
what
sir.
document
I
you're
will
referring to?
clarify it if I can just get it so you can see it. All right. So, Mr. McLaughlin, did you review the Duke Energy panel's rebuttal testimony?
Yes,
Okay. And are you familiar with the Sykes and Quick rebuttal exhibit 1 that was presented?
I remember reviewing that, yes.
Okay. Thank you. And would you accept, so, and Presiding Commissioner McKissick, this is a exhibit that was pre-filed in the case, which will be entered in the record with the company's rebuttal testimony. So unless it's your preference, I'm going to withhold from entering it as an additional exhibit twice at this time and just ask some questions about it, if that's okay.
That will be quite sufficient.
Thank you, sir. So you made the comment a moment ago that you're not contesting the fuel savings for the test period, correct?
That's right.
Okay. And are you able to see that I've highlighted the years 22, 23, and I apologize. I should probably come down here and practice a little more with this thing before I try to use it, but maybe that'll make it smaller.
Presiding Commissioner McKissick, may I approach the witness to give him a physical copy?
That will be fine, Mr. Ledver.
Okay,
You ready? Great. All right. So would you accept, subject to check, that the dockets identified on the left side of the page there, 1295, 1324, and 1345 are the the JAAR rider dockets for the preceding 3 years. So
Subject to check. I don't have those memorized, but
Okay.
I assume that you got it correct.
fair enough. Thank you. And so would you further then accept subject to check that what's represented here in terms of total fuel savings to the North Carolina jurisdiction is 430 million over a 10-year period, and that was 46 million in 2021, 68 million in 2022, and 57 million in 2023 from operation of the proportional interest in these JAAR assets. Does that look right to you?
That's what the numbers show. Is this based, well, I'm not supposed to ask you questions, but.
That's not normally the way it works. No, sir.
Well, assuming, okay, I'll answer this way. Assuming this is based on the corrected JAAR reports and not on the erroneous reports that had been filed in the past.
Your counsel will have,
subject to check.
yes, sir. Your counsel will have opportunity to ask those questions if he likes. But so then would you accept subject to check that for the years contested in this, for the years the contested cost at issue 2021, November and December, then 2022 and 2023, specific to the LGS class, the LGS portion in this far right column, this shows that the class benefited from 11.6 million of fuel savings, 15.9 million in 2022, and then 11.3 million in 2023. Is that what that shows?
That's what the numbers show.
Okay. And the company, based on their initial mitigation proposal of spreading these costs out over 2 years, was essentially breaking that $16 million of under-recovered cost into two $8 million with no interest recovery adjustments or corrections to the RF balance. Is that your understanding?
That was the offer that was in the company's original filing, yes.
And then in the rebuttal case, they took that $16 million and offered to, without interest, split it into three. So my lawyer math is that's about 5.3 something million per year. So materially less than the fuel savings that have been generated over all times that have been issued. Is that subject to check of what the information I presented shows?
It is a lesser amount, but since we're talking about the LGS class, I do want to, I think I'd be remiss if I didn't point out that this is still a significant impact on LGS customers. And I pointed that out in my testimony, and there's been very little discussion of actual impact of the company's request on customers today. It's mostly been about technicalities.
Understood. And so the company has presented mitigation proposals to try to manage that impact and is foregone interest that they otherwise would have the right to recover. You would agree with that straightforward, simple yes or no statement?
That is correct.
Thank you. That's all I have.
Does that conclude your testimony?
Yes, sir, it does.
Okay,
Thank you.
question. Okay. Redirect.
Thank you, Presiding Commissioner McKissick. Excuse me. Mr. McLawhorn, are you an attorney?
No.
So you aren't taking a position on the legal arguments about recoverability?
No, this is purely about whether the company should be held accountable for the errors it made or whether customers should be responsible for those.
You mentioned a few moments ago about the impact on customers.
Yes.
I'd like to hear a little bit more about that impact.
Well, based on the JAAR rate proposed in this proceeding, even with spreading it over 2 years, and I haven't done the math for the 3 years that they offered in their rebuttal, but we could do that. A typical SIG or CUCA customer would see about $1 million increase per month in their bill from the JAAR rider. A 50 megawatt customer, the rate is going up $2 per kW.
James, I believe it's per year.
Per year, I'm sorry. So, I mean, that's an unbudgeted amount of money that industrial customers have. While it may sound like a small number, they're facing any number of rising energy costs and other costs, and that's just one of them. And of course, if they make a mistake in calculating the price of the products they sell and they discover that 4 years after the fact, they can't go back to their customers and say, we made a mistake. We need to rebill you for all those products we sold you during that time. They have to eat it.
No further questions.
All right, let's see if there are any commissioner questions. Commissioner Vanderbar?
So, Mr. McLaurin, you've got you're an expert, got a considerable experience in this realm. Well, I heard some arguments. We all heard arguments about the fact that these were reasonable and prudent expenses. And part of me thinks that their mistakes don't really change the prudence of those expenses. But on the other hand, just letting the ratepayer cover that sort of sets up that, what is it, the moral hazard that these things are just going to continue. So there are a number of options. And I just from your experience, first of all, I'm a little surprised this has never come up. Has it ever come up in your experience, this kind of mistake, either a positive or a negative mistake after the fact with no limit on when it happened?
Not of this type to my recollection. I'm trying to think. I mean, there have been any number of rider proceedings that have a true up mechanism attached to them. I mean, the 2024 DEC fuel proceeding is one, but that was not due to an error that the company made. That was something outside the company's control. This was totally within the company's control.
Right. And I guess we should be happy that it's only happened this one time after all those years.
Well, that I can recollect.
Or that you've seen, yeah. So my only question to you with your experience is this the best way to go about it? Or should we, as I alluded to earlier, pay the reasonable and prudent expense, but then exact some sort of a management penalty so that it doesn't become a moral hazard going forward? Is that a reasonable, or is it better just to say, look, you missed your window, or is it better to just pay it out and create a moral hazard?
Well, I'd rather not opine on the management penalty. I think the thing for the commission to focus on is this is an error that occurred. The company has admitted that it was an error, but this has gone on for a number of years. And whether it is reasonable or not, after the fact, to expect customers to go back and pick up all of these costs.
So your position might be that the fact that it's so much later and then they made those mistakes, that makes those expenses not prudent.
Well, the expenses as they were paid out, I'm not contesting the prudence, but I think it's worth questioning whether the company's actions in not identifying this error until now, were those actions reasonable and prudent? Now, I'm not an attorney, but that's what goes through my mind. Mm-hmm. Should they have known this before they did or not?
Well, last question then. What do you think what do you think is an appropriate use of a management type penalty? I mean, if not this.
I feel like I'll get in trouble if I start opining on that, but certainly, the commission imposed a management penalty on the company over its management of coal ash costs. several rate cases ago. So
Okay,
I think that was an appropriate
use of that
use of that.
mechanism. Thank you.
Believe Commissioner Tucker was next in the queue.
Thank you, Commissioner McKissick, and good to see you again, Mr. McGlaughlin.
Good to see you as well, Commissioner.
Yes, sir. Thank you. In your testimony on page 9, you talked about, and I'll quote, "To put this increase in more practical terms, an LGS customer with a monthly billing demand of 50 megawatts will see a bill increase of 100,000 per month roughly, or 1.2 million annually." So that was what you were referring to earlier when you said some of the customers would experience $1 million.
Yes, and you know, just many of the CUCA and SIG customers are much larger than 50 megawatts. That was just the number I chose.
Yes, sir. In Duke's questioning and your response, they initiated that they would consider moving to a 3-year payout of the $16 million. Did you hear that earlier?
I did.
And of course, you're not going to, you said earlier, you're not going to get into the management fee discussion to speak of, penalty that is. You would rather them not charge this and take on the responsibility for their errors completely, correct?
That's correct.
Were you in the room when Ms. Toon was making her comments to us, to the commission, about the length of time or the lack of time limitations on their ability to true up or recover under collected cost?
Yes.
Do you remember her stating that it could be as much as up to 10 years?
Yes, I heard that.
Okay. If Duke were to consider, since they have a 10-year window that they could use, if they would spread this out over a 10-year period for your large customers to pay this off, and they could recover that, would that be a consideration that you think that they would consider? Because I agree, business needs certainty, and to come in with a heat-sinking missile on an annual budget, and then again, they can't go back and add that cost in on the products they've already sold, pretty much because they're not a monopoly. And Duke has the opportunity, I believe it perhaps may have the legal backing to be able to do so all the way up to 10 years. And certainly if they build a nuclear plant, they're going to be truing up more than 10 years while it's going to be built. Is that the statement of a 10-year spread to pay this 16 million back? Is that something that is more fair to your customer base, or would you think it would be?
Well, it would definitely lessen the impact on them. I don't think Mr. Collins or I are changing our testimony as it stands now, but it would certainly lessen the impact.
And they would have the opportunity over that, the first year would be a major impact still, but over the 9 years, using the comparison of the window that Duke said that they have the ability to go back and collect under collections, they would have certainty over those 9 years as to what they would have to pay, which they could build that in the cost of their products rather than a condensed window of 3 years.
It would certainly lessen the impact. And maybe, I would like, since you brought up Ms. Toon's comments, I may have not understood her correctly, but I didn't understand her to say that 10 years was a good point to cut it off. I did not hear a cutoff point.
Perhaps I did not either, but I just remember. But I just remember in her discussions, she mentioned 10 years as she was, giving an oral argument. So I just picked up on that part of it as an opportunity for consideration for both the parties here. But I'm not in the settlement business. I'm just thinking in business, you know, if there's no choice and Duke has a legal backing, if they would, you know, consider that, and you guys would consider that, it may be a way of skinning the cat by, you know, Duke being able to recover those monies over a longer period of time. And that's all I'm asking, if that would be, given the facts and they have the legal backing and they're going to collect it within the 3-year period, if they would stretch it out further somewhat as a management penalty, as Commissioner Vandervaart alluded to, it would help Duke get their monies back, and the SIG customers, the large customers, your large load customers would have an opportunity to have some certainty as they run their business. That's all I'm asking you to.
Well, and again, I'm not a lawyer, but if the commission.
Neither am I,
If the
sir.
commission decides that they legally must give Duke, allow Duke to recover this money, and there's no way around that, then certainly spreading it out as long as possible would be less painful to our customers.
No further questions, Commissioner Kissett.
All right, I believe Commissioner Comerite has a question or two.
Good afternoon, Mr. McLaughlin.
Good afternoon.
Okay. I just have a couple of questions. You testified about the approximately that the average cost for the LGS and MGS customers would be, if this $16 million under recovery was approved by the commission, that they would see about a $1 million increase per year over the 3-year period. Is that correct?
That was one example for a 50 megawatt customer. Now, if it was a 500 megawatt customer, it would be 10 times that amount.
Right. And so did you also do a calculation for the same 50 megawatt LGS or MGS customer about the savings that the benefits or the savings that they incurred over the 4-year period because those costs were not charged to them? Did you do a similar analysis?
Well, it would be a similar amount. But they paid what Duke billed them, and that's what they expected to pay. Those were the rates approved by the commission, and we've not asserted that Duke did charged other than the rates approved by this commission. So they paid what they were asked to pay.
Right. Yeah, I agree. They paid what they were asked to pay, but do you agree that they did receive some benefit because they did not have to pay all of the costs that had been incurred for their benefit? So that they received some benefit or savings because they were not charged the amount of the $16 million under recovery. So they did receive some benefit or savings.
Their bill was lower than it would have been. Of course, costs were increasing during that entire time from other areas.
Right. And there's been some talk about some sort of a possible management penalty. And I think there was some discussion about that several years ago in the coal ash proceeding, the rate case coal ash proceeding, that a management penalty might have been assessed against Duke. Are there differences between this accounting error and the coal ash proceeding about the errors or mistakes that had been made? You don't necessarily need to go into detail, but just as a general question, there are some significant differences between this accounting error and the coal ash situation. Would you agree with that?
Well, I would rather not go. That was a management penalty, was not something that I discussed with my client. And before I go off opining on that, I would need to talk with my counsel and my client about that. So I'm not comfortable.
Okay.
Respectfully.
Right. And so I'm not advocating or disputing a management penalty. I was just saying would you agree that there's some significant differences between this accounting mistake and the coal ash situation? That's my simple question.
It's certainly not the same.
Right.
Yes.
Okay.
But again, the error here is the fault of the company in this case. They did not report to the commission correctly. And they made their filing, their application based on, I'm not saying they intentionally did it, but they were the only party that could have made the correct filing. I mean, the commission, public staff, other interveners, we have to rely on some level of information from the company, from their books. We can't know whether every number in their books and reports are 100% accurate other than what they report to us.
Thank you.
I guess I have one or two questions, Mr. McLawhorn. And I'm looking at your testimony on page 7. I'll let you turn to page 7. And at the, I guess there's on line 14, there's a question which is posed, which is why was the error not found prior to 2025? And what steps has DEP taken to ensure it does not happen again? And then beginning on line 17, it reads, according to DEP, its rate design team provides various reports to the rates team for its use, one of which is the JAAR revenue report. The rates team relies on the rate design team to identify and validate reports it uses. Prior to the discovery in 2025, reports were reviewed only when errors were found or changes to reports were requested. The company has now implemented a semi-annual review and validation process, which establishes a formal requirement to regularly review reports such as the JAAR revenue report to ensure accuracy. It is unclear why DEP did not have a formal review process in place prior to February 2025, given the reliance of these reports for regulatory filings and the establishment of new rates. I guess I have two questions of you. Do you believe the process which has been established at this time is a reasonable process in light of what you have seen and observed in this particular JAAR proceeding?
I'm presiding Commissioner McKissick. That is an answer I can't give you. I mean, we can take Duke at their word that they have made the corrections, but we won't know until the future. In a data request, we asked Duke to provide internal reports and documentation regarding the errors that were at issue here, and they declined to respond to that data request. So I don't know all of the background information or what was discussed and how it was rectified, just that they're saying we've implemented this process and we believe this will take care of it. That's all I know.
And I guess my follow-up is this. I gather there was an investigation conducted because of discrepancies that were determined back in 2023. And I guess what I'm interested in knowing in terms of your thoughts is whether, as a result of what occurred in 2023, adequate measures were taken to mitigate the overprojection of revenues from the JAAR rider and to correct the discrepancy that was determined at that time, and more importantly, to follow up on those measures to make certain that there were not further discrepancies that could have been disclosed.
Because the reporting error continued to occur after that time, it would appear that all of the existing errors then were not corrected. But of course, it could have been new errors that occurred post 2023. So I don't know.
Thank you. I don't have any further questions. Are there any questions on commissioner questions?
I just have two, if I may.
Sure.
So just one clarifying question to start. You said in your response to Commissioner McKissick that the company declined to answer data requests. Would it be more accurate to say they asserted the attorney-client privilege over analysis that was prepared under the advice of counsel? And so they didn't decline to respond, I think was the term that you used.
Well, we asked for any reports or memos or any information related to this issue, and were not given anything in response. It was all part of the objection to the data.
So they responded to through an objection that said that that analysis is privileged. Not to
That's
get
what-
overly lawyerly about it, but
We did not get any information on the issue at hand.
understood. Thank you. And then one other question. So you received a number of questions from commissioners, I think Commissioner Tucker, Commissioner Vandervaart, as well as Commissioner Kimmerite about the concept of a penalty, which your clients have not argued for in this proceeding. Is that accurate?
That's right.
And is it your understanding from reviewing the JAAR rule as well as the company's testimony that they have a right to recover interest on under-recovered balances and are foregoing that recovery of interest on these under-recovered costs, which understanding you contest, but would you agree with that?
Can you show me where in the rule it says that?
Yes, sir.
with
Not a
interest?
problem. So just for orienting you, and I apologize, this is subsection I here, which is the rolling recovery factor. And then if you go down to 3 below that, it says the balance in the deferral account net of tax shall accrue a monthly return at the net of tax rate of return, gross up for taxes as approved, so on and so forth. Do you see that?
I'm sorry, which subsection in the rule are you?
Yes, sir. I'm on page 3 of the rule. The same page as the rolling recovery factor section, and then in the middle of the page is subsection 3. And it's on the screen there, if that would be helpful.
That's what subsection 3 says. Of course, that's not pertaining to going back and rebilling customers for rates that were calculated incorrectly to begin with.
Understood. Well, I would direct you, and I think you said you reviewed the company's application and testimony. This is Mr. Sykes' direct testimony that's now under the record, page 17. And I can provide a copy if you need it, but on line 13 through 14, it's his calculation that making the business decision not to include a return component calculated at the time to be approximately $1 million that the company was foregoing as part of the mitigation proposal to allow the 2-year payback of these costs. Do you see that?
Yes, I see that's what he said.
And so if the company had a right to recover interest on these under-recovered costs and foregoes that, in effect, they are accepting perhaps not a penalty, but some recognition that the error occurred and that foregoing this $1 million of interest is a reasonable resolution as part of a mitigation proposal. Would you agree with that?
I agree that that's Mr. Sykes' position. I'm not agreeing that with his assertion.
Understood. Thank you, Mr. McLaughlin. I don't have any further questions.
Okay. Since there are no further,
Presiding
oh, excuse me.
Commissioner
Yes,
McKissick,
go ahead.
if I may, thank you. Mr. McLaughlin, I'd like to turn your attention to Exhibit JSM 3.
Okay, I'm there.
Just a few moments ago, counsel for the company discussed with you and asked you whether or not the company actually responded or if the company, through counsel, objected to the requests. I'd like you to read the last sentence of subsection F, which is on the second page of the exhibit. Please read the sentence in its entirety.
I will be happy to. Would it be better to read the question first? Would
Sure,
that be helpful?
absolutely.
So the question first, or the request from subsection F was, please provide copies of all memos, reports, or similar documents that the company has prepared or had prepared on its behalf related to the JAA rider revenue reporting discrepancy. And the response from the company was, the company through counsel objects to these requests to the extent they seek information protected from disclosure by the attorney-client privilege, the attorney work product doctrine, or any other applicable privilege, protection, or immunity subject to and without waiving objection. The company answers as follows. The company has conducted a reasonable search and the company has no information in response to this question at this time. However, the company reserves the right to supplement this response as appropriate.
Are you aware of any response provided with a privilege log?
I am not.
I have just one more follow-up question. Commissioner Tucker asked your thoughts on spreading out the recovery over a 10-year period. Is it your opinion that it would be fair or unfair to recover the $16 million disputed costs?
It's my testimony that it would be unfair. My response to Commissioner Tucker was that if the commission in its determination finds that it is legally bound to allow the recovery, that would be less impactful to LGS customers than the company's proposal.
At this time, we would move admission.
Yeah,
Oh, nothing further.
nothing further. All right. Thank you. Are there any motions?
At this time, we would move it for admission of what was pre-marked as BCC1 and attached to the pre-filed direct testimony of witness Collins, and what was pre-marked as JSM 1 through 6, which was attached to the pre-filed direct testimony of witness McLawhorn.
Without objection, your motion's allowed.
Thank you.
And let us go ahead and identify it as correctly as we can as an exhibit, so it gets this duly noted. Go right ahead.
Commissioner McKissick, are you asking for the exhibit that was referenced in the redirect? The questions on commission questions?
That would be correct.
That was exhibit JSM-3 that was attached to witness McLaughlin's direct testimony.
Okay.
Have it be marked for information purposes as CPRE, CUCA, Collins, McLaughlin, redirect exhibit number 1.
All right, I think we've got everything covered now. The witnesses may be excused at this time.
Thank you. Thank you.
Ms. Toon, there was a question about whether you had appropriately moved into the record the Sykes testimony and exhibits. Do you want to go ahead and clarify that just for purposes of the record?
Yes, please. Presiding Commissioner, I move that Mr. Sykes' direct and revised supplemental exhibits be accepted into the record at this time.
Without objection, your motion's allowed.
Thank you.
It looks like next on the queue are Boswell, Cofield, and Zhang. If you need a short break, why don't we take a 5-minute break? But let's try to keep it exactly 5 in the interest of time. Be 3:08. Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you.
Right. Everybody remember to keep your microphones close to your mouth, please. Mr. Whitfield, would you, including me. Mr. Cofield, would you please state your name, business address, and current position for the record?
Sure. My name is Darius Cofield. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst with the accounting division of the public staff.
And Ms. Song, will you also state your name, business address, and position for the record?
Yes, my name is Fan Zhang. My business address is 430 North Salisbury Street, North Carolina, Raleigh, North Carolina. And my current position is I'm the manager for the electric section of the public staff accounting division.
All right. Ms. Boswell, will you also please state your name, business address, and position for the record?
Michelle Boswell. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm the Director of Accounting for the Public Staff.
Now, Mr. Cofield, on September 2nd, 2025, did you and witnesses Zong and Boswell prepare and cause to be pre-filed joint direct testimony in this docket consisting of 16 pages and 3 appendices labeled A, B, and C?
Yes.
All right. Do you or your panelists have any corrections to your pre-filed direct testimony?
No, we don't.
And if you were asked the same questions today, would your answers be the same?
Yes, they would.
And finally, did you and witnesses Zong and Boswell prepare and cause to be filed on September 26th a summary of your joint direct testimony?
Yes, we did.
Presiding Commissioner McKissick, at this time, I would move that the pre-filed joint direct testimony of witnesses Cofield, Zong, and Boswell with appendices A, B, and C, along with the pre-filed summary of the direct testimony of public staff witnesses Cofield, Zong, and Boswell, be entered into the record as if given orally from the stand.
All right. Without objection, your motion is allowed.
Thank you, sir. And so now the accounting panel is available for cross-examination and for commission questions.
Very good.
Thank you. Good afternoon, Brett Breichwart on behalf of Duke Energy Progress.
Good afternoon.
And so it seems that the panel all filed testimony together. And Mr. Cofield, are you the lead witness, or how should I approach asking questions to the panel?
You can feel free to ask any questions, and we'll step up if we need.
All right. Very good. I'm going to start with somewhere I was finishing with Mr. McLaughlin, which is the Rule RH70. Are you all familiar with Rule RH70?
Yes, we are.
Okay, thank you. And so familiar with this provision providing for a rolling recovery factor. This is on page 3 of the rule. And then we were just speaking briefly about this subsection 3 here, which provides for a return on the deferred balance. Does that, are you familiar with that provision of the rule?
Yes.
And my understanding from reviewing the company's testimony is they view that provision as providing for a rate of return on the rolling recovery factor balance. Is that accurate?
Yes.
Okay, thank you. And are you aware, and I can put it on the screen here, of Mr. Sykes's direct testimony where the company has agreed to effectively forego that return as part of their initial testimony, which they estimated at the time to be approximately $1 million as a result of admitting the error from the past under recovery calculation based on the revenue reporting error. Are you familiar with that testimony?
Yes, we do.
Okay, and did you investigate, as part of your investigation, did you review this statement and assess whether it's accurate that the math works out essentially to a million that the company is agreeing to forego as a result of this revenue reporting error?
So let me say it this way. So we did review the application and the schedule, but because the company put that lump sum at the end, so in other words, on the line by line on each month, there's no like the reflection of it. So I would say that number can be subject to check.
Okay, subject to check. And you don't contest that the company would otherwise have the right to recover this return on their deferred balance?
Under the commission rule says, or the statute said they allowed for the financing costs as well as the deferred balance to earn a return. Yes, they are.
Okay.
They allow for that.
Thank you very much. All right, I'd like to move on to another topic based on your investigation. So the scope of the cost that are at issue, which Mr. Ledford called the contested costs earlier, that we can continue with that. There are no additional costs that the company is proposing, or I guess to use the term incremental costs. These are costs that were reviewed in the 22 for the November, December 2021 months, and then the 23 for the 22 test year, and then the 24 for the 23 test year JAAR rider proceedings. And so these costs have previously been reviewed in those dockets. And so there's no additional costs that haven't previously been presented to the commission and approved for recovery. That this is a revenue side of the equation. This is not a cost side of the equation issue, correct?
Yes, the public staff does not contest the cost side. However, as you said, the main issue here is a reported revenue issue.
Okay.
So that's play into the revenue requirement. In other words, the company present your prudency cost and the public staff agreed to, that's where the dollar amount to be used for setting the rate.
Okay, but the costs that the company are seeking the commission to authorize to be included in the RRF through this correction, those are the same costs that were under recovered previously. And so the company's not seeking to recover any new costs, correct?
There are no new costs included in the filing in this proceeding. However, this is not a cost issue. This is a revenue issue. So what the company is seeking here, as the public's staff's understanding, is that you are seeking revenues for which you did not include previously in the calculation of the rates in previous JAAR riders.
Understood. And the costs that are at issue I'm trying to establish are the same costs that were previously approved by the commission for recovery and determined to be reasonable and prudent. Correct.
The cost included in those JAAR recoveries are still deemed to be prudently incurred and properly accounted for. The 16 million that the company is seeking here is the revenue that was not reported correctly in those years.
Understood. And we can do, let's put the revenue reporting error to the side because I think we have a disagreement there and focus on the cost. To confirm, the residential class has already fully paid these under recovered costs that were allocated to the residential class. I had a question for Mr. McLaughlin and he is representing the industrial customers here and so he didn't address it. But can you confirm today that in the 24 JAAR rider and the 23 JAAR rider and the 22 JAAR rider, they were appropriately calculated for those for the residential class, and those costs have now been recovered from the residential class? Is that correct?
The company has not indicated to us that they had a reporting error within those. We did not have the time in this proceeding to look into whether or not the company accurately reported those revenues for 21, 22, 23, and therefore we did not. So based off the company's assumption that they accurately reported the revenues at that time, then yes, those costs have been recovered through those rates.
Okay, and you would agree with me that the rates for residential customers on a kilowatt hour basis and the rates for the industrial customers are calculated on a kilowatt basis or a demand basis. So there's a distinction there that related to how this revenue reporting error occurred.
They are billed on different basis. Why that there was a revenue reporting error in the customer systems, I would leave to the company speak to. what was
but-
the causation of that.
But through your investigation, you did not identify any basis to suggest that residential customers have already paid these same costs that the company's now seeking to recover from the LGS and MGS classes that are billed on a demand basis, correct?
Again, the public staff did not review the revenue reporting. And if there was an issue for residential in 21, 22, or 23, due to the time limitations in this proceeding and the company not bringing this to the public staff's attention until they filed on June 10th. But subject to the company's reporting that they have accurately reflected those, we are taking those subject to check. Yes.
Okay, so yes.
Subject to check. Yes.
All right, thank you. And so focusing on what's recoverable through the RRF, the rolling recovery factor. We talked about this provision of the rule earlier, but I'll put it back on the screen just for reference. And so is it the public staff's understanding and testimony that the rolling recovery factor allows both test period costs and revenues to be considered, but they are added to a pre-existing balance that cumulatively continues over time? Is that accurate?
Yes, that's the cumulative balance from the last year. So in other words, as I believe our council already addressed that. So because the rule allows deferral accounting treatment for the JAAR, so it's just rolling from the ending balance to the next period as a beginning balance. So in other words, yes. And in the matter of fact, that I can point you to in the commission order, the last, in the sub 1345 commission order, the ordering paragraph number 1 is the order issued in November 13, 2024. In fact, they specifically saying the company shall be allowed to recover that rolling cumulative balance as a credit of $547,000. So that's what should be the cumulative balance as a starting point for this test year.
Okay, and this cumulative balance includes both the over recovery or under recovery prior to the test period, as well as the experience during the test period, correct?
So if you are speaking the ending balance, the ending RRF in this proceeding, yes, is a 2 piece. 1 piece is from the prior period cumulative balance, and then add the difference during this test year.
Okay, and would you agree with me that under the rule and under the statute, the way the rolling recovery factor is designed, it allows for any under recovery to be included in future rates based on cost prior to the test period?
I should not say it's any. So remember, again, it's like, yes, the balance is carried forward, but it's not, should not interpret it as any adjustment to it. So it had to be within a reasonable time, meaning in this situation, it will be your prior period cumulative balance, and then add to the current test year differences.
Okay, so maybe just to make sure I understood your response there. Costs incurred prior to the test period, if they're outstanding, would be recoverable and they would be added to the test period. And that would be the computation of the rolling recovery factor. So key point that I'm trying to establish is looking back in time prior to the test period costs are still recoverable. There's no prohibition on recovering those costs under the rule or under the statute, correct?
But remember, the cost, we does not dispute the cost, the prudence cost. We are already, as I said before, we already setting the rate to recover those costs is already set. And then only here, the issue is the reporting revenue. You are reporting it, or you are overstating the revenue, so it should not mix with the cost per se.
Okay, let's try it a different way. So, Presiding Commissioner McKissick, if I could, I'd like to enter in the record what's been pre-marked as DEP potential cross exhibit number 3.
Okay.
So that should be in the binder. It's the black binder in front of Mr. Cofield there.
Okay.
And so
We're looking at DEP cross exhibit number 3. So that'll be Duke Public Staff Boswell, Cofield Zing. It's your DEP cross 3.
yes, sir. DEP potential cross exhibit number 3, which is
Yeah. You're doing
direct testimony of Mr. Sykes from the sub 1324 proceeding.
He's right. There's only 2 in this binder. We do not have a third one in the binder.
Is the cross exhibits or the redirect exhibits that you have there?
Hold on, let's see. Yeah, hold on.
Well, I can, and I'll try to be quick. I'm not going to spend much time with this, and I can try to use the screen here if that helps.
Yep, it's here. It is
Okay.
here.
Very good. So if I could mark this as,
Give us 1 second. We'll make sure everybody has it before them. You do have it there? Yep, number 3. These potential cross exhibits go from 1 to 8.
that's correct. Do you see sub 1324? That's from a prior proceeding. All right, very good. If we could
Everybody
mark
has it
this as
before them. Yes.
DEP Public Staff Accounting Panel Cross Exhibit 1. That works for you, Mr.
Yes, that
or
works.
Presiding Commissioner. Thank you.
Absolutely.
So to the panel, are you familiar with this testimony?
Yes.
Okay. And this is from the 2023 JAAR rider proceeding, effectively 2 years ago, correct?
That's
And so the test period for the 2023 rider proceeding would have been the calendar year 2022, correct?
Yes.
And so some of the under recovered costs that are contested here are that we're seeking to now recover through the RRF correction that Duke has proposed were presented in this testimony. Is that correct?
Again, it is the public staff's understanding that you are seeking to recover the under-reported revenue associated with those 3 years. This is not a cost issue. This is a revenue reporting requirement issue. And the company did not appropriately and accurately reflect its revenues. And therefore, the company is coming in seeking now the collection of those revenues for which it did not accurately report in 2021, 2022, and 2023.
Yeah, and I'm not an accountant, but I'm going to try to just briefly confirm my understanding is that there are costs that have gone unrecovered because the rate was not properly calculated as a result of the error. And so the company is requesting the commission to update the RRF to correct that. And so on a go-forward basis, those costs will be recovered because of the revenue reporting error correction. So maybe this is semantics and we'll get to the same place, but there are unrecovered costs the company is asking the commission to include in the RRF. You agree with that?
There are unrecovered revenues from which the company inappropriately and inaccurately reflected within the confines of its 2021, 2022, and 2023 proceeding.
Okay, well, where in the statute or the rule does it provide for recover of prudently incurred revenues? It speaks to prudently incurred costs, correct?
It speaks to prudently incurred costs properly accounted for, and in setting rates, it is an offset to the appropriately incurred revenues and properly accounted for and reported revenues.
Okay.
I think the question's been asked and answered.
Yes, sir. I'll move on. Thank you. All right. So moving on with this exhibit, this is page 17 of the testimony, whoever's reviewing it.
Yeah.
Okay. And so to establish what would be included in the RRF on page 17, lines 11 and 12, the company presented that as of the test year ended December 31, 2022, the company has a joint RRF balance of 23.3 million. Do you see that? Sorry, this is page 18. I think I said 17. I apologize. No problem.
17, that's why I want to confirm.
Yes, sir.
Page 18, yeah, duly noted.
Yeah,
Line 11 and 12.
11, 12, page 18.
Yeah. And so those costs were based and informed by costs incurred prior to the test period in that 23 rider proceeding, correct?
So again, remember 2023 rider proceeding, the test year is 2022, the
Right.
calendar year 2022. So back to the rule in RA-70B16, it says the cumulative balance from the prior period plus the difference in the experience during the test year. So here is you are talking about is the test year. So you have any revision in the test year, we are accepting it as long as we review it and find it's reasonable. We did the same thing for this current proceeding, which we include that $409,000 during the test year is included, is allowed the company to recover that. We are only talking about things outside the test year.
Right. Okay. And sorry, let's keep moving to the next sentence. So the next sentence says that this 23.3 million is largely comprised of the under collection of the test year ended December 31, 2021, and then related interest due from customers through the end of 2022. So you've just correctly established the test year in this proceeding was 2022.
Yeah.
But this reflected the cumulative under recovery from prior to the test year, correct?
So remember, read, if you may, read the first sentence on line 11. As of the test year ended December 2022, like meaning you already include the whole year of the test year as well as your prior period balance for the 2021.
Correct.
So you already have combination inside here.
Understood.
So two-piece information here.
Two pieces of information, but part of this is cost incurred prior to the test period, which the company sought for recovery as part of that cumulative rolling recovery factor balance, correct?
Again, we did not dispute the prudency on the cost piece.
Okay.
Yeah.
So the public staff agrees that the company and the commission can go back prior to the test period and allow for recovery of cost based on the rolling recovery factor balance.
Okay, again, here I think there's a misunderstanding here. The cumulative beginning balance for the 2022 is what is in the prior one as well as rolling into this one. There's nobody adjust that amount. The only change the company say that there's a reporting issue related to the customer connect for this filing is only changed for the test year. That's how it lay out on here as well as on the rebuttal of witness size current rebuttal, the joint rebuttal, because that's linked to the 2023 filing. The 2023 filing, I double check before come to the stand. There's no change on the ending balance as of December 2021, which is roll into the beginning, like January 2022 balance.
Yeah, I'm gonna try this just one last time, and it must be on my end that we're not connecting, but this 2023 proceeding, which had a 2022 test year, included costs being recovered that preceded the 2022 test year that were part of the rolling recovery factor in 2021 and earlier, correct?
Yes, I
Okay,
mean,
thank you. Thank you.
because the timing of the rate period versus the test year, you always have, if you truly trying to chase it down, that's like chasing the rabbit hole type thing. But the concept is like, what is the review period? What it like current review period is the test year of 2024, right? Then after you finish and then you roll to the next one, you can't just always go back to the beginning of the job. Like, meaning you open the whole case for recovery anytime
Okay.
the company deemed to appropriate.
Thank you. Could you turn to page 14 of your testimony, please? And so one of the issues here that seems to be in controversy is whether the company can recover based on these under-recovered costs. And the question was asked earlier, and I don't recall which commissioner asked it during the oral argument, but if the roles were reversed and the company had overcharged customers, whether those costs should be flowed back even if they preceded the test period in the case. Do you recall that?
Yes.
Okay, and subject to check, or if you're on page 14, line 21, 22, it's the public staff's position that going back in time, if the company made a error to the customer's disadvantage, that those costs should be refunded to customers, regardless of when the error occurred or how far extended back. Is that accurate?
It is based off the fact that if the company is in full control of the information and the ratepayers are not and do not have any of the ability for which to audit and or check the company's information, it is one-sided to allow the company to not refund those dollars back to the ratepayers.
Okay, but as a matter of the statute and the rule which provide for recovery or refunding, you're not taking the position that it shouldn't work the same both ways. You're just disputing that it's inequitable here because the company made the revenue reporting error. Is that correct?
We are stating that the company had full control over its amounts, over its reporting, over verifying the amounts that it was presenting to this commission, over the amounts that was utilized to calculate the rates for which the commission set and approved. And therefore, the onus of this error, which occurred beginning in 2021, according to the company, and lasted at least until 2025, according to the company, is the company's responsibility.
Okay, you artfully didn't answer my question of whether the commission has the authority under the statute and under the rule to treat the error the same going both directions.
I am not an attorney, and I believe all of that discussion was handled by the briefs earlier today.
Okay, so you don't take a position then as the lead accountant for the public staff.
I am not an attorney, and therefore I do not take a position on statutes for which were discussed earlier today.
Okay. All right. Presiding Commissioner, I've got one more brief exhibit to present. Are you familiar with the SEPS rider in this proceeding?
Yes.
Okay. And are you aware that in the SEPS rider, the company did in fact identify an over recovery that had occurred that was improperly accounted for based on the same revenue reporting error?
I am aware that the company filed supplemental testimony 7 days before, subject to check, before we filed our testimony, signifying that they had an error for which we have not been able to audit, review, or testify upon. Therefore, we reached agreement with the company that that item would be held open for review. Yes.
Okay. And you would agree that in the context of SEPS, the company has agreed to flow back the over recovered amount dating back to November 2021 with interest, and the public staff has agreed, sounds like subject to further review, to that being a reasonable resolution. Is that accurate?
That is.
Okay, thank you. I don't have any further questions.
All right. see. Is there any redirect at this time? And I think you only had one exhibit you introduced.
That's correct.
Okay.
Presiding Commissioner, sorry, Brett.
Please.
No,
I'll wait till the end to move it.
Wait to the end. Okay.
Whatever's your
That's
preference.
fine. We can wait to the end. As long as we get it all covered.
Yes, sir.
Okay. Go right ahead.
thank you, Presiding Commissioner. I do have a few redirect questions for the Public Staff Accounting panel, and I'm going to mark a redirect exhibit, which may take them just a second to find. It's the exhibit to Mr. Sykes' supplemental testimony that we were discussing during his testimony. So unfortunately, I don't think the pages are numbered, but do you have his supplemental testimony? And then can you find, please, exhibit A1TU, which is about halfway through the exhibits to his testimony.
I'm sorry, the supplemental testimony in this case of Ryan Sykes?
Yes, and Brett, if you have a clean copy to.
I likely do. I just curious, I didn't think I asked questions about his supplemental testimony or introduced in my examination any of the specific issues you're trying to raise on redirect, which is limited to the scope of my cross normally before the commission.
That's true. You asked a number of questions of these witnesses about whether it was appropriate to get a rate of return on the RRF balance. And so I wanted the witnesses to take a look at what the RRF balance was at the relevant point in time.
So you're simply wanting them to look back at that particular testimony, notwithstanding the fact that it was not raised.
Yes, Presiding Commissioner, Mr. Breitbart asked a number of questions about whether it was appropriate, whether or that the company's position is that it is entitled to a full rate of return on the underreported revenues going back several years. And he cited in support of that, he cited Rule R70B D3, and I wanted to have the witnesses have the actual RRF in front of them as they address that contention by the company.
Will overrule any objection.
Understood. Thank you.
Thank
And I've
you.
provided a copy to the witnesses so we can.
Thank you
Rest.
very much. I
Yes, ma'am.
appreciate that. All right, thank you. So if you could refresh yourself if you need to with the rule that Mr. Breitbart was pointing you to, which is R870B sub 3, I think. Yes, where it says the balance of the deferral account net of tax shall accrue a monthly return at the net of tax rate of return grossed up for income taxes as approved in the Electric Public Utilities most recent general rate proceeding. Okay. Now, I just have really a quick question to ask you here about this exhibit, which is where does the $8.1 million that Duke is seeking to recover in this proceeding, where does that fall in the RRF if you looking at this exhibit?
It is line 114. They just plug the number under the column.
Okay,
B.
thank you. And so what's the RRF balance that under the rule is entitled to earn a return?
Are you referring the beginning balance or the ending?
Well, Mr. Breitbart asked you about what on the RRF under this rule, what earns a return. So I'm asking you, what earns a return?
In this, yeah, in this one, the ending balance, actually each month, the beginning balance for the default, you can see the column. I'm sorry, so small. Column G is the return, is based on the calculation of the beginning default balance on column D.
Okay, and so the adjustment that Duke is seeking in this proceeding is not in the RRF.
Is they just plug it after they calculate the return piece and then they put it at the end.
Okay, so what is the opinion or the position of the Public Staff Accounting Panel as to whether the $8 million that Duke is seeking to adjust the RRF is entitled to a full return as if it had been collected, as if it had been reported all along?
The public staff believes that an error that was in full control of the company to have accurately reported correctly since 2021 should not earn a return.
Okay. And I really just have one more question to ask you all. It may be a question that has numerous subparts, but I think there may be some confusion and maybe even some frustration about the public staff's position as to whether the JAAR rider allows an electric public utility such as Duke to recover for costs incurred prior to the test period. So as succinctly as you can you please state what the public staff's position is on that?
The public staff does not dispute the prudently incurred costs to be recovered. However, here the issue is a reporting revenue issue. They overstated their revenue.
Okay. Is there anything to add to that? Okay, so let me ask about allowable, what the public staff's position is about allowable adjustments to the RRF. What in your view and your understanding is an allowable adjustment to be made in each year to that RRF?
Just as earlier during the oral argument, our counsel stated it will be within the operation of the rider.
Okay, and with respect to what counts as operation of the rider, is recovery of past costs to the extent they're reflected in the RRF, is that considered by operation of the rider?
If it is part of the cumulative default balance as the end of the test year and roll it to the next, then it will be considered as operation of the rider. However, here is the company have full control of their reporting revenue, and they, again, we have emphasized several times, they are presented inaccurate revenue, correct, reported to the commission as well as to all the other parties, including public staff or interveners.
All right, and I think just one more sub question, if you will. So do you have rule R870 in front of you, and you can look at
yes,
sub B, sub 1, sub 6?
Yes.
Okay. It states that the public utility will maintain an over or under recovery balance and add to the balance the difference between the reasonable and prudent financing and non-fuel operating costs incurred by the public utility during the test period and the revenues to recover these costs during the test period that were actually realized. Does this rule allow a public utility to add to the over or under recovery balance for events that took place outside of the test year?
Again, so here has two components. So for the test year is only the actual experience during the test year. For the prior period, like the the beginning, the cumulative balance is determined by the last JAAR rider, which is also based on the test year, actual experience.
Okay, I don't think that was, let me.
Presiding Commissioner, this has gone fairly far afield of the questions that I asked in terms of the operation of the rider, and I don't think council's getting the answer she's looking for, but this is well beyond the scope of what I asked in terms of operation of the rider. So this is supposed to be a redirect on questions that I raised in my cross-examination.
So I take that to be an objection to the line of inquiry being beyond the scope of your examination.
That was much more artfully put, yes.
All right. Can you wind it up very quickly?
I think so, Presiding Commissioner. Thank you. I think I have one more question. Let me just ask it this way, or let me just ask this one more question, and I think that'll be clear. Does this rule allow the utility to make adjustments to the RRF based on events that took place outside of the test year?
Based off the advice from our legal counsel during this case, no, it does not.
Okay, fair enough. Thank you. No more questions.
All right. Let's see, as it presently stands, there may be some redirect, I would presume. Okay. Very good. And I'm not seeing any other time reserved here by anyone, so we will now move on to commissioner questions. I know I have a few here, but I'll see if other commissioners have questions first. All right, Commissioner Cameron.
Good afternoon. I have just one question. This relates to following up from Mr. McLaughlin's testimony about the bill impact of approximately, I believe he said about $1 million for an LGS or MGS 50 megawatt customer over a 2-year period, $1 million a year. Do you recall, I assume you were in the room for that testimony, is that right?
Yes.
Okay. And did I correctly state his testimony about a bill impact of about $1 million over a 2-year period for a 50 megawatt customer, to your recollection?
Yes, to my recollection.
And so I just want to have a better understanding of that bill impact. So do you know what for that 50 megawatt LGS or MGS customer that would have a $1 million impact per year for 2 years, what that percentage of their bill would be? Have you done that analysis?
We have not.
But we would be happy to provide that as a late filed exhibit if the company wishes, or if the commission wishes for it.
Okay. I would request that as a late filed exhibit. Thank you.
Are there any other questions, other commissioners? Yes, go ahead, Commissioner Tucker.
I guess this is for certainly the public staff, the county staff. All day, we've heard the word error. All day, we have heard filings outside the test period. We've heard from Duke and the opposing parties. And then earlier, I believe it was you, Ms. Boswell, that said you had to make the assumption that the company had made the corrections necessary, whether it be internal or the information that they have given to you and to others. How is this commission supposed to view that? Or do you have, from your accounting experience, a good feeling that these numbers are correct?
I will state that the public staff and the company are working together for an audit of their Customer Connect system outside of these proceedings here to get a better handle on what would be what could be possible errors still existing and whether or not they have fully corrected everything.
So whether it be over or under the $16 million, in your opinion, could change after the audit?
Potentially, yes.
So the customers in question about the exorbitant increases in their bills, it could be less or it could be more. Is that what I'm hearing you say?
Potentially, yes, if there are more errors found resulting from the reporting issues coming from their systems and reporting the revenues therein, yes. We, I believe, sampled approximately 40, which in the grand scheme of things is fairly small. Out of those 40, we didn't find anything, but since this appears to be a systemic issue across all riders, whether or not everything has been caught and whether or not they have all of the appropriate procedures in place for this not to continue in the future, we haven't validated yet.
And the issue is they did not bill correct. They underestimated their revenues, not their costs.
They overestimated their revenues.
Excuse me, overestimated their revenues.
They over-reported their actual revenue, so it's not an estimate. They had in their financials correct revenues, theoretically. From this report that they utilized, it did not accurately reflect the revenues which have been reported in their financial statements. And as part of their internal controls, no one ever actually compared one to the other. And so therefore they have over-reported for the MGS and LGS categories. And subject to correction by my counterparts, LGS is due to owe money here and MGS is due refunds here.
Okay. Well, no further questions, Commissioner McKissick. Thank you.
Okay. All right, I have a few questions here, and some of these you have answered in part already. However, these are questions which our outstanding staff of the commission always wants to make sure we get officially answered as part of the record. And I'm going to address these to the panel, and whoever's appropriate, go ahead and answer that particular inquiry. On page 14, beginning on page 9 of your September 2nd testimony, you stated the public staff recommends the DEP be allowed to recover only $409,298 reported in relating to the reporting error, which is the portion of the over-reported JAAR revenues that arose in the text year. You further testify that the allowance of the 2024 amount reflects the appropriate period over which DEP should have reviewed and caught the reporting issues. You recommend in your testimony the DEP should be held responsible for its internal controls and reviews and should bear the burden of any under-collected amounts associated with its lack of review. However, beginning on page 14, line 19, and continuing to page 15, lines 1 through 2, you state that should an over-collection from ratepayers occur because of any past or future issues due to items that are or were within full control of DEP, DEP should be required to refund all amounts associated with the issue with interest dating from the period the issue originated to the final refund date. Now, can you provide any additional explanation for your differing recommendations in general regarding the regulatory treatment of an over collection from ratepayers versus an under collection?
Sure. So as we previously stated, testifying today, the error here was in full control of the company. Had they had the appropriate internal controls in place, for which we asked on several occasions and had conversations with the company, and it wasn't until they filed the rebuttal that they were able to state any of the internal controls that they had prior to this incident. When something is within full control of the company, we look to the test year and say if it occurred in the test year, it's recoverable. But since it's within full control of the company and the ratepayers have no avenue for which to verify that the company's accurately and correctly reporting its information, we feel as though that it's inappropriate to allow the company to keep any over collections that they would have otherwise had from those ratepayers, since their duty is to accurately and correctly report to this commission.
All right. Can you provide example dockets or types of circumstances where the commission accepted the type of differential recommendation for over collections versus under collections by the utility?
Sitting before you today, I could not. We're happy to provide that as a late filed exhibit if the commission wishes.
If you could do so, that would be appreciated. Should a distinction be made concerning DEP's request to recover the under collected costs from 2021, 2022, and 2023 in this proceeding, due to this proceeding being a rider proceeding versus a general rate case proceeding? So should there be a distinction?
I would say that I don't know that these costs could be recovered through a rate case proceeding, since there is a rider that exists to recover these costs from. I would say that based off the advice of our legal counsel, that the statutes that exist do not allow for for recovery of these costs associated with things that occurred outside of the test period.
Very good. We'll shift gears a bit. On page 11, line 21, you testified the DEP discovered the issue in February 25, but did not notify the public staff until June 10th of 25, when DEP filed its direct testimony in this proceeding. Given the magnitude of the error, did DEP provide the public staff any justification for why it did not report the issue to the commission when the error was discovered and prior to filing its testimony in this proceeding?
Based off of my recollection, and I will look to my colleagues if they recollect something different, when we posed the question to the company, part of the answer we got was that because they had found the error in February, that they were working through to find resolution to the magnitude of the error.
Okay.
Yep, I can add a little bit to it. So we discovered during they filed the testimony, and then we scheduled a call with them. On that call, they just simply say there's a reporting error due to they misuse the KW. So and not until the rebuttal, they link these discovery occurred in February 2025 to the 2023 filing. So, I mean, what I'm trying to say is just a piecemeal we're getting the information on. It's not like one at the beginning, we get the full picture. We piece by piece to kind of like, they are fitting the information to us.
I will also add, it's our understanding that Duke reached out to SIG and CUCA to discuss the issue and didn't do so with the public staff prior to filing.
I see. Now, was there any attention brought to the public staff that you're aware of back in 2023 when they found the discrepancy?
So in the 2023 rider filing, they stay in the testimony just saying that they discovered there's an issue with the custom connect that related to the reporting issue. So they make the whole adjustment for that whole test year of 2022. And then they because the timing of the filing was the test year, so the impact to the 2023, the first few months, they said they will address in the next test year. So that's all the information we are understanding at that point.
At that time?
Yeah.
Okay, thank you. And I take it all three of you have read the rebuttal testimony of Sykes and CUCA, is that correct?
Yes.
All right. In the rebuttal testimony of Sykes and CUCA, on page 4, line 8, they stated that every dollar at issue in this proceeding was prudently incurred. Now, does the public staff agree with this statement that all other costs related to the $16 million under collection of revenues in contention in this proceeding were prudently incurred?
The costs were deemed to be prudently incurred and properly accounted for in each of the JAAR proceedings for which they related to.
All right. Very good. In the rebuttal testimony of Sykes and CUCA on page 21, beginning on line 5, they stated the DEP has validated the results of the revised JAAR report via sampling, and that the public staff has validated accounts for the revised JAAR report against customer bills through its discovery requests. Therefore, according to these witnesses, DEP concluded that the JAAR report is now calculating revenues accurately. Does the public staff agree with DEP's conclusion?
The public staff sampled approximately 40 just related to LGS and MGS, subject to, they're telling me I'm correct. And based off of those 40, we did not find any additional errors. As I stated previously, the company and the public staff are working together for a full audit of the Customer Connect system and all of the internal reporting for all of the riders, since this just was not a JAAR issue, but was a systemic issue across all of the riders.
And when you indicate you took a sampling of 40, do you have any idea how large that universe is that you were pulling from or selecting from?
I could not remember the dollar amount, but I believe we took example, took sample based on the fluctuation of comparing the original reported versus the revised. So we took sample from that, and then actually we work with the company to make sure, because they feel like if we ask too many samples, it will be burdensome for them to pull this, because they already revert the old reporting to the new one. So in other words, they already revised their system. So if we sample, they will take several hours for each sample to pull the information. So given that impression, that's why we select only 40 of them.
I see. So it takes several hours going through each one, and it's voluminous and time consuming.
Yeah, that's what they said, because we take into consideration when we work with the company to make sure original, our sample size is quite some. And then they said it's really burden for them to pull, because each sample will take several hours for them to pull.
The juxta is the public staff wanted a larger sample. The company indicated that it was burdensome to provide such a larger sample. The public staff shrunk the sample to help the company along, which is why I say that within the confines of the Customer Connect audit, there may very well be other things that are found.
I thank you for providing that clarity. Does the public staff, based upon your investigation, feel that the $16 million as listed on page 8 of your joint testimony is the correct dollar amount of under-collected JAAR cost?
We believe that it is the company's representation, and for what we have been able to sample, it reflects the amount of over-reported revenues, yes.
Okay. And on page 33, lines 8 through 33 of the joint rebuttal testimony of Sykes and Quick, they state that in DEP's clean energy and energy efficiency portfolio standards application filed in docket number E2 sub 1356, DEP corrected previously reported revenues in the same prior periods. They testified that the result was a credit to customers with interest applied from the beginning of the error, reducing the cost to be included in the proposed CEPS rates by approximately $345,000. Why would the regulatory treatment of the correction made in the CEPS docket be different than the regulatory treatment of the correction for the undercollected JAAR cost at issue in this proceeding?
Well, first, let's level set for a moment. The company filed those corrections 7 days before we filed testimony in that proceeding. So the public staff has not reviewed, didn't sample, hasn't looked at any piece or part of what the company had stated as far as what that credit is. The fact that the company chose to bring forth a credit is the company's choice to do so.
Okay. Let me see if there are any other questions from commissioners. Not seeing any. We'll now entertain questions on commissioner questions.
The questions from the public staff, presiding commissioner.
Okay, not seeing any. These witnesses can be excused, and we'll entertain any motions at this time that are appropriate.
Thank you, presiding commissioner. My one cross-examination exhibit would ask that to be moved into the record at this time.
Without objection, your motion is allowed, and the naming convention that was identified, just for the clarity of the record.
Sure. DEP, Public Staff Accounting Panel, cross-examination, Exhibit 1.
Thank you. And in the interest of time, we're going to go ahead and bring up Sykes and Quick.
Just real quick while they come forward, presiding commissioner.
Yes.
We also need to move in an exhibit.
Okay.
If we could, this was previously marked as Sykes supplemental testimony exhibit A1-TU, and we ask that it be, we would move it into the record and ask it to be identified as Public Staff Accounting Panel Redirect Exhibit 1.
Without objection, your motion is allowed.
Thank you.
You may come on up to the witness stand. Where are you? Well, I know Mr. Sykes has already been sworn in, but Ms. Quick, we haven't sworn you in today. Do you solemnly swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank you. Mr. Sykes, are you the same Mr. Brian L. Sykes that previously appeared in the proceeding as part of the company's direct and supplemental case?
Yes.
Ms. Quick, please state your name and business address for the record.
My name is Leslie Quick, and my business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I am Vice President of Customer Technology, Advocacy, Regulatory, and Business Support within our Customer Services Organization for Duke Energy Carolinas, Duke Energy Progress, and other affiliated Duke Energy companies.
Please briefly describe your role and responsibilities at Duke Energy.
I have responsibility for the customer services support for DEC, DEP, and other affiliated companies.
Mr. Sykes, did you and Ms. Quick testify as a panel? Cause to be pre-filed in this docket, joint rebuttal testimony consisting of 37 pages and one exhibit.
Yes.
Was your rebuttal exhibit refiled on September 26, 2025 to make one ministerial correction to the document?
Yes.
Can you explain that pre-file change to your rebuttal testimony?
Our rebuttal exhibit references proceedings and other dockets before this commission, and we corrected 2 of those docket numbers.
Do you have any further changes to your joint rebuttal testimony at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed joint rebuttal testimony, would your answers be the same?
Yes.
Your joint rebuttal testimony does not include confidential information, is that correct?
Correct.
And did you pre-file a summary of your joint rebuttal testimony for the commission?
Yes.
Presiding Commissioner McKissick, I apologize.
Yeah, it's okay.
I ask that Mr. Sykes and Ms. Quick's pre-filed joint rebuttal testimony be entered into the record as if orally given from the stand, as well as a summary of the joint rebuttal testimony as also pre-filed with the commission.
Without objection, your motion's allowed.
Thank you. Presiding Chair, I would also ask that Mr. Sykes, and Ms. Quick's joint rebuttal exhibit be pre-marked for identification to be entered into the record at the appropriate time.
Very good.
The panel is now available for questions from parties in the commission on rebuttal
Okay.
testimony.
Give me 1 second here. At this point in time, I'm not seeing anybody having reserved opportunities to cross-examine, so we're going to go ahead.
Commissioner McKissick, I believe SIGFR and CUCA.
You do? Okay.
Public
Go.
staff as well.
All right, I see here. Yeah, we'll do, yeah. Let's go ahead and move forward then. CUCA.
Thank you, Commissioner McKissick. Again, my name is Peter Ledford. I'm appearing on behalf of SIGFR and CUCA. I'm going to start with a question that your counsel directed us to ask you, which is if the corrected rebuttal exhibit 1 attached to your direct testimony accounts for the $16 million in the savings, or if it does not account for the $16 million.
Sorry, could you repeat the question?
Your rebuttal exhibit 1 lists savings over the last 9 years associated with the JAAR rider. Is that correct?
That is correct.
Does that exhibit, as it's presented, include the $16 million in contested costs, or does it exclude those costs?
The exhibit excludes those costs. The exhibit reflects fuel savings only.
Okay, thank you. So on page 6 of your rebuttal testimony, you talk about excuse me, it would help if I was looking at page 6. In page 6 of your rebuttal testimony, you talk about the review that took place in 2023. So is it correct to say that the company identified problems with the report in 2023, took steps to address those, but did not fix the underlying problem?
So I'd say the review that occurred in 2023 did identify an issue with the report, and we believe that to be the only issue with the report at that point in time.
But it turned out not to be so.
Yes, in 2025, as we've stated, we discovered another error in the JAAR report.
In 2021, did the company ever justify the costs it was spending on JAAR assets to the income it was receiving from the rider?
I'm sorry, repeat your question for me.
In 2021, did the company justify its income from the JAAR rider to the costs it was incurring for the JAAR assets?
Objection, I'm not sure how this is relevant.
I believe it goes to reasonableness and prudency.
We'll overrule the objection.
Yes, so as part of our internal review, our end user review, either my team or myself, we review the report as it's coming in on an annual basis, on a monthly basis. So we have an opportunity to look at revenues as they are coming in and assess them for reasonableness. And so we have history with the JAAR rider going back to 2015. So in 2021, as revenues were coming in, we would have benchmarked the revenues against our experience. In addition, we are looking at changes on a monthly basis. So the error that we've talked about here, the $16 million, could equate to about $500,000 a month of a variance. And when we look at revenues received from the large general service class and medium general service class, $500,000 may not be a reasonable variance, or may be a reasonable variance to not assume there's something going on with the report that leads us to an incorrect revenue amount.
So you did not identify the issue at that time?
In 2021, no. In 2021, Customer Connect implementation was November of 2021. So there were 2 months of revenues in 2021 that we now know had an error.
And so in 2022, did you justify your income to your expenses?
Yes, for the same explanations I've just given. The end users of the report, who are closest to the JAAR reports, are looking at revenues for variances to determine if they are reasonable based on their experience with the JAAR revenues at that point in time. Again, at that point, we had 6 to 7 years worth of experience with revenues. So I think we had a good benchmark to say, are the revenues appropriate or not? Did it give us cause to look at the report to potentially assess if there was an issue?
But it did not identify the missing revenue.
No, based on the controls that we had in time, the end user controls, the review of the monthly JAAR report or the annual report, which builds the customer rates on an annual basis. We use our experience to determine if there might be a potential issue.
And in 2023, you did not identify a potential issue?
No, in preparation of the annual proceeding, as I stated in testimony in that docket, when we reviewed 2022 revenue, we identified something was wrong. And so in 2022, the report yielded, I want to say, a little over $90 million. That was the single highest revenue for a test period that we had seen since inception of the rider in 2015. So there's a lot that goes into looking at the revenues. You could have an over-recovered position, an under-recovered position. Costs on the prospective basis could be rising or declining from one year to the next. But again, our end users had the appropriate controls in place to determine if there was a potential for an error to exist on the revenue side.
You just, correct me if I'm wrong, you just said that you had what you needed to identify a potential error?
We had reasonable controls in place to determine if we thought there was a potential for an error.
But there was a potential for an error because there was an error.
There was an error, yes, that's undisputed.
Okay. So in 2024, did you discover the $16 million were missing?
In 2024, our controls at that point in time did not determine that there was an issue with 2023 revenues.
And so it was in 2025 that you first identified the issue.
Related to the $16 million, the control that was put in place in February of 2025 is what led to discovery of 2 design errors in the report, which now we know totals to $16 million.
So we went through 4 rounds of review without identifying the error, 4 years of review without identifying the error.
I would say at least 3 years. In 2021, we had 2 months. So that wasn't the best benchmark, but yes, in subsequent years, we did identify that there was an error.
I'll concede it was not a full calendar year. So would it be reasonable and prudent if my bank made an error 3 years ago for me to go back and argue with them about it now?
I can't opine on that.
And if my bank refused to adjust it in my favor, would that be unfair and unprecedented?
If you deem that to be the case, yes.
If a SIG or CUCA member charged a customer the wrong amount for a product in 2021, do you think that customer would be willing to pay the difference today in 2025?
I'm sorry, I missed the first part of the question. Could you repeat?
If one of my client's members charged a customer the wrong amount in 2021 and went back to them today and attempted to charge the correct amount, would that customer pay the difference?
I can't opine on that.
Would it be extraordinary and punitive if that customer did not pay the difference 4 years later?
I cannot opine on that.
If my employer has a rule that gives me 30 days to submit an expense report, but I wait 4 years to submit my expense report, would it be extraordinary and punitive if my employer refused to reimburse me?
Again, can't opine on that. What I will say is, as we've iterated today, the general statute does allow recovery of all costs under the JAAR rider. And so we are simply asking to revise the rolling recovery factor so that we appropriately reflect the cumulative balance of doubt or imprudent and reasonably incurred costs that the company is due.
So it is your testimony, though, that it would be extraordinary and punitive for the commission to deny Duke's request for recovery here.
I'd say the commission has the authority to decide this case, but going back to the general statute and commission rule working together, the cumulative balance is something that the company should maintain through the operation of the rider. And in this proceeding, we are attempting to do that.
Would it be extraordinary and punitive if the commission denied cost recovery for Customer Connect in the forthcoming rate cases?
Objection. This matter regards to joint agency asset rider, not the next generation.
Sustain.
Can you turn to Exhibit A1-TU to your direct cut testimony, excuse me, supplemental testimony? It's also Public Staff Redirect Exhibit 1.
Could you identify that number once again so that everybody can pull it up?
So Ms. Harrod identified this as Public Staff Redirect Exhibit number 1. It's also Sykes Supplemental Exhibit A-1-TU.
Thank you. And one thing I'd like to bring to your attention, we're going to try to see this rider proceeding through today. So notwithstanding what we indicated earlier about adjourning today at 5, we're going to try to see this one through. Guess so everybody can plan accordingly. If you need to send a text message to someone, go ahead and do it at this time. Let them know you'll be running late. Thank you.
I should just have a few more questions and then I'll be done.
That's fine.
So if we look at the value in row 89, which is December of 2022, that carryover goes over and forms line 90, January 2023. Is that correct? As part of the rolling recovery factor?
Yes, it does.
And if we look at December of 2023 in line 101, that cumulative balance rolls over to be the rolling recovery factor for January of 2024.
Yes, that's correct.
And if we look at December of 2024, does that amount roll over to be the amount for January of 2025?
In this case, it does not, because as the company has described previously today, we are attempting to recover $16 million of reasonably and prudently incurred costs. What you will see on this exhibit is approximately half of that amount based on the company's proposed mitigation to MGS and LGS customers in this proceeding.
So you agree that's not a current part of the RRF balance?
No, I do not agree with that.
So are you disputing your exhibit?
I'm not disputing my exhibit. In order to effectuate the rate that we need to recover and show the mitigation offer that we have, there was no other option but to put the $8 million adjustment on line 114.
So it did not exist in December of 2023, but it was adjusted for January of 2024.
The underlying costs associated with the $16 million existed in prior years. So in the 22 filing, the 23 filing, and the 24 filing, we illustrated our costs and no party found them imprudent. And so we had put customers on notice at that point in time that the company needed to collect $16 million over those 3 years.
No further questions.
Okay, what we're going to do is take a quick 5-minute break, and when we come back, you'll have the opportunity to continue examination. Thank you.
Oops, sorry, Dwight.
And we will try to plow through the end. And what I've generally found is once 5 o'clock approaches, things move along a lot more swiftly. And I say that is in looking at Attorney Harrod.
Pressure's on.
But take all time you need to do your job effectively, notwithstanding the clock.
Thank you, Presiding Commissioner. I will do my best to walk that tightrope. I did reserve an hour time, but I will try to use time effectively such that whatever time I take, it will fly by. Good afternoon, Mr. Sykes, Ms. Quick. Let me start by asking a little bit about your roles in the company. Mr. Sykes, is it accurate that your department is rates and regulatory planning?
Yes.
Okay. And are you one of the end users for the JAAR report we're talking about?
Yes.
Okay. Is also the accounting department another end user for that report or not?
I believe they are, yes.
Okay. Ms. Quick, I understand from your testimony, your department is customer technology, advocacy, regulatory, and business support. Is that right?
Yes.
Can you please say what your department's role is with respect to the JAAR report?
Sure. I have responsibility for the reporting team that's described in testimony also, who develops and produces the reports for the end users.
Okay. So just to sort of get on the same page here, beginning with the transition that the company made to the Customer Connect billing system in November of 2021 and continuing until today. How many design errors has the company detected with the JAAR report?
I believe it's 2 design errors for the JAAR report.
Okay, so where I'm a little bit confused is the 2020, but let's just walk through it, okay? So the question that I asked you during your direct that you deferred to Ms. Quick was the error that we're talking about here today, that's the $16.1 million revenue reporting error, was discovered, as I understand it, in February of 2025 in connection with the company doing a comprehensive review of financially relevant reports that were generated out of the Customer Connect system, correct?
Correct.
Okay. What triggered that review?
So I took responsibility over the reporting team in October of 2024. And we had some existing processes and business controls in place with the reports already. I thought there was an opportunity to supplement that. And so we implemented a SOX control, which basically requires the end users to work with us to validate the financial reports, which there's about 49 of them on a semi-annual basis. So just do another due diligence review. There's a lot of things that are changing with reports, report requirements, enhancements, et cetera. And so it's just an opportunity to take another view at these reports, a deep dive into these reports twice a year, on top of other monthly variance analysis, et cetera, that the end users do.
Okay. So that was at your personal initiation?
Yes.
Were there any other factors in play, just your personal initiation?
No factor in particular. It was just understanding the business, understanding how the processes worked, and thinking of ways to improve the reporting team and what they produce, and put some extra controls around that. So nothing in particular.
Okay. So let's start by talking about 2021. When Duke set up the JAAR report in 2021 in connection with the transition to the Customer Connect billing software, as I understand from your testimony, Duke checked the results against legacy data, and it seemed that the JAAR report was functioning as intended. Now, what does that mean that you checked it against legacy data, please?
So we had an operational readiness testing team as part of the Customer Connect project team. And so they developed and transitioned hundreds of reports from our legacy system to the Customer Connect system. And as part of that, they did the appropriate testing at the time to ensure the correct conversion of the reports from legacy to Customer Connect.
Okay, but the specific question that I asked you was, what does it mean that they checked the report against legacy data?
So they would take legacy reports and just validate that the revenues or whatever comes out of the report are in line with that historical reports that have been produced out of the legacy system and do appropriate testing with that.
Is that a sampling process or did they test all of the data?
It is a sampling process, as it would be really, really, really hard and not cost efficient and very time consuming to test every single specific example or test scenario with bills. So it was a sampling.
Okay, so as I understand, I'm not sure if there were 2 or 3 errors, logical errors in the report, but what I do understand is that at that time, from your testimony, if you could confirm this, whomever designed the report did not apply the price to the correct KW billing determinant for the LGS and MGS customers that were on time of use rates. Is that correct?
That's correct.
So that's one of the errors.
Yes.
Okay. And as I understand it, this person or people, and just wait a minute to circle back. These are all Duke personnel. This is not an external contractor. Is that correct?
Yes, they were Duke personnel and potentially some contractors as part of the project team. I don't have that exact information.
Okay. And would these be people from the rates department and from the customer data department?
The rates team would be participating in the operational readiness testing since they are the business experts. Yes.
Okay. So these business experts, though, they picked the wrong KW determinant. They picked what determinant did they pick and which one should they have picked?
So I believe they picked KW build. And at the time of conversion, that should have been on peak KW.
Now, how did that happen? I mean, how did these were people in the rates department, did they not understand the tariffs?
I would say that this was a very complex and unique situation that probably was not able to be tested down to the exact degree to ensure accuracy. I think it was probably a misinterpretation in requirements. And when we did the analysis after the fact, didn't look to be that big of a variance to stand out as far as an issue.
And is it fair to assume that it wasn't that big a variance because the burden fell very heavily on a narrow class of customers rather than being something that was pervasive across all the customers?
I would say it's a smaller class of customers that have very unique billing situations versus the KWH bill customers.
Okay, and was the rates department aware that this was a complex tariff?
So I'll speak on behalf of rates. We do have more than one rate group. So my group is responsible for developing the rates that the commission approves. There is another team, kind of called rates, that implements rate design. So to the extent that team was involved, yes, they would be the subject matter experts to weigh in on the accuracy of the report.
I see, but nobody from that team is a witness in this proceeding.
Correct.
Okay, so repeat for me again what piece of it your team has?
My team relies on data from accounting, whether it's capital additions, depreciation expense. We look at the input data and we look at the rate making side. So we're responsible for setting the annual rate that the commission approves based on our reasonable and prudent costs.
Okay. So neither one of you, the people who would have picked the wrong KW determinant, those people did not report up to either one of you.
No, not at the time.
Now, there was another design flaw, as I understand it, which is, and Ms. Toombs actually did a really good job of explaining it in the oral argument. I appreciated that. That where a rate would change in the middle of the month, that time where the rate hadn't been charged for the whole month was not reported. Instead, it was reported as if it had been charged for the whole month. That's fairly accurate way of describing the second design flaw?
So I would say it a little bit differently.
Sure, please.
If there is a rate in 1 month and a rate change in the subsequent month, we would have applied the applicable rate. That was the commission approved rate. The design issue that we're talking about is on the kilowatt side. So the demand from the customer was erroneously reported, and then the appropriate JAAR rate was applied to yield the revenue. And so as we said in testimony, those revenues were overstated because the kilowatts were overstated.
But it had two facets to it, that the wrong kilowatt determinant was picked and also the time factor wasn't included.
Potentially. There could have been an instance where it was just the billing determinant was wrong, but there also could have been a potential where the billing determinant should have been on peak when it was billed KW.
Okay.
So there were times where the design errors were working together.
So I think what I understand from what you said a minute ago, Ms. Quick, is that it would have been very burdensome to have sampled a large number of the JAAR bills, but the failure to do so meant that this error wasn't detected as part of that operational readiness testing.
I would say that we have experts who deal with sample sizing and what we should be doing as far as converting of reports and how much we should be sampling. I believe we did sample LGS and MGS bills, but not the ones that necessarily had these detailed complex impacts.
Okay, so those sampling experts didn't understand the operation of the tariff to know that there would be detailed complex impacts. Is that fair to say?
I do think it was an error that was overlooked in that process. Yes.
So then let's move forward then to 2023 when DEP determined that there was an error in the JAAR report. And as I understand it, that was determined by comparing the 2023 JAAR application and test year activity for reasonableness. Is that correct?
Yes.
Okay. Now, what was that error that was detected at that time?
At the time, when we looked at 2022 revenues, the underlying error was proration.
Is that the one we were talking about with the time difference?
Yeah, so where a rate applied in 1 month and a new rate applied in a subsequent month.
Okay. Now, I'm looking at your rebuttal testimony. It starts at page 18, if you want to go there. And it describes that discovery of that time proration error and the testimony. I'll wait for you to get there. So the testimony says the CDS team worked with the end users of the report to sample bills that were showing duplicate KW on the report to ensure the issue was resolved. However, without full understanding of the complexity of the JAAR billing structure for the customers billed on KW, sampling of bills would not have been sufficient to ensure all issues were corrected. So that's the second time that there's a sampling error that results in an error in the JAAR report not being detected, correct?
Are you on page 18?
Yes, did I misread it?
And could you tell me what line item?
Sure, of course.
Yeah.
Oh, okay, I think it starts at the bottom of 18. Thank you for your help, everybody.
Okay.
Okay,
yeah.
it starts right down there at the bottom of 18. Yeah. and goes to the top of 19. So take your time and read it, and then I'll ask a question again. All right, so my question is, by my count, this is the second time, first in 2021 and now in 2023, when Duke had an opportunity to catch this error because it was actually looking at the JAAR report, and because of a failure to determine an appropriate sample, Duke didn't catch the error. Is that accurate?
So I think there are two different instances. So customer connect conversion, implementation of new reports, yes. As Ms. Glick just testified previously, the team did a sample. And then in 2023, as my team was doing research on the revenues being yielded by the report, we worked with our reporting team to determine if there was a potential issue, which was on a sample basis. So yes, another sample basis for research.
Okay. In that testimony where it says without full understanding of the complexity of the JAAR billing structure for the customers billed on KW, sampling of bills would not have been sufficient to ensure all issues were corrected. In that sentence, who exactly is it that lacked, and I'm not asking for names, of course, but within Duke's corporate structure, which department, which personnel lacked full understanding of the complexity of the JAAR billing structure?
I would say my team, the SME that was working on the report in the 2023 issue at the time thought that she had addressed all the issues with the end users. Unfortunately, there was a gap there and we didn't actually resolve all the issues at that point in time, which led to the error we found in 2025. That employee no longer works on this report. We have a new employee on my team who is a subject matter expert, a very detailed JAAR expert and LGS, MGS demand bills. So that works on this report now.
Okay.
And she was able to discover the issues that remained in 2025.
Okay, so the person who your CDS person was relying on was somebody in the rates department?
I would say it's in partnership with the rates department. So my team understands, right, the configurations of the system, how to pull the data. They understand generally the concept around tariffs, rate design, et cetera, but they work in partnership with Brian's team and then our other rate design team to ensure that we develop appropriate requirements to ensure that the reports are accurate going forward. So it was missed as part of that step.
Okay. I would like you to please turn to public staff proposed cross exhibit 8.
I'm sorry, I don't have that in front of me.
Oh,
Might not.
I think it's, is it under here? Excuse me, if I may. Early in the day, you seen it? Yes, this is it. I think there's two copies of it. Here you go. Sure, that. Been a long day already. Presiding Commissioner, let me note and also note for the witnesses that this is a confidential exhibit. I do not know what about this exhibit is confidential. Do the witnesses understand the parameters of confidentiality?
That's the exhibit again. We didn't.
Of course, it's public staff potential confidential cross exhibit 8.
And I do have the exhibit before me, and I looked at Duke's counsel to see if you all can take a look at that and review it quickly to let us know if we need to go into confidential setting to.
I don't plan to ask the witnesses about details. I just want to ask them sort of top line.
Witness had an opportunity to review. I think you should be able to answer without disclosing anything confidential. But if you reach that point, then make presiding chair aware, and then we'll deal with that. I don't believe we need to go to confidential session at this time.
All right. It sounds as if what they're essentially saying is if we get ready to approach something confidential in terms of an inquiry being made, they will alert us at that time, and we will have to go into a confidential session. And we'll look at the room to make sure that who is in here at that time and who may need to leave the room at that time, and alert John when it comes to video feed as to making certain nothing goes out.
Well, at 5:02, we'll try to avoid that. So let me ask this question, and if you feel like you might have to say something confidential, maybe I can reword the question. The question I want to ask you in reference to public staff potential cross-examination Exhibit 8, which is a response that Duke made to a public staff data request. I would just like you to, if you can, state the other riders and proceedings that were affected by Customer Connect reports.
And if you could, let's go ahead and officially use our traditional naming convention
Yes.
for this particular exhibit, so it will be consistent with our.
I apologize, Presiding Commissioner, I got sidetracked by
okay.
the confidential issue. So let's call this, please, public staff, Sykes and quick rebuttal. It should be public staff. Yeah, Sykes and quick rebuttal, confidential cross Exhibit 1.
I think that should cover it, and it'll be duly noted in the record.
Thank you. Okay, so to repeat my question, just if you could please, at a top line level, without revealing any confidential information if possible, just let us know what other errors that were discovered in connection with the 2025 review that impacted other riders or other proceedings before this commission.
I'll take that one. So as we've talked about in this proceeding, we've had a $16 million issue in the JAAR proceeding. We've previously discussed the SEPS error that existed. I believe that was referenced earlier today. The CPRE rider had a small adjustment as well. We also had a billing adjustment in the fuel rider and the DSM EE rider.
I believe I'm correct that this is also going to require some adjustments to the storm securitization true-up. Is that also correct?
Possibly, yes.
All right. Let me ask you, now that you've got the notebook, let me ask you to turn to public staff proposed cross Exhibit 13. Commissioner McKissick, are we behind it?
Yes.
Could please identify that as public staff, Sykes and quick rebuttal cross Exhibit 2.
Duly noted.
All right. May I ask, is this a document that you've seen before?
Yes.
Okay. So I'm going to identify it for the record. This is the investigation and examination report of Duke Energy Progress LLC, alleged incorrectly calculated bills and issuance of bill credit as reported in the media. This is an investigation report by the Office of Regulatory Staff of South Carolina. The report date is September 27th, 2003. And is it your understanding that the ORS undertook this investigation at the request of the South Carolina Public Service Commission?
Yes.
Okay. And Is this anything that your department worked on, Ms. Quick?
Yes.
So I'm just gonna go over a couple of quick things here. The table 1, it's right at the beginning. It is an unnumbered page. Well, actually in the docket numbering on the side, it's page 5 of 95. And one of the questions that ORS was asked to investigate, question number 4, why errors in billing were not identified earlier. And the ORS's investigation, this is their summary of their investigation, states that insufficient oversight during and after deployment of Customer Connect contributed to the failure to identify the error and configuration of tiered pricing rate structures prior to January 24th, 2023. So are those some of the same rate personnel who would have been involved with validating, trying to remember what you call it, with preparing the operational readiness testing when you transition to Customer Connect?
No, this was related to a new rate that we had implemented in South Carolina that was configured incorrectly. And we discovered it and we realized that we needed to refund customers on average around $5. And it was caught quickly and addressed quickly, but a very different issue as customers were being billed incorrectly in this scenario as the proration was not happening appropriately with this tiered rate.
So my question is, were those people who failed to identify the error in the configuration of the tiered pricing rate structure, are they within the rate department that you supervise, Mr. Sykes?
I'm not familiar with this, so I'm going to say no.
Okay. Okay. Ms. Quick, are they within the?
We would be working with the rate design team on this. And this would be a separate technology group working on this.
But so is that rate design team also the rate design team that would have been involved with, I'm sorry? Did you answer my question? No, I hit the microphone. Would that rate design team be the same team that was involved in the operational readiness testing of Customer Connect?
These are completely separate issues, so it's going to be really hard for me to compare these two issues we've talked about, being the JAAR issue and this time of use configuration issue in the system.
I'm not trying to compare the issues. I'm trying to ask about the personnel or the departments that work on these issues. That's my question.
I'm not sure I can answer that from this ORS issue.
All right, and if we turn to page 20 of Public Staff, Sykes and Quick rebuttal cross exhibit 2. In response to ORS discovery, this is most of the way down the page. There's a paragraph of indented text, and it states that there was a tariff misinterpretation which resulted in an incorrect configuration setting being applied. Do you see that? Sorry, page 20, the pages are numbered off to the side. They're like, it's like a docket filing.
Thank
Did
you.
find
That's
it?
what I was
Oh,
missing.
so you're referring to the document stamp pages rather than the page number itself?
I don't think it has internal pages other than that file stamp along the side.
Okay. So
Page 20.
page 20 of the stamp along the side. Okay.
Yeah. Do you see the text?
Yes, I
block
do.
text there? Thank you.
Mhm.
Okay, so the question is, in that case, the company stated that one of the issues was there was a tariff misinterpretation, which resulted in an incorrect configuration setting being applied. Do you see that?
Yes.
All right. So again, you can't say whether those are the same department that was involved with the North Carolina JAAR report issue.
Objection, this has been asked and answered several times at this point, and I'm not certain that the tariffs in South Carolina, how they relate to the JAAR tariff here in North Carolina. I've allowed sort of the question to go on for a while, but I'm unclear of the direction and the relation. to this
I'll
matter.
abstain that objection.
I'm happy to move on. So following the process that we've talked about in 2023 with respect to the JAAR report, which the company at that time identified the proration error, but did not identify the error involved with selecting the wrong KW determinant. Is that correct?
Yes, that's correct.
Okay. So I just want to kind of go back to page 5, line 9 of your testimony. And I'll read that sentence into the record. Our testimony explains that these design errors were introduced during the system conversion to Customer Connect in November 2021 and were not immediately apparent as they were embedded within the JAAR report logic, i.e. the methodology underlying the manner in which the Customer Connect program generated the BIL 509 report, and difficult to detect through routine but reasonable end user review processes, as will be further addressed below. Now, my question is, what's the basis, given that there's an error, it persists over more than 3 years, and you fail to detect it when you specifically look at this report 2 separate times, what is the basis for your testimony that the end user review process was reasonable?
So as I testified earlier, we look at the revenues that the report is yielding. And based on our experience with the writer, we assess if those revenues are reasonable, either on a monthly basis or on an annual basis. And as I've testified to previously, 2023, preparation of the 2023 annual JAAR proceeding was the first opportunity to look at a full test period, so 12 months worth of JAAR revenues to make that assessment if the revenues being determined by the report were appropriate for the end user of the report and the person who prepares the annual JAAR filing.
Okay. Well, now that we've seen your rebuttal testimony, I certainly have a better understanding that you had some processes and what those processes are. But the question I have is, what's the basis for your assessment that it was a reasonable process given that it didn't detect the error?
So I would say it's reasonable in the sense that we were looking at revenues. At that point in time, we had no basis to believe that the report, the underlying KW, the demand on the report was incorrect. So when we're looking at the report and seeing the KW that we're seeing and multiplying that times the JAAR rate to get comfortable with the revenues that the report yielded, to me, that's a reasonable end user control.
All right. At any point between 2021, when you implemented Customer Connect, and sometime in 2025, when you undertook this review you've discussed, Ms. Quick, did Duke tie out the results of the JAAR report to its financial data?
No, and I will say this. So prior to October of 2023, we did not have a tie point to the ledger. In the rate case that led to October of 2023, the JAAR rider was split out on customer bills such that we now had better visibility into the revenues that were actually being billed to JAAR customers.
I believe you have an accounting background, Mr. Sykes. You started as, what I meant to say is an auditing background, correct? You started as an auditor with Arthur Andersen back in the early 2000s, right?
That is correct.
Okay. So is it your testimony as a professional that it was an adequate auditing, it was an adequate from an auditing standpoint to have a testing procedure that didn't involve tying out to other validating data?
Yes, had we had that data, absolutely, we would have used that as a tie point. As I stated previously, the JAAR rider was not broken out on customer bills. So we didn't have a tie point necessarily back to the financial statement, but I don't think it was unreasonable at the time to look at the JAAR revenue report on a monthly basis. And then when we were preparing our annual filing, the end user controls that we had in place at that point, I don't think those were unreasonable.
I would like to get into the record another confidential exhibit, but I would just like to get it into the record. I won't ask any questions about it, so we don't have to go into closed session if that's acceptable to, it's pre-marked as proposed confidential public staff proposed cross exhibit 12. And if it's acceptable to just put that in the record.
No objection.
Without objection, your motion's allowed.
Thank you.
Just to go ahead and use our traditional naming convention, so we'll have it appropriately identified.
Yes, so we would like to mark and move into the record public staff Sykes and Quick rebuttal cross exhibit 3.
Confidential.
Thank you. Confidential cross exhibit 3, which is pre-marked as public staff potential cross exhibit 12.
Thank you. Without objection, your motion's allowed.
Now, just to identify for the record, if we could please, this exhibit that we've just marked as public staff, Sykes and Quick rebuttal cross exhibit 3 constitutes a new procedure that the company has instituted to well, I'll let you, Ms. Quick, I don't want to say something inadvertently on the record that shouldn't be said. Can you identify this exhibit without getting into confidential information?
Sure. This is an additional review we put in place to review the reports. It is a SOX control review where we do a semi-annual look with the end users, detailed review of these reports on a semi-annual basis going forward. And that is a SOX compliance rule, I guess, we have in place to ensure accuracy of the reports on an ongoing basis. I will say that is in addition to our existing processes that I mentioned in my testimony in that 4-step process.
Okay.
You
And
may want to refer to the date of this exhibit.
oh, certainly. This exhibit is dated June 30th, 2025, correct?
Yes, it was official as of June 30th, 2025. We actually implemented it in, I think, early February is actually when we implemented the process. We made it an official SOX control. I couldn't think of the word control a minute ago. Made it an official SOX control as of 6/30.
Thank you for that clarification.
Thank you, Presiding Commissioner.
Presiding Commissioner, if I may.
Yes.
I believe council planned to move into the record but not ask questions. I'm fine with the questions continuing, but just want to remind our witnesses to be cognizant of confidential information as you respond.
Appropriate. Thank you.
I don't have any more questions about that exhibit. But I would like to say presently, the company does tie out and I believe you already testified this, but just to be clear, the company does now validate the JAAR report with the company's financial records, correct?
Yes, as of October 2023, we have the capability to tie the JAAR revenue report back to the JAAR revenue reports that are reflected on our general ledger accounting books.
Okay. All right, a couple of times in your testimony, you've commented on the public staff's conclusion of the accounting panel that Duke lacked appropriate internal controls. And I'll just mention a few of those places. On page 10, you say contrary to some of the generalized assertions, the company did implement a reasonable review process. Again, on page 11, similar language, contrary to some of the generalized assertions, there was a review process in place. On your testimony on page 22, there's a longer discussion. A couple of question and answers about the public staff's testimony that the company lacked appropriate internal controls. Here's my question about that testimony. To your knowledge, what is the source of the public staff's understanding of Duke's review process at the time the public staff filed their testimony? Ms. McCarthy.
We received several data requests asking about this. I think when we were responding to those data requests, they were very narrow focused to the issue in 2025 that was discovered. And then we saw the staff testimony and realized that they were interpreting it as a broader internal controls issue. And so that's why we addressed that in the rebuttal testimony.
Maybe you didn't update your data request responses after you saw the public staff's testimony, did you?
I believe all those responses were responded to accurately. It was just narrow focused until this point in time.
There was a call on August 1st, 2025 among the subject matter experts from Duke and the public staff, including the lawyers of the public staff. I believe you were on that call, Mr. Sykes. Were you?
I was.
And were you on that call, Ms. Quick?
There were 5 calls. I can't remember if I was on that one or not.
Fair. I believe Ms. Bateman, Laura Bateman from the accounting department was on that call. Do you recall that?
If I recall correctly, yes.
Okay. Do you remember on that call, Michelle Boswell asking the company to describe the processes it had in place to detect errors in the JAAR report?
I don't recall specifically, but it would not surprise me.
Do you recall explaining any of the things that later showed up in your rebuttal testimony?
I really don't specifically recall the conversation.
All right, let's look at public staff exhibit, potential cross exhibit 10, please. And while you look for that, presiding commissioner, I would like to identify this for the record as public staff Sykes and Quick rebuttal cross exhibit 4, please.
Okay, duly noted, without objection.
All right, so do you see that that question says, please provide the detailed internal controls and procedures Duke utilized to verify the costs and revenues for JAAR before February 2025?
Yes.
Okay. Do you view that as a narrow question?
Again, as we stated previously, as we were responding to this request, I believe a number of the requests said the reporting error. And as we were responding to the numerous questions received from the interveners, we assumed the questions were focused on the reporting error that we identified in February 2025.
Okay, so you just misinterpreted the request. Is that what you're saying?
Yes.
All right, so let me ask you then, okay, so you see that that says, please see the response to public staff data request 3-5. See that?
Yes.
That's the complete response to that question about asking for the detailed internal controls. Okay, so then let's look at that, which is public staff proposed cross exhibit 3. And presiding commissioner, I would like to please mark this for identification as public staff, Sykes and Quick rebuttal, cross exhibit 5. Thank you.
Duly noted.
All right, so in the interest of time, I'm only going to refer to that particular response. Public staff, data response 3-5, part C, sub 1. So that question says, please state whether the semi-annual review and validation occurred as a result of the reporting error discovery. If not, please explain why Duke did not discover the issue in earlier years, but until February 2025. Is the public staff's understanding that the Customer Connect program was implemented in November of 2021? All right, so please, if you would, read Duke's response in full to that question C-1.
The process in place prior to 2025 reviewed reports when errors were found or changes were requested. The semi-annual review and validation process establishes a formal requirement to regularly review reports, ensuring that they are functioning as designed and remain accurate and up to date.
Okay, so in that response that you read, the first sentence refers to the processes in place prior to 2025. I believe I'm correct that the second sentence refers to the processes that your team put in place in 2025.
Correct.
So in short, when the public staff asked for a detailed explanation of the procedures that Duke used to verify the costs and revenues for JAAR prior to February 2025, the response was one sentence. Is that accurate?
Yes, based on our interpretation of the question, which again, we interpreted as being focused to the reporting issue identified in February 2025.
Okay, when you're going to give testimony in a proceeding, is it your practice to read the discovery responses as they're being drafted? Do you review those yourself if you know you're going to be the witness?
Yes.
Okay. Let me ask you to turn to page 4 of your rebuttal testimony. Line 19, it says, to be clear, the company acknowledges and takes full ownership of design errors in an internal report used to illustrate revenues assumed collected by the JAAR writer. What does it mean that the company takes full ownership of that mistake?
So we acknowledge that the error existed and it was our report that was incorrect.
Okay, but the company's seeking full recovery of all of those underreported revenues, correct?
Yes.
Okay.
As we've stated previously, we feel that the costs incurred to support that $16 million error were reasonable and prudent as proved in prior JAAR proceedings.
Right. If we turn to page 16, line 11 of your testimony. You've characterized this, if we look at 16, line 11, you've characterized this as a relatively minor underreporting of revenue. Have you not?
Yes.
So you understand that the large general service customers certainly don't consider it to be a minor underreporting, correct?
I can't speak on their behalf.
Okay, fair enough. But it's also your testimony, and I don't think we need to go there. We can if you want to. It's on page 30. It's also your testimony that if the commission did not allow Duke to recover for this relatively minor underreporting of revenue, that would constitute a penalty in your view. Is that correct?
That is the company's position, yes.
Okay. And I believe I also understand it to be well, we've talked about this to some extent. So I think it's fair to say that it's the company's position that it can go back however far that it needs to, in its view, recover any unrecovered costs or any over-reported revenues, no matter how far back it goes.
We believe the statute allows for that, yes.
All right. As I understood Mr. Breishart's questions of the accounting panel, it's also the company's position that it can get back interest on those amounts that it didn't seek. Even if it's 10 years back, it can still get 10 years worth of cost of capital for that. Is that the company's position?
I believe technically we're entitled to it, and then it's a management decision should we seek recovery of those costs.
And it's your position that that's what the General Assembly had in mind when it enacted the JAAR statute?
In reading the plain language of the statute, it says all costs, and a return is part of the costs allowed under the statute.
All right. Would you also, in your interpretation of the statute, believe it would be appropriate for the public staff to reopen prior rider proceedings and re-audit costs and determine whether it thinks that those costs were reasonably and prudently incurred?
I would say the public staff has already, through their testimony, signed off on the reasonableness and prudence of prior costs.
Well, the same could be said about the testimony that you personally gave regarding the correctness of the revenues. Is that not true?
Yes, it's true. And at the point in time when those filings were made, we believed the revenues in that report to be accurate.
All right. I have no further questions.
All right. Redirect.
None from the company.
No redirect. Okay. And I think we've got everybody covered. We'll look to commissioners for questions at this time. I know I have a few here, but I'll recognize I'm not seeing any others. So I will go ahead and ask a few commission staff questions. On page 11, beginning on line 21 of the joint testimony of public staff witnesses Cofield, Zhang, and Boswell, they testified the DEP discovered the JAAR reporting issue in February of 25, but did not notify the public staff until June 10th of 25, when DEP filed its direct testimony in this proceeding. Given the magnitude of the error, why didn't DEP report the issue to the commission when the error was discovered or at some point prior to filing its testimony in this proceeding?
I'll take a first stab at that. And
if you could speak a little louder.
Yeah, sorry, I'm losing my voice at this point in the day.
I understand.
So as we identified the issue in February, it took a couple of months for our reporting team to fully investigate the issue and then generate reports that my team could then go back and compare what we previously reported to what the revised revenue reports are at this point. So that took some time. We're working against a June 10th commission mandated deadline. So it just took time. I would say in retrospect, we probably should have made the public staff aware. I think typically if we report something to public staff, it's where we have issues where we have misbilled a customer. And we're saying in this case, we did not misbill customers. So again, with hindsight, we could have had a call with the public staff to make them aware of the issue that they would see in the filing.
Okay. Anything you'd like to add, Ms. Quick?
No, I'll just add that it was a very complex scenario. And so the reporting team, it took them a while to kind of figure out kind of all the wires in the system and how it equated to, or what it equated to, which was a 16 million working with Brian's team. So it's not like it just took a week to actually do the analysis and get out the results. But in hindsight, like Mr. Sykes said, we could have given the public staff at least a heads up that we had an issue that we were aware of, even if we didn't know the amount at the time.
Okay. Should a distinction be made concerning DEP's request to recover the undercollected costs for 2021, 2022, and 2023 in this proceeding, due to this proceeding being a rider proceeding versus a general rate case?
So I'll answer that one. In reading the the general statute, we believe we are entitled to all costs. This is a very long rider. We invested $1.2 billion in the assets that we're talking about. So it's going to take a long time to recover the $1.2 million. So to go back to 2021 In light of the reasonable end user and other controls that we had in place, we do feel it's appropriate to go back to 2021 to recover the $16 million.
Anything you'd like to add, Ms. Quick?
I think he said it well.
Okay. All right. Do you agree with the overstated revenue amounts listed on page 8 of the public staff September 12, 2025 testimony of approximately 2.95 million for 2021, 6.85 million for 2022, and 6.3 million for 2023?
Yes.
All right. And on page 13, you testified that the first full year review opportunity was in 2023. Why did DEP not implement an accelerated review schedule immediately after the system conversion, given the substantial revenue implications of JAAR?
I'm not sure I can answer that question because I did not have the team at the time of that issue being discovered.
Okay. And you took over this team, can you refresh my recollection?
October of 24.
That's what I was thinking.
Yep.
Is there any impetus other than you taking over this team, any other factors that led you to reevaluate the way these reports are being done and to try to move to this semi-annual type of evaluation that's occurring based upon the changes that you've implemented?
So as part of our 4-step process that I mentioned in my testimony, where basically a business user, end user submits a change to report or a new report or identifies an error with a report, they submit that. Then we do requirements with the teams to build out detailed requirements. Then we build out the workaround so that we can kind of test the scenarios, make sure the report is correct, et cetera. And then lastly, we put the report into production. What I will say in that whole process, I felt like there wasn't official sign-offs per se. It was a lot of requirements being documented, a lot of support going back and forth between the teams and the subject matter experts and my team being the reporting team. But at the end of the day, I felt like we could add and enhance that control by putting in this new SOX control, where we do take a deep dive into these reports twice a year, because there's changes being made to these reports on an ongoing basis. Not every report, but a lot of the reports. So it didn't hurt us to just take another due diligence review twice a year and make sure that the end users agree on the reporting numbers.
Do you feel that that type of review should have been conducted back when errors were discovered in 2023? Because at that point, they had a workaround that they implemented, and then they went back to what they had come up as a potential fix, as I best recall.
I guess I would answer to that as it wouldn't have hurt, for sure. Having more eyes on these reports and doing more reviews of them, it never hurts.
Okay. On page 15, you say that the methodological error was not detectable in routine monthly reviews. With hindsight, can you now explain why the monthly reviews did not detect significant anomalies?
Yes, when we were looking at monthly revenues, we're not only comparing to the prior month, sorry, we're looking at a handful of things, but the complexities here with proration, my team would not have had insight into that. And again, we had no reason to believe that the kilowatts were incorrect. So we, as Ms. Quick stated previously, this is a complex billing for medium general service and large general service customers. So the revenues did not look materially incorrect from what they previously were. So it just, did not rise to a level, unfortunately, on a monthly basis that would have caused us to question the revenue report sooner.
So were there any type of threshold alerts or exceptions that would have triggered kind of a closer review or analysis for the monthly reports.
Yes, if we had seen a revenue being yielded by a current month report that was in stark contrast to a prior month, we would have asked the question. So our revenues for the LGS customers on a monthly basis are $5 to $6 to $7 million. So let's say it was an $11 million revenue for 1 month, we would have questioned it at that point, but we were operating within reasonable variances given prior month revenue data.
And is there some reason why there weren't some type of formalized methodology for establishing what might have been reasonable triggers that would have resulted in a closer analysis that would have detected the overstatements of revenues at an earlier point in time? Would that have been a reasonable thing to have implemented?
I think so, but at the same time, I trust the end users, the monthly preparers of the JAAR report, as well as the annual preparers. They are closest to the data. So I rely on their expertise and knowledge. If they saw a variance that was large enough or a revenue that went from 5 million down to 1 million, I rely on their experience and expertise to call attention to that such that we could work with Ms. Quick's team to investigate the report.
And moving forward, has there been any type of agreement reached with the public staff or with the interveners relating to a more closer examination of the reports that will be prepared, either the monthly reports that will be submitted to the public staff or in terms of the semi-annual reports that you're doing that will alert you to the way things are proceeding on a regular ongoing basis?
I'm not aware of any agreement between the company and public staff at this point.
Okay. All right. I don't have any further questions. Let me look to my colleagues to see. I'm not seeing any hands raised. It's amazing what 5 o'clock can do. It's past 5. I mean, that's what I mean. We will now have questions on commissioner questions.
I just have 12 or 13. Just kidding. I have.
It's fine. It's not a problem. We don't have a cross in the back to nail you to.
No questions from the public staff.
I'm very.
Go right ahead.
Short.
No one should feel timid about asking questions. I don't want anyone to feel that way. So certainly take all the time you would like.
No, this will be very quick. Mr. Sykes, I'll start with you. Although there's not a formal agreement to work with public staff, it's fair to say that the company will continue to keep lines of communications open to work with public staff to make sure they understand our processes and controls going forward in this matter as we would with other matters.
Yes.
And anything you would like to add, Ms. Quick?
I would just answer to that question. Of course we would. We worked with them on the bill samples. They were time consuming to figure out all the data. So we're happy to work with them, especially as we need to buy their confidence in our reports.
So you think fair to say that it's important to continue that relationship and collaboration with public staff?
Yes.
No further questions.
All right, very good. Let's see, do we have all the appropriate motions to get all the exhibits into the record, or if you'd like to proceed at this time?
I have a few. Do you have any? Presiding Commissioner, the public staff would like to move into the record what's been identified as public staff Sykes and Quick rebuttal cross-examination exhibits 1. Sorry, that should have been confidential cross-examination exhibit 1. Public staff Sykes and Quick rebuttal cross-examination exhibit 2. Public staff Sykes and Quick confidential rebuttal cross-examination exhibit 3. And then public staff Sykes and Quick rebuttal cross-examination exhibits 4 and 5.
Without objection, your motion is allowed.
Thank you.
All right.
Presiding Commissioner,
Yes.
at this time, I move that Mr. Sykes and Mrs. Quick's joint rebuttal exhibit be accepted into the record at this time.
Without objection, your motion is allowed. The witnesses may be excused. Ms. Toon, I'm not sure you ever formally got the application into the record.
Thank you for the reminder.
I mean, you
Presiding
didn't from the
Commissioner.
outset.
At this time, I
Go ahead.
also move that the company's application be moved into the record.
All right, without objection, your motion is allowed. Well, are there any other concluding matters? Not seeing any. I just want to thank everybody for their time today. This brings us to a conclusion of this particular rider proceeding. I remind the parties that proposed orders are to be filed with the commission no later than Wednesday, October 22nd. And it's my understanding that tomorrow they will presume hearings at 9 a.m. Is that correct? I look to Commissioner Cameron.
That is correct. The fuel rider proceeding will begin at 9 o'clock in the morning.
All right. We're now hereby adjourned. Thank you for your time.
Thank you, Brett.